lo que balística más guay. Dame un segundo. Haciendo algo. ¿Qué lo que? A ver. Si me sale bien. Mm. ¿Qué lo que? Estoy haciendo una vaina aquí, pero respetar los rangos. Sí, ¿sabes? A ver. Un segundo, mi gente, que tengo ocupado con un ocupador. Dame un segundo. Ya, casi, pero no te salí. Ahora sí. Ahora sí. Un segundo. Ahora sí, el mejor de esta vaina, vamos. Ahora sí, papá. El mejor de esta vaina. El mejor. Igual, vamos. Ahora sí. Un segundo. Espérate. Dime qué es lo que mi gente, qué es lo que ustedes dicen. Estamos Bad Bunny, baby, aquí esperando que el juicio empieza en menos de media hora, pero hay que ver si supuestamente lo van a transmitir, pero vamos a ver qué es lo que es. Vamos a ver si Microsoft cierra o extiende o Jackie Chan. Mi gente, esta compra. Mi gente, que lo que, estamos Bad Bunny, estamos haciendo la fotito tú sabes. Microsoft New Xbox Game Pass es oficial. El Game Pass Core es oficial. A mí no me importa esa mierda. A mí lo que me importa es la compra. No sé, loco. Él dijo como que vaina. Yo puedo celebrar, loco. Yo voy a hacer mi post también ya. Tengo todas mis miniaturas ready. Vamos a ver, mi gente, qué es lo que. Gente, yo sé que estoy. Vamos, que es lo que ya tengo mi vaina, mi tweet ready. Nueva Zelanda acaba de aprobar. ¿Dónde aprobó? ¿Tu casa? ¿Dónde aprobó? Aún no aprobado, amigo. ¿Dónde? ¿Quién dijo que aprobó? ¿Quién dijo? A quién tuviste que aprobó? Florian dijo que yo estoy hablando de Nueva Zelanda. ¿Quién dijo que aprobó? Que lo que Samu, todo el mundo saludó. ¿Quién dijo que aprobó Nueva Zelanda? ¿Quién? ¿Dónde está? Milton, ¿quién dijo que aprobó Nueva Zelanda? ¿Dónde? En Japón. Que es lo que mi gente activo, el mejor del bloque. No cogemos esa con ningún mancote como lo conté. Prr, prr. ¿Dónde aprobó Nueva Zelanda? ¿En tu casa? H. Adoni, gané. Gente, estoy haciendo una vaina. Ya puesto después de las 10 calorías. Nada depende si Microsoft lo quiere dejar. Eh, Milton responde, Milton responde. Milton responde. Oh, yo sé, Malabé, yo me estoy hablando de eso, estoy hablando de Nueva Zelanda. ¿A qué hora hay qué? Lo que saludo, preocupa que. Claro, papá, que yo dormí. Estoy montando que yo soy la robo bestia. Mi gente, esto se acaba. Después de esto ya no hay madrugada ni nada. La noticia que hay amigo, mira, amigo, déjame enseñarle a Milton. Vino a decir que, mira, amigo, mira, amigo, mira, Milton, mira, Milton, mira, Milton, mira, Milton, y- Milton. Tengo la de, ¿qué? Milton, mira, Milton, ¿cómo está Milton? Amigo, ve, aquí dice actualización, pa, actualizamos, le damos aquí, traducir, aquí dice estado abierto, resultado cero, Nueva Zelanda, aún no aprobado, Australia, le damos pa, traducir, estado bajo consideración, no ha aprobado todavía, no aprobado, no aprobado, por favor. Nueva Zelanda aún no ha aprobado, no ha aprobado. Nueva Zelanda aún no ha aprobado. Falso. Otro tipo tiene mi propia consola. Yo tengo esa consola de 360. No hay link todavía. No hay link todavía. No hay link. No hay link todavía. No hay link todavía de la transmisión. Dice que se va a transmitir, pero no hay link todavía. ¿Qué es lo que David? Dani. 9:15. Alguien me mandó algo ahí. ¿Qué fue? No hay link todavía. O sea, hay link, pero no de verlo, porque no, hasta que no empiece. No, hay que parar el cat. Pónteme de espalda a ver si no se me para. Que te lo voy a romper. Pónteme de espalda, a ver. Pónteme de espalda para que tú veas cómo te voy a agarrar y te voy a romper la cabecea. Llaman el chapote, el chapotea. El papá de los guas. El problema que se dice, o sea, el problema que se dice que se va a transmitir Pero hasta que no empiece la transmisión no sabemos si van a transmitir. A ver. A ver. Hello. Ok. Vamos ready que para que empiece el juicio. ¿Qué es lo que? Victoria aprobó. Victoria aprobó. Ya quicha. Ya casi. En 11 minutos tiene que empezar. Vamos allá. Mejor del bloque. Recuerda, nosotros somos los mejores del bloque. ¿Qué pasó? Saludos. Vamos a saludar a la gente. A Hades, Anónimo, Josué, Adoni, Darwin, Palakbox, Deep, Apena, Darwin, te saludé 2 veces. $2 de sapo. Pepe, Fari, Davey, Tani, The Game, 610, Mayo, Vanex, Héctor, Goku, Expo, Orlando, Mundi, Gusti, Giancarlo, Todo Gaming, Santiago Roja, Aymala B, Carlos, David, Samuel, Milton, Cacuevaca, Daniel Ortega, Sergio, Epi, H, Santiago, Josué, Rafa, La Amenaza, Frost, Brader, Soul, Heron Game, Inmortal, Star, Sky, Remisero, Wilmerson, Luis, SNKV, por ahí, Luis Patricio, JJL, The Only 182. Yo, papi, que la que hay. Estamos activos aquí en Marte. Cerca volada. Aquí en Marte son las 9. Ojalá que no vengan a joder esta gente de que no se puede transmitir este directo. Me la van a pelar. Me la van a pelar. Vengan con tiras de que no se puede transmitir. Que es lo que es Wilson. Nueva Zelanda ya es 18, ya como la 1, la 2. La 1, la 2 por ahí. Del 18. Si ellos ya yo subí un tweet. Si ellos van a hablar, va a ser después de la audiencia. Un video que subió Xbox, ¿no? ¿Dónde? En YouTube. O el Game Pass, sí, el Core. Sí, el nuevo Game Pass. Vamos a verlo aquí.
Hi everyone, welcome to the Game Pass Community Update. I'm Megan, Community Lead for Xbox Game Pass, here to talk about Game Pass Core, what it is,
Vamos a tener otro video porque este video. El otro lo conecto. Este. Ya aceptó.
TLDR message. First up, what you've probably already heard. We're updating Xbox Live Gold in a few months. Its new name is Game Pass Core. You might be asking, what if I have Gold? Do I need to change anything? Do my existing games go away? Do I need to change my payment or login or anything? Do you have games with dogs we can pet in them? And the answers are no, 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 and absolutely yes. Games with dogs you can pet are delightful. But seriously, here's the bottom line. If you're a Gold member, you don't need to change anything. Nothing with your subscription will change. No action is needed on your part. Same if you're an Ultimate member, no action needed. Soon you'll have more details on the core collection of games that you can access the entire time you're a Game Pass Core member. This includes a select catalog of games from the full curated Game Pass library, like Forza Horizon 4, Ori and the Will of the Wisps, Grounded, Fallout 4, and more. If you want access to a more frequently updated collection, Day 1 games, perks, along with multiplayer, check out Game Pass Ultimate. Any games you've received in the past from Games with Gold, you'll still have access to as long as you're a Game Pass Core or Ultimate member. Instead of Gold being your ticket to crossplay and multiplayer, it's now Game Pass Core. Same functionality, just a new name. Deals with Gold will become deals with Game Pass, and free play days will still be available to Game Pass Core members. Again, nothing really changing here but the name. Check the link below for our announce message, and we'll be back in a few months with more details. We'll talk with you all soon.
O sea, es lo mismo, pero con más de 25 juegos de Game Pass. O sea, que tú vas a tener juegos, más de 25 juegos. De calidad. ¿Qué es lo que es Ricky? Kilby. Minipong. Torque. ¿Qué es lo que? Aquí esperando el otro cabello tan medio raro hoy. ¿Qué pasa, chapo? Voy a comprar el audífono eso, pa. ¿Qué es lo que, mi gente? Estamos papón esperando aquí a ver si empieza el juicio. Me pongan y venga los majón de mujer, ¿dónde? O sea, como que son medio guaristiqui, loco. Sí, yo estoy yo estoy en el link de vaina, yo estoy en los dos lados, en la vaina que la de Microsoft y la de ¿cómo se llama? Y la del K, pero no han puesto nada. Pon la vaina, ¿qué vaina que ponga? Como si no he empezado, hijo tu maldita matemática. ¿Qué es lo que yo voy a poner? No he empezado nada. ¿Qué es lo que tú quieres que yo ponga? No he empezado nada. Oye, pon la vaina, no he empezado nada, no hay nada. Estoy en droga. Estamos aquí, ahora sí. Estamos en directo. Ahora sí. Estamos aquí. Estamos aquí. Ahora sí, espérate. Ahora sí, vamos a poner esta vaina. Todo ready. Sí.
Good afternoon, everybody. Before we begin, I'm going to make the usual live stream warning. Some of you are joining us via our website on live stream. An official recording is being made, and an authorized transcript of these proceedings will be produced. It is prohibited for anyone else to make an unauthorised recording, audio or visual, or to photograph the proceedings, and a breach of that provision is punishable as a contempt. I should explain, however, that because of an application that may be made in a moment, the live note may run rather more shortly than is to be expected, but those listening will, of course, be able to hear the application and my ruling in relation to it before anything happens to the stream. But Mr. Beard, I understand that there is an application to cut the live stream.
Yes, there is, sir. I think we explained this in the back end of our submissions. It's obviously not to render the proceedings non-public, but because of the sensitivity in relation to essentially market-moving noise that occurs during the course of a hearing, it is asked that the live stream on this occasion be disabled. Obviously, it will mean that a transcript is available in due course. These are public proceedings and people are attending, both from the public and from the press. We don't want to stop that in any way.
Lord Gravett, do you have anything to add?
Lord, we support that application.
Mr. Bailey?
We're neutral on the point and consider it's a matter for the tribunal.
Grateful. It seems to me that the question is whether this hearing should be in private or in public. I appreciate, of course, that Microsoft are not saying that it should go into private session, but a distinction between in public proceedings where people are present and well able to text what is going on being permitted, and a live stream where people can see what is going on is not permitted, is not a matter that is not a distinction that I'm prepared to draw on this occasion. So we'll proceed with the live stream as it stands, but I do want to be very clear that these are important of wide public interest proceedings, and what I said on the last occasion when the live note was suspended holds in spades today. I expect people to watch and to do no more than that. Well, thank you very much. Before you begin, Mr. Bailey, a few preliminary points. I think it would be as well if I said a few general things about how the tribunal is minded to approach this application. Now, I suspect that everybody's thinking will have moved on or been affected by the announcement of a deal regarding Call of Duty between Microsoft and Sony. I think it should be on the record that that is something that I've seen in the public media. I've not seen anything else, but it does seem to me to be a matter that is likely to be addressed, at least in the abstract, today. And it does seem to me that we need to understand that this is a fast-moving situation where events are changing clearly quite rapidly. I want also to be clear that I feel quite rightly very much at the end of the food chain here. I have seen what there is in the press, and I'm quite sure that all of the parties before me know far more, and you will inform me as appropriate what I need to know, but that much I do know. It may be, in light of this, that the parties are rethinking the need for an adjournment at all, and I have in mind whether the course outlined in Microsoft's skeleton at paragraph 21, what I will call the CTS eventing approach, is something that is more live than it was before the weekend. But that is something we can come to in due course. I make these preliminary points in relation to the question of adjournment or suspension of these proceedings, as the parties have termed it. First of all, I don't want anyone before me today to be troubled about time or length of submissions. I appreciate that the CMA sought a short hearing regarding this adjournment application, but for reasons that I'm going to go on to, this is a troubling application, and I want all of the parties to appreciate right from the beginning that I'm anxious for their help, and I don't want anyone feeling that they are under any time pressure. We will sit as late as is necessary. Secondly, I am, to my considerable regret, hearing this matter on my own. It seemed to be necessary in the course of last week that this application come on as soon as possible, but neither Professor Newberger nor Mr. Tidswell were available for full panel hearing either today or tomorrow, or for that matter, Wednesday. I'm in no doubt that I have jurisdiction to grant the application. It is more that I find the application a troubling one, and one where it would have been better if we were sitting as a three rather than as a single chair. Thirdly, it does seem to me that the adjournment of any matter is a judicial decision, and it can only be made for good and proper reason. A number of points specific to this case arise out of that fact. First, the substantive application, the Section 120 application moved by Microsoft, is no ordinary application. It is one that was brought on expeditiously because it is a merger case, and it was listed for the 28th of July 2023 over the CMA's significant opposition. I'm not going to change that listing lightly, and I'm only going to do so for good reason. Secondly, there has already been one application to adjourn, as well as resistance to the original date. That application for adjournment was made on the 28th of June, just over a fortnight ago, was opposed by Microsoft, and was refused by the Tribunal on the 29th of June 2023 under neutral citation 2023 Cat 43. Second applications to adjourn are rare. I appreciate that the grounds for this application, as well as Microsoft's stance, are different. Nevertheless, I am extremely surprised that the negotiations going on between the CMA and Microsoft did not feature in the first application. And I'm afraid, unless, Mr. Bailey, you can persuade me to the contrary, that is a matter which is going to have to be explained by the CMA in evidence. Why, just over a fortnight ago, was this application, as presently framed, not made? Thirdly, there is an assumption by the parties that provided they agree, there will be an adjournment granted. That is evident from the communications that both parties have had with the press, and it is evident from, for example, paragraph 24 of the CMA's written submissions. I think it's appropriate that I read this out. I know you've all read it, but this reads, for the avoidance of doubt, the CMA does not ask the Tribunal to rule on the lawfulness or appropriateness of any of the above routes in this particular case. It is respectfully submitted that this would not be necessary in the context of a case management hearing, or appropriate given the hypothetical, and that is a word to be underlined, given the hypothetical nature of the facts as matters stand. Rather, the CMA has set out the above routes to seek to address the Tribunal's concern that the CMA could not consider alternative proposals from Microsoft without any change to the status of the FR. The routes above show there are several ways in which that could in principle be achieved. Now, the underlying assumption of that paragraph, and there's a similar paragraph in Microsoft's written submissions, the underlying assumption is that the Tribunal is not concerned with the reasons for the adjournment and can grant it simply because the parties ask. Now, that would absolutely not be the case in civil litigation. Indeed, I don't think anyone would be in any doubt that if this application were made in private civil litigation, it would be refused without a second thought. Here, of course, the CMA is a public body, the National Competition Authority, and I will listen very carefully to the reasons for the CMA's conduct and for its making of this second adjournment application. But the reasons for the adjournment must, in my judgment, outweigh the public interest on which the Tribunal has already ruled twice as regards the listing of this application. So, Mr. Bailey, if you think that I'm not concerned about the whys and wherefores of this application, then you will have to push back quite hard on that point. And this is my invitation to you to do so. and I will welcome your submissions on this point, but it is only fair to you that you know where I am coming from so that my concerns can be addressed head on. So much for the preliminary points regarding this application. That brings me to the final area that I want to raise before the parties, before we begin the submissions, and that's a framework for analysing this application. If, and it's a big if, I might, that the parties' consent is not enough, the question has got to be what is. And I've given this matter some considerable thought over the last few days. I'll describe my thinking again so that the parties can push back as advised. I'd far rather that you, and in particular Mr. Bailey and Mr. Beard, have a target to aim your fire on than not to know the general direction of the tribunal's thinking. I have in mind a four-stage process. First stage, the tribunal must be satisfied that the course proposed by the CMA, viz. Discussions with Microsoft necessitating an adjournment, have a proper legal foundation. By this, I do not mean to say that I have to be satisfied as a matter of law that the CMA is right, but I do need to satisfy myself that there is some proper jurisdictional basis for what the CMA is doing or what it is proposing to do. In this regard, I find it quite troubling that I've been presented with a cornucopia of possible jurisdictional bases. Really, one is or ought to be enough. In short, as a part of the first stage, I must understand the legal basis on which the CMA intends to proceed. It's not necessary for me to rule on the lawfulness of that basis. That would be a matter for separate later proceedings. But I do need to understand the prima facie thrust of the jurisdiction. Secondly, and this is the second stage, as regards each such jurisdictional basis advanced, I must be satisfied that, at least arguably, there is a sufficient factual basis for exercising the jurisdiction. If, for example, it is said that there has been a material change of circumstance, then I need to know what that change of circumstance is. Provided, to carry on with this example, there can arguably be said to be a material change of circumstance, then it seems to me I should inquire no further. But that far, to make the inquiry and to have an answer to it, that far it seems to me I must go. Thirdly, assuming that these two requirements are met, the legal jurisdictional basis and the factual basis satisfying it, I must be satisfied that the CMA is indeed seeking an adjournment for these reasons. In other words, not only must I be satisfied as a matter of theory that the jurisdiction might exist, I must be satisfied that the CMA has decided to go down this route. The application, in other words, cannot be hypothetical, but it must be grounded in reality. I have in mind that there ought to be some evidential support for this adjournment, which explains the thinking behind it and enables me, when making the judicial decision whether or not to adjourn, to have something to refer to by way of factual ammunition. So it seems to me, as the third stage, points 1 and 2 need to be buttressed by evidence from someone in the CMA. Fourthly, and finally, I must be satisfied that there is no obvious problem in the CMA's proposed course of action that would expose the CMA to an inevitable and successful judicial review if it pursued the course it is suggesting, whatever that might be. In other words, I must not expose either the CMA nor this tribunal to justified criticism in having allowed an adjournment in circumstances where it should not have been granted. If there is an obvious problem, an obvious defect, it must be dealt with. Here, in this case, I can see only one such potential problem or defect, but I do think it needs to be addressed. The coincidence between events in the United States, the FTC's failure to obtain an interim injunction, and the application here is unfortunate. it is, I think, common ground that events in the United States are immaterial to Microsoft's and the CMA's application today. As a matter of law, that seems to me to be right. But it does seem to me also that the CMA needs to go on record that, as a matter of fact, these events have not been a consideration at any point in the CMA's thinking. So that's my framework, and of course, you will want to push back on it. Now, Mr. Bailey, before you rise, I don't want you to be concerned that simply because you do not have, say, the evidence in place that this framework implies, I'm going to refuse the application. That is not going to happen today. The furthest I would go today is to say not today. Of course, you may be able to persuade me that the application should be acceded to today. That's the whole point of this overlong preliminary excursus. So the answer may well be yes. It will not be a definitive no. I've got too much respect for the CMA and for the common position of the parties to go that far. And if we need to, then there will be a hearing with all three of us later on this week to dot the I's and cross the T's or hear further submissions. So the point of today is either to get to a yes or to articulate the problems that I have in getting to yes, because it will only be a conditional no. At some point in the course of your submissions, Mr. Bailey, Mr. Beard, and to the extent relevant, Lord Grabbanner, you're going to have to assist me on points 1 and 2 of my framework, even if you disagree with it. I welcome disagreement with it, but I want assistance on points 1 and 2. In other words, you're going to have to go through each jurisdictional base relied upon and identified the facts and matters relied upon to suggest that it is triggered. I've made a list of the various avenues. There are 5, I think, in total, and we'll have to go through them one by one in addition to your general submissions. Now, I'm conscious that I've spoken for far too long, but the parties do need to know the concerns that the tribunal has and has articulated. If you wish me to rise, any of you, for a certain period of time, I'm very happy to do so.
We would be grateful for an opportunity just to
of course.
take into consideration everything the tribunal has said.
I've thrown an awful lot at you, and of course, 15 minutes or half an hour?
15 minutes.
15 minutes, well, that you can have. If you want more, then just let me know. Thank you very much.
Break. El juez está enojado, loco. El juez dice que... El juez está enojado porque hay un break de 15 minutos. El juez está enojado porque dice que porque ellos ahora deciden estar de acuerdo. El juez van... El juez está enojado porque dice banca, pero todo este drama y ahora ustedes se pusieron de acuerdo, entonces denme la explicación porque que quiere que le expliquen bien porque están de acuerdo. Entonces ahora cogen un break y puede ser que ese break fue para hablar con el juez, para no decirlo en público, que cuando viene a ver van a anular, para que el juez anule ¿cómo se llama? El bloqueo. Sí, parece que le van a pedir al juez, la CMA como que anule el bloqueo. Parece que ya están ellos están de acuerdo. Ellos van a parece que van a anular el bloqueo. Pero eso piden el break para hablar con el juez. Pero no quiere que se escuche, tú sabes. Pero eso pusieron el break para explicarle al juez qué es lo que van a hacer. Pero no quiere que sabemos. Pero parece que ellos quieren anular, loco. O sea que ya hoy, y el juez lo dijo, el juez le dijo a la CMA que no pierda tiempo, que trate de explicar y demostrar hoy todo lo que va a decir, vaina. Porque si ellos están de acuerdo, ya si ellos están de acuerdo, ¿qué es lo que están haciendo perdiendo tiempo? Ya el juez va a anular esa vaina. Hasta Florian dice que puede hacer que el juez anule, pero Tom Warren dice que no. O sea, Florian dice que puede hacer que el juez anule y Tom Warren dice que no. ¿A quién le creemos? A Florian. Si dijo el lunes con la CMA ya perdió mucha atención, que el juez le haga tomar una decisión. Eso hasta que no le haga hacer. Chapo, déjate de cagar. Sí, estaba afuera cagando. En el patio, estaba cagando. En el patio adelante ahí. Estaba cagando. Florian lo sabe que pie coger. A Florian, claro que tomó de. Pero parece que este break es para explicarle al juez, porque no quiere, tú sabes que ellos no quieren que sea público. Porque ellos no quieren que salgan de que, la CMA, tú sabes, los memes, porque ellos se enojan con los memes. Ellos no quieren que haya memes. Tú ves todos los memes que hicieron la otra vez y se estaban burlando de los abogados, de las FTC, de la CMA y todo. Entonces ellos no quieren eso. Por eso que yo nada más puse el audio y el subtítulo. Vamos a ver qué va a pasar. No hay gente que va a subir, pero la gente va a subir meme por su propia voluntad, por su propio lado. Pero si se empiezan a subir memes de mi canal y salgo de la cara mía en los memes, pues si quieres meter el medio, soy yo. Soy yo que me voy a joder. El juez Mi claramente no está contento con ninguna de las partes, un poco más molesto con la CMA debido a sus intentos anteriores de posponer los procedimientos de revisión judicial. Así que sí, no es bueno para ninguno de los dos. Todavía me sorprendería si no concediera la suspensión en este momento, pero veremos la base sobre cuál ambas partes la solicita. Está claramente frustrado, sin embargo, lo dije en etcétera. Pero lo que tiene, si los dos dicen, si los dos le dicen al juez que anule, o sea, la CMA está de acuerdo que anule, él tiene que anular. Porque si Microsoft y la CMA le piden que anule, porque se pusieron de acuerdo, me imagino que lo va a anular. Pues si las dos partes están pidiendo que anule. Se está adelantando como así. No, yo hay gente que ya está subiendo vaina en Twitter, subiendo, o sea, anular el bloqueo, que el bloqueo lo anule, anular el bloqueo y se aprueba. Cuando se fue anoche que lo dijo Nueva Zelanda, déjame ver, yo tenía la página abierta. Nueva Zelanda no aprobaba, loco. Déjame ver. En pleno juicio, loco, déjame ver. Um, déjame ver. Nueva Zelanda no ha aprobado todavía. O sea, anular el bloqueo, de que tú sabes que la CMA bloqueó, anular el bloqueo, quitar el bloqueo. Lo que pasa es que ahí está molesto porque la CMA quiso retrasar, pidió retraso, quería retrasar, entonces ponen la audiencia, después la cancelan y después ahora dicen que están de acuerdo, que sé yo qué, entonces por eso es que el juez está quillado. Entonces ahí mismo yo dije un break, para explicarle al juez, tú sabes, detrás de cámara, explicarle al juez lo que la intención de que ellos tienen. Pero el juez le dijo que a la CMA que se deje de perder tiempo. El locón entra a disco, ahí viene el locón entra a disco, el locón hace peca de arrastre, el locón hace peca de arrastre, el locón hace peca de arrastre, el locón. Habla, habla loco, no te escucha.
Ey,
Ahora,
oye bajito, tengo el micrófono de grabar.
el locón, peca de arrastre, medicol. Dime.
¿Qué pasó? Yo vi ahí un tweet como que estaba
Es que
molesto.
está molesto con los dos, pero más con la CMA, porque como la CMA quería
El
retrasar.
problema es que la CMA le hizo perder tiempo a
Sí,
ellos.
sí.
Es ridículo mundial, loco. Es que ellos son el ridículo mundial. Entonces, ¿qué va a decir una compañía, un inversionista? Esta gente me hizo perder todo el tiempo sabiendo que no tenía la razón. Por llevarle
Y
por
también
estar de acuerdo con la
y el
INACAN.
mismo gobierno le estaba diciendo que se pongan de acuerdo, que se pongan de acuerdo, y no le hizo caso, y al final viene y le hizo caso a Microsoft.
Ya, porque no tiene de otra, pidieron,
Sí,
porque yo te dije a ti, nosotros lo analizamos,
yo te dije
que
y lo
todo
analizamos.
lo de ellos se basaba en Linacan. Cuando ellos se vieron apretar, lo último que ellos hicieron fue Linacan y ya, y el juez le dijo ya, oye, si Linacan pidió que ya tú no tienes argumento. ¿Qué argumento tienes? No hay argumento. Si ella desiste y no llega a un acuerdo, él mismo va a tu país.
Ellos pidieron un break, parece que ellos le están explicando al juez. Florian dice que puede hacer que el juez anule el bloqueo hoy. Que como...
Debería anular, eso no
Y
puede
Tom
pasar de
Ware
hoy.
dice que
Eso no
no,
puede.
Tom
Tom
Ware
Warren
dice
lo
que
que
no.
quiere llevarle la
Sí,
contraria
a
a Vaina, es
Florian.
lo que quiere ya, es lo que ya, si su Florida. Igual que Virol y nosotros, lo mismo, los mismitos, que si uno dice uno, el otro quiere llevar la contraria y ya para sí. Si no hay extensión hoy, queda en ridículo Tom Warren, porque Tom Warren aseguraba como que sí, como que sí. Bueno,
Y dije,
eso se
bueno,
tiene que acabar hoy, eso no puede pasar de hoy. Y Microsoft tiene que cerrar hoy, no puede pasar de hoy.
esta gente se jode de que con que Nueva Zelanda aprobó, loco. Yo tengo desde anoche diciendo que no ha aprobado. Y esta gente sigue con lo mismo.
Todavía no oficial, la página no se ha actualizado, loco, pero esta gente sí habla. Imagínate que si un desinformador, por querer tener atención rápida, dice que aprobó, ya todos están diciendo lo mismo. No ha aprobado. Eso no, todavía Microsoft lo que le dijo que las acciones de Activision
Van a
Blizzard iban
pasar a mano de ellos.
a mano de ellos ya,
Globalmente, global.
y todavía están en espera la aprobación, no se ha aprobado. Ya está hablando disparate, que todavía no oficial. Claramente va a aprobar, porque no va a aprobar.
Pero van a esperar, yo creo que después del K van a aprobar.
Para mí sería una noticia si no aprueba, y ya, eso sería un escándalo. De que porque aprueba, de que noticia aprobó, ya eso se sabe.
No,
Tiene
porque
que
puede hacer que
aprobar.
se queden callados y cierren y ya, y no pase nada.
Bueno, se quedan callados.
Y ya, y no. Pero si yo lo dije en Twitter, si ellos van a hablar hoy,
Oye,
eh,
hoy es 18 de
pero no
julio en
importa.
Nueva Zelanda.
Es
¿Qué
horario,
quiere decir?
es hora
Que no,
de vaina que vale de aquí de California. Importa.
no, pero que el veredicto de ellos vale en su país, no es California. Yo no tiene
No
que ver
digo
con
yo,
California.
pero cuando expire es horario de aquí, o sea, como aquí no sea mañana todavía, en California, todavía no se ha expirado el contrato. O sea que cuando el contrato se expire, ya ellos lo van a decir ahorita, ellos, hoy en la mañana. Después de esta vaina, ellos lo van a decir.
Claro que ellos lo van a tener que decir porque hablaron tanta M, tanta vaina para el final de
Sí,
que quedarse
eso me
callado
sí, exacto. Dice, Florian dijo
y
que el
ser de
juez,
que una Canadá, de que, ya, no
Florian
dijimos
dijo
nada.
que el juez quiere una base sólida hoy por parte de la CMA o que hoy mismo obligará a la CMA a aprobar la compra. Ya pasaron los
Que
15
todo,
minutos. Ellos lo quitan porque ellos están hablando, ellos están explicando, el juez. Cuando él porque la CMA y Microsoft no están de acuerdo que él tramita y él dijo que sí que va a tramitar, pero que no tramita a la gente que no hagan, que no lo tramita, a la gente que no quiere que graben, que suben fotos. Ellos aquí ya fue por los memes, como estaban burlando de los abogados de ellos aquí ya, porque están haciendo memes y vaina.
sí, vea, gente. Bueno, pero yo subí a la cara del tipo.
Sí,
Es
pero
que realmente, tú sabes qué fue lo que pasó y por qué la gente se burló. Porque mucha gente estaba vendiendo de que ellos eran de que unos
no,
profesionales,
no,
que nadie
el dúo
podía con
Fey era que estaba
ellos.
vendiendo, el dúo
Claro,
Fey,
como que
ellos
ellos
dos, ya.
eran profesionales, como que nadie podía con ellos, que ellos estaban muy capacitados, que si ellos tomaron esa decisión era la correcta, porque ellos sí son profesionales. Y cuando nosotros vimos ¿dónde están los profesionales? La gente se burló, loco. Porque
Lo que el juez está vendiendo es que si la CMA no está de acuerdo o sea, que termine hoy, él va a poner que termine hoy.
él va a
Porque,
terminar
pero
eso
eso fue que
hoy,
él dijo
ya.
que no hay más tiempo, que
Loco,
dejen de perder
esa
tiempo.
visita de Brad Smith, ¿tú crees que fue qué? A pérdida de tiempo. Oye, Brad Smith se reunió con el primer ministro y ahí hay una orden directa. Ellos tienen que acabar eso hoy. Y si no, Microsoft le va a pasar por encima. Le va a pasar por
Dame
encima.
entre estos
Ellos no
perros,
pueden hacer nada, ellos no tienen nada con qué bloquear. Ya los argumentos de Linacan se cayeron. Sony
Eso es lo
firmó
que
también.
yo lo que entiendo, que el juez le dijo, yo lo que, o sea, el juez como quiso decir a la CMA, como yo espero que tú viniste hoy para terminar esto hoy, no me vengas con excusa de que otro juicio, que otra vaina. Eso es lo que quiso decir. Como que no pierda tiempo a la CMA, todo lo que tú vas a dar o enseñar, lo que tú explícalo a hoy.
Al final, haga lo que ella haga. Si él ve que no hay nada y ellos quieren posponer y quieren tumbar la
Él
compra,
lo va a
él lo
anular el
va a decir
bloqueo.
que no, él lo anula.
Él lo anula el
Le va a
bloqueo.
decir, mira, esto yo lo anulo porque él tiene la potestad. Ellos tienen la potestad de anular. Porque para eso el CAT no solamente está
La
para
gente está
revisión.
mal que Microsoft tiene que convencer. Bueno, es Microsoft la CMA, porque Microsoft es la CMA que bloqueó, no fue Microsoft que bloqueó.
No, 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 es que ya todo se
Es que
cayó. Él le habló de
Microsoft me
Linacan,
tiene
él
que.
mismo le mencionó.
Es la CMA que tiene
Pero que él mismo le mencionó a Lina Khan que ya ella perdió en Estados Unidos. Entonces, ¿qué le está
Sí.
diciendo él? ¿Qué es Microsoft? Porque Microsoft,
Él le está diciendo a la CMA que se ponga la pila, que hoy,
la que está quedando mal
que
es
la
la
CMA.
CMA, porque todo
Sí.
el mundo aprobó. Ya lo de Lina Khan se cayó. Ya oye, ya Sony firmó. Sony firmar automáticamente ya. Lo que
Ni la
tenían lo
CMA,
de la
ni
nube es una estupidez.
ni la CMA ni Microsoft. ¿Por qué tú dices Microsoft, loco? Oye, te dije, ¿por qué Microsoft tiene miedo de algo? Porque los dos no quieren que tramitan. ¿Por qué no quieres que tramita? Porque lo que va a pasar hoy, la gente se va a empezar a burlar de la CMA y van a hacer memes y de
Te
todo.
digo,
Por
te digo
eso.
algo, no, porque están, claro, Microsoft ya no le interesa que le tiren, porque ya ellos quieren llegar a un
Sí, es
acuerdo.
un acuerdo.
Oye, al ojo público ya Microsoft no le interesa nada, que ya la gente vea que lo que la CMA.
Bienvenido.
Al principio sí. Otro dato, y el dato más letal, si Sony sabe que hay algo que pueda hacer, no hubiese firmado todavía.
Ajá.
Sony firmando ya sabe que ya no hay de otra. Cuando Sony firma ya, es que Sony ya sabe que no se puede hacer nada y que la compra
Ah, la
está
bolsa, te viste
garantizada.
tu reembolso,
Ya.
deja ver. Buena pregunta, loco.
A las 9 ya entró. Yo creo que entró Frisá.
Sale abierta, loco. Está abierta,
A
¿no?
92, sí, a 92 está subiendo. No, bajando está. Está bajando, pero entró, no cerró.
¿Y por qué entró entonces?
¿Será que viene extensión o qué? O ellos van a cerrar, ellos la van a sacar, o en la pausa la van a sacar, porque es una pausa.
Oh, no, sí, ellos lo van a cerrar porque en la pausa del cierre, porque a un cierre en break.
Hay
en
una
el lunch.
pausa, no hay un break.
Sí, hay
¿A
un
qué hora
break
es?
de cierre, entonces ahí ellos lo sacan, pueden sacarlo.
Está bajando, que es lo importante. Ahora no puede pasar, lo más importante es que no pase de 95. Si pasa, y no entró ni frisar ni nada, ellos la dejaron así abierta. Vamos a ver qué pasa.
Sí, eso dijo el güey que no quiere burla, por eso es que ellos están enojados, porque se te pusieron a hacerle burla, porque sus abogados son de ahí de ellos, entonces ellos no quieren que se burlen de su abogado, porque son de allá del Reino Unido. No. Aquí dice que está en bolsa, sí, aquí dice que está en bolsa.
Está
que
en
está
bolsa,
bien,
ya lo vi,
sí.
está en bolsa.
Sí,
Bajó
está
a
en bolsa,
92.
a 92 estaba ahí. Pero puede
No
parecer,
subió porque
no, estaba
subió porque
90, estaba
estaba
93,
90,
bajó, bajó.
No, sí, pero se mantiene verde porque cerró en 90 y se mantiene por encima de 90, todavía está arriba.
Mm.
Entró subiendo, no bajando.
Si lo van a sacar puede ser cuando esté el break de que él cierre, porque ¿a qué hora, Donny, que cierra? ¿A qué
No,
hora
hay
el
una
break?
pausa, hay una
A
pausa,
una
como a
pausa
qué
que cierra,
hora,
¿a
a
qué
las
hora?
10 o
En lunch, ¿no? Cuando van a comer, la gente de la bolsa ahí que cierra. No, porque los memes lo van a hacer, el meme lo va a hacer tú por tu cuenta, no por mí, porque si tú haces meme por mi directo, soy yo que me voy a meter en lío. Pero si usted agarra a usted, lo ve usted y tú haces los memes tú, el que se va a meter el problema eres tú, no yo. Hagan break.
También el gobierno quiere ver que ellos resuelven, porque ellos quieren mandar un mensaje. Ellos quieren que se transmita para que la gente vea que ellos son serios. El gobierno, estamos hablando del gobierno, que ellos resuelven. Porque ahora mismo el ojo público ante los inversionistas no es muy bueno
Voy a hacer una
de lo que
pregunta
está
a Doña,
pasando
Doña
allí.
se queda callada, pero es que más sabe mañana es. ¿A dónde? ¿A qué hora que cierra la bolsa?
¿Qué sabe
A las
Adonis de
12, ¿no
bolsa,
es?
loco?
No,
Búscalo cuando es la pausa.
Adonis sabe de a qué hora es esta vaina. Adonis Futra. Chapote, es verdad que el acuerdo con Nintendo incluye, yo subí una cosa y que dice que es similar al de Nintendo, el de Call of Duty de Nintendo es similar.
Bryce me dijo los juegos y después borró el tweet, búsquelo, y después puso un nuevo tweet, dijo Call of Duty nada más, es Call of Duty nada más, está
No, porque por
garantizado
ahí
nada
están
más.
vendiendo que todos los juegos de Activision. No, los juegos que
Mentira,
lleguen
al
a
principio él
Activision.
lo dijo y después borró el tweet,
Cállate.
yo busqué la noticia y después el
Yo
tweet él lo
sé,
borró
pero
y
los
hizo
juegos
otro
que van a
nuevo y
llegar
puso
son
Call
los,
of Duty.
los juegos que van a llegar son los que ellos decidan que si ellos quieren que lleguen.
Sí, pero no es
Pero
Call of
no es
Duty,
porque
nada más
tienen
que tiene
contrato. Llegan, velo ahí. Llegan.
May it please the tribunal. I'm going to structure my submissions according to the 4 stages that you, sir, very helpfully outlined earlier this afternoon. Can I just say at the outset that the CMA respectfully agrees that, of course, adjournment is a matter for judicial decision, and we accept also that we need to convince you of there being a good, proper reason for granting that application. We do say that the parties' consent is a relevant factor in that regard, but we don't say that it is sufficient in and of itself. Can I just say, in terms of a headline point, because I'm mindful, sir, that you said that you're troubled by the application, as things stand, the CMA's belief is that a stay for 2 months and the adjournment of the main hearing would enable a rapid process for considering Microsoft's restructured deal when it is notified to it, and that it offers a realistic chance of addressing the CMA's concerns. Microsoft has indicated that it's prepared to put forward something that addresses those concerns, and of course the CMA has not yet seen the final version of that deal. and I'm not here today to prejudge the final assessment of it. But what I can say, and I will move on to all of this in more detail, is that the discussions between the parties to date have been productive, and that both sides wish to see a short opportunity in order to address the CMA's concerns. And crucially, if the restructured deal does address those concerns, then we anticipate a situation of comparative certainty being achieved more quickly than if the current litigation moves forward as is envisaged according to the Tribunal's directions. So I'm going to turn first to stage one of your framework, and that was that the Tribunal needs to be satisfied that any course that is proposed by the CMA has a proper legal foundation. And respectfully so, we agree with that. We agree that you do need that there is at least prima facie a legal basis for what the CMA is proposing to do. Equally, we agree with you that you do not need to be satisfied as a matter of law that the CMA is right. And so that was the intention of paragraph 24 of the skeleton. It was really to say today is not the opportunity, the moment to definitively decide what is lawful or not. Now, with that in mind, I'd like to address you on each of the mechanisms or routes by which we say the CMA is entitled to consider a restructured deal whilst the final report remains in place. I'm going to start, as our skeleton does, by looking at the route where Microsoft notifies a restructured transaction and what the CMA would then do next. And in that regard, I think it would be helpful if we turn up in the authorities so that we can see firstly what the statutory provisions are. And once we've seen those, I'd then like to turn to make some comments about the process, because it seems in my respectful submission that I need to show you the legal basis, but also show you how it would operate in practice. And while we anticipate that it is capable of delivering a swift outcome. So we can turn to the authorities bundle, please, tab 1 at page 14. If you're using the electronic version, it's page 16 of the PDF.
Yes.
So this will be familiar to the Tribunal. This sets out the statutory duty in subsection 1 that the CMA has to make a reference if the CMA reasonably believes, I interpolate reasonably because the Court of Appeals judgment in IBA Health established that belief needs to be reasonable, that it is or may be the case that the arrangements will result firstly in the creation of a relevant merger situation. Of course, if that's the case, secondly, whether the situation may be expected to result in an SLC. And so in my submission, what the CMA would do in relation to the restructured transaction is it would wish to investigate whether that duty is engaged or not. And that isn't bespoke to this case or Microsoft. The CMA's doors are always open to dealing with parties that wish to restructure and seek to address the concerns that it's identified.
Well, isn't the case, though, that here those doors have already been passed through? I mean, if one looks at section 33 and the definition of a relevant merger situation, what we have as the relevant merger situation is what is stated in paragraph 1.1 of the findings in the decision. And that is the anticipated acquisition by Microsoft Corporation of Activision Blizzard for further investigation and report. Now, that's what has been the case since this matter was accepted for phase 1 reference by the CMA pursuant to this very duty. Surely we're in a position where section 33 is engaged in relation to this transaction, whether it is tweaked or not?
Well, if I may say so, it's that last part of the point you put to me, whether it's tweaked.
Yes.
As we understand it, Microsoft is not intending to put forward as Lord Justice Dillon said in Argyll, colourably different or tweaked transaction. The whole premise of what is envisaged is that the restructured transaction will be materially different. And so that one of the first questions that the CMA will need to consider with an open mind is whether or not the restructured transaction does create a new relevant merger situation within the meaning of section 23, and whether or not that is different from the one that you, sir, referred me to in the final report. So that is a question of fact that needs to be addressed.
Okay, so what you're saying is that the events of the last period, whenever that began and finished, but the events of the last period are such that they have ended the relevant merger situation that caused the decision and are creating a new relevant merger situation, one that is so different that it can't be characterized as falling within the reference as described in 1.1 of the decision.
No, I'm not saying that.
Right.
And the reason I'm not saying that is because Microsoft have not notified this transaction. So the CMA has not seen what exactly is going to be put forward to it. Okay. There have, of course, been, without prejudice, discussions between the parties.
Yes.
And I will obviously not trespass that. Moreover, I will, however, deal with your factual basis, second stage, later. But of course, to jump to saying the restructured transaction is necessarily or inevitably a new relevant merger situation preempts the CMA's analysis. That there are, I would agree, a number of possibilities. So that Microsoft notifies the new transaction. The first thing the CMA will want to do is to satisfy itself whether the new transaction is, as you put to me, sir, simply a variant on the existing relevant merger situation. And if that is the conclusion that the group reach, then of course you're right, sir, that one would be saying there's nothing new here, and depending on the timing, whether it's relevant to the making of the final order. On the other hand, it is also the case that if the restructured transaction is notified and the CMA look at it and they decide actually, yes, there are things that are materially different, that means there is a new, if I can use the shorthand, RMS, and therefore section 33 is, in my submission, legally open to the CMA to look at this to see whether or not it would result in an SLC. So it's really important in my submission that it is dealt with on its merits, looking at the facts and by reference to whatever Microsoft notifies the CMA. And at the moment, of course, that hasn't yet happened. We understand it will happen, but it's not for me to speculate. And I obviously wouldn't wish to preempt the outcome of the CMA's assessment in that regard.
No, Mr. Beard, timing. When? If there's going to be a new notification, when is that likely to happen?
In terms of the precise timing, I will take instructions as to whether I can explain the details of what's going on. Urgent. It is of the very essence of the position that we want this moved along. And so very active steps have been taken by Microsoft to put in place an arrangement that can be considered by the CMA as an urgent basis. But I'm concerned not to trespass on the precise timings, you know, whether it's tomorrow, 3 days' time, whatever that might be.
Yes.
Because those are the sorts of issues that are actually being discussed. Because again, without wanting to trespass on without prejudice discussions, obviously we don't want to be putting forward something where the CMA looks at it and goes, well, nah, that you didn't think about the following. So obviously there is some interaction in relation to these matters.
Well, that's very helpful, Mr. Beard. You see, the problem with the Section 33 route is that you can't actually, today, certainly say it's likely to be engaged. Well, you can say it's likely.
I think you can say with real confidence that it's likely to be engaged.
Really? Okay.
I don't think there's any doubt about that, sir. Without
Right.
trespassing without prejudice in negotiations.
Okay, all right.
And so I think we can, with confidence, say that Section 33 will be engaged. There are then some procedures.
So just to
I'm
be
so
clear,
sorry.
no. When we say Section 33, so it's been engaged once.
Yes.
But what you are saying is that you can say with confidence that what is going to come out of the Microsoft review of the transaction is something that is going to be not a variant on an old RMS, but a new RMS.
Yes, I think, I don't know whether Mr. Bailey is going to come to it. We think that the Argyll judgment is quite helpful in this regard. I don't know if you've had cause to have a look at it. We set out some of the points in the submission. Obviously, in that case, you had two competing bidders for distillers, one of whom essentially tripped the equivalent of Section 33 in relation to its proposed bid, but only in relation to an overlap in relation to whiskies. And what was then done was that rather than Guinness having to go through the full referral process with the MNC, it said, well, look, if that's the issue, we'll make sure the deal is restructured so that whiskies, which is the only bit of the deal, and I don't know how big a bit of the deal it was, but that bit of the deal will essentially be excised so that before it closes, we will not be requiring that. We will not be triggering an RMS covering whiskies. In so doing, it was held by the CMA that was a different RMS because essentially the bit that was of concern no longer formed part of the transaction. And what the Court of Appeal and the court below emphasised was that this was, in their language, supremely a matter of fact and degree assessment by the CMA. And of course, sir, you've already said you're not trespassing on those issues today. But I think I can say with confidence that what we have here is a situation where one can substitute the notion of whiskies for something else that is relevant to the concerns that the CMA has, and you are in the territory where, without doubt, it will fall within the CMA's relevant discretion to conclude that Section 33 is engaged.
So I don't want to put words into your mouth, and please do spit them out if they are not palatable. But are you saying that the likelihood of what the outcome of Microsoft's process is going to be is that the decision that we have here is superseded by events that have occurred after the decision was made?
Yes, that is exactly right. And then
Right.
I think what Mr. Bailey's talking about are the possible procedural routes by which that is being made manifest.
So, I understand. So that's where you're coming from. We'll hear from Mr. Bailey in a moment. So the superseding by events point is actually, to my mind, quite important. It's what I thought first when I looked at the press reports of the arrangement that Microsoft have made with Sony, because it undercuts an enormous part of the reasoning in the decision, which was right then, but is wrong now for the best of reasons, because the position has changed. Now, that being the case, I can obviously say I appreciate the CMA stand by their decision. They've said that. I appreciate that Microsoft say the decision was wrong. I understand that. But why should I care? It seems to me that if things have moved on, that there are new circumstances that require a fundamental revisiting of the decision, that we're in quashing territory, not because of error, but because the decision is addressing altogether different circumstances. And it's become, in the nicest possible way, historical. I mean, it may indeed have prompted this development, which is to the benefit of all concerned. But surely we need to consider the position as things stand now. And what I was rather expecting today was an identification of a statement from Microsoft explaining what's going on. We can keep it confidential if necessary, but a statement saying, look, this is what's changed. Here is the new landscape. That goes to the CMA. The CMA look at it and say, well, looking at that, we're not asking ourselves, is this a new RMS or an old RMS? What we're asking ourselves is, has the landscape so changed that looking back at the decision that was made quite properly some months ago, is it now wrong to have the prohibition decision continue to hang over Microsoft when a fresh case is being considered? Because that, it seems to me, is verging on the oppressive.
Well, I'm happy to
sorry,
deal with that.
Mr.
Could I perhaps address it, because it's a
Of course.
matter that relates to the final report. The CMA, as you say, sir, does stand by the final report.
Of course, there's no, that's not for debate today.
Subsequent events, be they as part of without prejudice discussions or subsequent contracts entered into with third parties, do not, in my submission, invalidate or warrant the quashing of the final report. And the basis for the application before you today is not about how events have moved on so rapidly that they cast a shadow of or cloud of illegality over the final report. They're rather to say that there is a new transaction going to be on the table. And Mr. Beard has helpfully clarified that the parties have real confidence that this will address the CMA's concerns. And so we are looking prospectively, and we are looking at what is the most effective and expeditious way of seeking to have our concerns addressed. And so that is why I wanted to address you on each of the routes.
Well, no, and say, don't get me wrong, we will go down each of these routes. It's just that if we are going down the Section 33 route, you are unable today to tell me, you certainly can't show me any evidence, that this is a new RMS rather than an old RMS. I mean, we've got...
Precisely because it is a prospective process that has not yet been embarked upon.
Well,
but of course, both parties agree, as I understand it, that what Microsoft will notify is capable, to put it at that level, of resolving the CMA's concerns, and the CMA will of course look at it afresh in terms of whether it creates a new relevant merger situation. It's difficult for the CMA to be to go any further than that without preempting its assessment.
Well, that I think is the chicken and egg problem we've got. Well, let's take one step back. I don't understand the quashing jurisdiction to turn on there being an error in the underlying decision. Obviously, that is one reason, and was the reason in Eventim, as to why things can be quashed. But it would be a very strange state of affairs for the CMA to say, we continue to stand by a decision that is prohibiting a merger, when the circumstances regarding that merger have so changed that the CMA itself has real doubts as to whether prohibition is appropriate. Now, are you telling me that a change of circumstance so significant that it actually undermines, after the event, the essence of the decision that was made, is something that does not give this tribunal the jurisdiction to quash the decision and to say, of course, the hearing the week after next can't take place, because the CMA quite rightly need to have questions remitted back to it so that they can consider exactly the issues according to a timetable which is in the public interest, so that the matter can be dealt with in a second decision, of course, informed by this, but not fettered by it. Because at the moment, you've got this dead weight of the merger must not take place around your neck. And what you're trying to do is you're trying to find little ways to sidestep a decision which I'm quite prepared to accept for sake of argument today, despite Mr. Beard's pushing against it. I'm quite prepared to accept today it's absolutely right when it was made, but that's not the point.
So I think there are two different situations.
Yes.
There is the situation which you're referring to, which is the relevant merger situation that was notified to the CMA last year and is the subject of the final report. Now, of course, as you know, sir, at the moment, the final order following that report has not yet been made. And so the ultimate outcome of the CMA's deliberations won't be known and a final order made until the 29th of August. And that is because Microsoft has made submissions to the CMA about a material change of circumstance and a special reason for not imposing a final order that leads to a prohibition. And the CMA is considering those with an open mind at this moment. So the fate of the relevant merger situation that is the subject of the report is subject to that process. Well, sorry, just the second situation is the one where Microsoft notifies a discrete, a separate transaction to the CMA. And one of the questions that the CMA will need to grapple with rapidly is, hold on, is this just a variant of what we've already looked at? In which case, so I see your point, that it will just lead to the question of it being prohibited. But if, on the other hand, as we understand from Microsoft that it is capable of addressing our concerns, we say that it should be looked at afresh, and we should look at it under our duty under Section 33. And the point about the prohibition order, which we can come to when we look at it, is that the prohibition order in draft currently envisages the CMA giving consent where it is satisfied that Microsoft acquires an interest in Activision and its concerns are addressed, in which case that sort of means that the final order is also taken care of. So it just seems to me that there are two separate situations, and at the moment I'm reluctant to see that one necessarily overlaps or is intertwined with the other.
Well, we'll come to the adopting of a final order that is not consistent with the decision next, I imagine. So at the moment we're on Section 33.
Yes.
And the position, as I understand it, is that both sides are telling me that they think it's going to be a new RMS, bringing it out with the old RMS, but they don't want to kill the old RMS because that's not certain, and they can't tell me anything about the new RMS because work is still in progress.
Well, both sides are not quite telling you that, sir, because I'm not saying that there will be a new RMS. I am saying that the CMA will look at it afresh, yes, and decide once it has been notified whether there is a new RMS. And so I'm saying that that is at least a realistic possibility, but I don't want to preempt the group's consideration of it. I think it's important that I preserve their right to decide once they actually see what is being notified. So there is a little bit more in Section 33, which I hope would assist in terms of the legal basis.
As I say, I really don't want you to be constrained for time here.
So if we're back to page 14 in Section 33, we looked at the duty that's set out in subsection 1.
Yes.
There are then 3 enumerated exceptions in subsection 2, which allow essentially the CMA to switch off its duty to refer. But then, importantly in my submission, Parliament has set out in subsection 3 5 circumstances where no reference shall be made. And the reason it's important is because you can see the variety of situations that are considered here. And in my submission, not one of them says no reference shall be made where there has been a prohibition of an alternative arrangement between the same merger parties at an earlier point. And if one looks at the 5 circumstances, they are in turn, first, that no reference shall be made if a decision is not reached within the statutory time limit. For your reference, that's 40 working days is set out in the Section 34ZA. There is also no reference where either the CMA has accepted undertakings in lieu or is considering that. No reference made where an anticipated merger closes and becomes a completed merger, and finally where the Secretary of State intervenes. So my submission is important because that reinforces our view that this is open legally for the CMA to look at the restructured transaction.
Well, yes, that is clearly right. But first of all, we don't have the new restructured transaction. And secondly, we don't have the wherewithal, which is related, for killing off the old Section 33 reference, which has resulted in this decision.
So
now what you're saying is, through a combination of a new Section 33 reference, which can be dealt with, as you say, in Section 33(3), and some way of driving a stake, if appropriate, through the heart of this decision, we get to the utopia of this transaction being allowed to proceed. So it's actually a twin track approach that you're suggesting.
I am suggesting that the CMA needs to go through the process it's doing vis-a-vis the final order. It needs to deal with what Microsoft has said about it and needs to reach a final order in relation to what let's call the original RMS. I entirely agree with that. That process needs to take place.
Yes.
I'm also saying that there will be then a separate subsequent process where, let's just call it the new deal, is notified to the CMA. And as part of that, the CMA will have to ask itself, is what is being proposed simply a reiteration of the earlier transaction? It will absolutely have to do that. And if the answer to that is yes, sir, if the final order has been made, it will be caught by paragraph 12 and it will be prohibited unless the CMA were to grant its consent. If, on the other hand, it is new and sufficiently different, then, of course, Section 33 is the route forward. There is, of course, as Mr. Beard was referring to, a sort of a third variant, which is that the transaction is notified any day now, at which point the final order has not yet been made. When the CMA looks at that restructured transaction, one of the questions it will need to satisfy itself about is whether the original RMS has been abandoned. And if that's the case, then under Section 37, it's under a duty to cancel the reference. So you're right, sir, we don't have the restructured transaction. And really, unfortunately, that's not in the CMA's gift or hand. That's really for the parties. But what both sides do have is a confidence, following discussions between them, that a restructured deal can address the CMA's concerns. And insofar as that is a new RMS, and insofar as it does address the CMA's concerns, then as you've seen in our skeleton argument, one mechanism by which the CMA would allow that to take place is by granting consent under the terms of the final order. And indeed, this is not uncharted territory. The CMA has actually had this scenario arise in previous cases. So we mentioned a couple at paragraph 15 of our skeleton argument, and if it's helpful just to have that in front of us, because the decisions themselves are not actually in the bundle, you'll find our skeleton argument is at tab 5 of the core bundle, and we mentioned a couple of cases at page 18. And could I perhaps actually address you?
So which paragraph, I'm sorry?
I do apologise, it's paragraph 15.
Yes, thank you.
And if I could address you perhaps on the one that is perhaps closer to the facts of this case.
Yes.
So this is the merger that took place, the proposed merger that was notified to the Competition Commission, involving two NHS foundation trusts in the Dorset area. And in 2013, the Commission analysed this and reached the conclusion that they were likely to lead to an SLC, and that the only effective and proportionate remedy would be prohibition. And ultimately that was then implemented by way of final undertakings given by the parties under section 81. Now, several years later, the same parties approached what was now the CMA to engage in the same merger in the same area. And the CMA approached that by essentially a twin track approach. It looked at it and said, we will analyse under the terms of the final undertakings that are in place that you gave to the Competition Commission, and we will decide whether we should give consent for you to proceed with this transaction. And at the same time, the CMA did a fresh analysis in accordance with section 33 and as part of a phase 1 investigation. And in a nutshell, the CMA was satisfied that market conditions had changed. Indeed, the NHS policy in that area had changed, and so the transaction was cleared unconditionally. And moreover, at the very same time as that phase 1 clearance decision, consent was given under the final undertakings. And so that, in a sense, encapsulates what the CMA has in mind when we refer to Route 1. Now, of course, I should acknowledge there is a difference between what I've just described to you, sir, and the situation. In that case, there was 7 years, I believe, in between the original merger and the second attempt at merging. But in my submission, although that is a question of time and therefore relevant to the CMA's analysis, one shouldn't allow that temporal consideration to be decisive. So that, I hope, assures you that the CMA has used this type of procedure before, and that is exactly one route by which the CMA could, once it has the restructured transaction notified to it, could appraise it.
Look at, let's go back to section 33, but not 2 or 3, but section 33(1), which is the trigger. So the CMA shall make reference to its chair for the constitution of a group under whatever it is, if the CMA believes that it is or may be the case that arrangements are in progress or in contemplation, which, if carried into effect, will result in the creation of a relevant merger situation. And the creation of that situation may be expected to result in an SLC within Indian markets. Now, that's a very broad test of what is a relevant merger situation. And the one thing I suspect one can take to the bank here is that whatever the restructuring, Microsoft will be acquiring Activision Blizzard.
Well, this is where it becomes quite difficult
I agree
to address you on that, because the nature of any restructured transaction and whether it's a complete acquisition or a partial acquisition.
It's structured in a different way, of course. I understand that. But you understand my point too, which is that there is an evidential requirement that needs to be passed to satisfy me, because the one thing that is special about this case is that we have got a Section 120 hearing in 6 days' time, which you both want to have adjourned, and I'm not unsympathetic to that, but it needs to be lawfully done. And at the moment, I can see Section 33. I have considerable doubts as to whether, even if it was a remarkably restructured transaction, it would fall out with Section 33 as drafted here. But who knows? But you can't help me any further, and that's not a criticism. You can't. So on what juridical basis do I say, well, fine, adjourn? How do I do that?
I wonder if it might help if we look at the Court of Appeal Authority.
Of course.
It is dealing, I admit, with what we regarded as Route 3, that is the question of abandonment, but there is a point of principle that comes clearly from all 3 judgments of the Lord Justices in terms of how one appraises arrangements in progress, which is the wording, sir, in section 33(1)(a), and I hope it may be of assistance.
No, of course.
When one's looking at this. Now, as my learned friend, Mr. Beard, indicated, just to give you the judgment is at tab 3 of the authorities.
Yes.
And the head note, as one would expect, explains the basic facts. And Mr. Beard already has summarised them eloquently, but if I could just recap. The applicant in this case was Argyle, and they were bidding for a company called Distillers,
Yes.
which has some competition pedigree. And they were a rival bidder in this connection was Guinness, and they both put in proposals in what the Master of the Rolls described as a mega merger dispute, which perhaps would be apt for this case as well. And what happened was the relevant decision maker at the time, which was the Secretary of State, referred, as Mr. Beard says, Guinness's bid to the Monopolies and Mergers Commission for inquiry and report, and didn't refer Argyle's. And then what happened, which is quite important, is that before the investigation was started, Guinness had various conversations with the chair of the then MMC, indicating that it might table a revised takeover bid, as Mr. Beard said, essentially removing certain whisky activities. And the chair concluded that this meant that the arrangements referred to in the predecessor to Section 37 of the Enterprise Act meant that the transaction had been abandoned. Now, that's just by way of context. Argyle then seek judicial review of that decision, together with the Secretary of State's consent to laying aside the reference. And there are just a few points that I hope it would be helpful to go through with you in relation to the judgments.
Yes.
It's perhaps helpful to pick up what was being said on page 181 of the bundle, yes. 261 of the All England law reports. Okay, and you can pick up just below letter E that the submission that was being made, put in another way, both the first Guinness offer and the revised offer would, if implemented, have created merger situations. The proposal to create a situation had never been abandoned. The second bid was merely a variation on the theme of the first. So that was the contention being made, that the chair of the then MMC had misdirected himself in law. Now, if we move to the Master of the Rolls and how he addresses that.
So H on which page?
I'm so sorry, 180. Merely to draw attention to the fact that the parties approached Sir Godfrey Le Quesne as the chairman of the MMC and explained to him the essential difference between the arrangement that was before the MMC and the arrangement that was now proposed, yeah. Which was the sale by respectively Guinness and Distillers of whisky interests to another company called White and Mackay. Yes. And he was satisfied that if that were to happen, and of course it had not happened at that stage, that was something that they were negotiating. If that were to happen, that would produce a different arrangement. And for that reason, and it was a matter for him, not the court, it was a matter for him par excellence as chairman of the MMC to abandon the reference. And that's what he decided to do, because he was satisfied that there was now a new arrangement in front of him, and he was satisfied that this would not give rise to a problem. Ergo, the deal was allowed to proceed. It was then challenged by Argyle as an inappropriate exercise of power, and that claim failed both at first instance and in the Court of Appeal. But the description at H on page 180 shows you that there were mechanics going on, conversations obviously without prejudice initially between the parties, and then directly with the equivalent of the CMA, the chairman of the Monopolies Commission. The analogy with the present situation is exactly the same. And if I may be respectfully permitted to make one point, there is a risk in this conversation of not really paying regard to one key point, which is that all the discussions between the parties are without prejudice. And it is not the function of this court or this hearing to be investigating what has passed in those negotiations. It's entirely inappropriate. And so at the end of the day, whatever proposal is made to the CMA, it will then be a matter for the CMA to make its own judgment, for example, in relation to Section 33. If it decides that the proposal consists of a new arrangement, that's a matter for it, not a matter for the court. If somebody subsequently wants to make a challenge to that, they're welcome to do so. But we'll then be in an Argyll situation. And Lord, I apologise to your Lordship and my friend for interrupting, but it is terribly important not to trespass on the without prejudice debate.
No, Lord Governor, that's very helpful. And to be clear, I don't want, unless the parties want to tell me, to know anything that is best kept between the parties. That's obviously
Lord,
clear.
I quite understand that, but the problem is that when your Lordship says, well, I would like some certainty as to what exactly is proposed,
yes,
you must realise that that cannot be done.
Well, the problem and why this is a helpful decision only so far is this. If the CMA wish to see matters as a fresh section 33 reference, well, that's their business, not mine. I accept that. If they choose in due course to treat it as a new or a rehashed RNS, that's their business, not mine. Accept all that. But I am concerned with the process of kicking off a trial that has been fixed at considerable effort in the public interest. And I need to be satisfied, as the tribunal here did not have to be, because that was not the case here. I have to be satisfied that I have a proper basis for kicking something off. And I'm not sure that the notion that in the future, it may be in a few days, but that the notion that in the future, the short-term future, the CMA may have the wherewithal to decide that there may be a new RMS is enough to enable me to say, well, that's fine. Let's just kick this old RMS, which is being judicially reviewed, into the long grass, even if the long grass is 2 months.
But, my Lord, you said at the beginning that what has happened in the last 2 weeks, because 2 weeks ago, the adjournment application was made and was not acceptable, and in due course, your Lordship rejected the adjournment application. What has happened since then is obvious that there have been further negotiations between the parties and circumstances have changed. In front of your Lordship, you are presented with, I hope it's right to say, 3 perfectly sensible parties, all very carefully advised by people who know what they're doing. The implication is perfectly clear that the parties are in the business of trying to resolve this problem. And that by itself ought to give your Lordship sufficient succour to the effect that this is something that is being properly dealt with by responsible people. And if I may respectfully say so, that's a rather important point to feed into your Lordship's discretion. As to whether your Lordship has that discretion, I completely agree with my learned friend, Mr. Bailey, and I'm sure that's Mr. Beard's position as well, which is your Lordship undoubtedly has that discretion. It's just that I would strongly urge your Lordship to take account of the fact that you are presented with sophisticated parties. This is a massive transaction which is heavily price sensitive, and your Lordship ought to proceed on the assumption that we know what we're doing.
Well, I certainly do that, but I think my fear and my concern is that the parties, all of them, are too concerned with shoehorning what is coming down the line in the future as and categorizing it as something without paying sufficient regard to that which has already happened.
But Lord, all that we have done, we haven't tried to shoehorn anything, with great respect. What we have sought to do, and both sides have sought to do this, is to present your Lordship with the different legal routes which would be available if there were an agreed solution. And all that has happened in the respective skeleton arguments that have been served but to indicate the different possibilities that lawfully might be operated. But nobody has gone further than that because of the without prejudice limitation or inhibition. And that is really the state of play. As to which, if any, of those might work, that's really a matter for the CMA, just as it was a matter for Sir Godfrey Le Quesne in the Argyll case to decide whether or not he was satisfied that there were different arrangements in place which enabled him to decide that the first reference should be discarded.
Well, of course, you're right, but one of the options that is articulated by Microsoft is the option in paragraph 21 of its written submissions.
Yeah. I've got it. Yes, more, yes, I take your point, yes.
So,
I
let's
know that sounded as if it was the one that your lordship favoured at the beginning of this discussion.
It's the one that has the best fit in these rather exceptional circumstances.
Well,
and the reason I say that is because the parties are quite understandably addressing me on a forward-looking basis. They're saying things are moving now without prejudice, communications highly sensitive. I understand that. Don't tell me about it. I understand why you're not. But what we do have over the weekend is a development which is really, in my limited understanding, quite significant. Now, it may be Mr. Bailey will tell me it's not, but I'd be interested in hearing from all of the parties that something quite significant has occurred, which you can certainly tell me about. I mean, if you need to protect me from the elements of confidentiality, and it can be done in a statement that I would be very happy to protect, but it has happened. Now, if what has happened is something which is quite significant in terms of the decision that has been made, in the sense that the concern was that an absence of an accommodation between the market players, including in particular Sony, with regard to the jewel in the Activision crown, Call of Duty, that has actually moved on. Yes. Then that is a material circumstance, not regarding future debate, but regarding past events that affect the significance of another past event, namely the decision that we're reviewing next week. And the point I make is a perfectly simple one. Why are we going to be chasing around for 6 days talking about a decision which has been superseded by events?
Look, it's really a matter for Mr. Beard to deal with. Can I just say this in response? Of course. 2 points. One is that it is public knowledge as to what happened on the weekend. The other is the impact of that is really a matter for the CMA.
Yes.
As to the CMA's reaction to that, it's not appropriate for me to comment, and I wouldn't do so. That is a matter for the CMA to consider and to see themselves what impact that has. That may lead them to a paragraph 21 situation, I do not know. But it is really not appropriate for discussion, I would respectfully submit, in this hearing. This is really a matter for the CMA and the exercise of its statutory duty and power to decide what to do about it. But I acknowledge the point your lordship makes, which is it does have obviously a profound impact upon the discussion. But it's not a matter for today in my submission.
Well, it's a matter, we may have to go off to another hearing because clearly we're going to require evidence on certain points. But
no, I don't want to.
Before Mr. Beard
territory.
That's fine. But just so that you can assist me on this, and I want to hear from all 3 of you on this. Sticking with Microsoft's paragraph 21, is your understanding of the quashing jurisdiction as limited as it appears the CMA's is, namely that one only quashes when there is something, presumptively perfectly good decision in the past, but just historical.
Absolutely. No, I respectfully agree with your lordship.
And Mr. Bid, of course, you'll have to address me on this, but if one were to have an articulation, not of what is being planned for the future, don't want to know about that, but the significance of what has happened in the past, which moved across to the CMA, so they can say, well, look, we've got to look at what we've decided in relation to facts as they were. We're now being told by Microsoft what is the case now. Of course, it's for the CMA to decide what they wish to continue to defend and what they wish not to continue to defend. But if they take the view that what Microsoft says isn't enough to impair the decision prospectively because matters have changed, well then that ought to be a good argument for the hearing to go ahead, for that to be tested. If on the other hand, if the change is sufficiently fundamental to require a reconsideration, then a remission, quite possibly on limited terms, purely and simply on the basis of the new facts, and obviously without prejudice to any points about the validity of the decision, we'd be saying it's a proper decision. We're not examining that, we're examining the new circumstances. Then one gets everything that one wants in one nice package. We get the removal of the hearing the week after next. We get the basis for the reconsideration very swiftly, as swiftly as the CMA can do it. And we get one set of proceedings, not two.
Your lordship's assumption in that question is that the only point that we'd be discussing is the impact of the deal that was done on the weekend.
Oh, yes.
With Sony. But of course, what your lordship is not taking account of is the possibility that there are other matters which the parties are discussing, which would have, in the big picture, an additional impact on the global picture. Well, and that's why I'm very concerned that we shouldn't be going down this road of what your lordship would see as a bigger certainty or give you more stomach for what we're inviting your lordship to do, is that really does involve trespassing on inappropriate matters.
Well, Lord Governor, let me say this. I'm entirely convinced, subject to what other councils say, entirely convinced you're right about that I shouldn't be entertaining speculation about what is going on in the future. My point is that if past events are enough to make clear that circumstances have moved on in so fundamental a way as to make the decision, whilst once right, a thing writ in water, then let's call a spade, throw it back, reconsider it, together with all the other matters that I don't need to know about, and reach a decision on the circumstances as they stand.
That's why we need an adjournment, so that we can have the further discussions between the parties with a view to making sure that the CMA understands exactly what's on the table, and it's not necessarily confined to what was discussed and done over the weekend. I'm sorry to have intervened.
No, Lord Governor, it's very, very helpful, and I'm sorry, Mr. Bailey, but I'll let Mr. Beard intervene if that's all right with you.
Mr. Bailey, I don't think he's going to object. Just to be clear, I agree fundamentally with Lord Gravener's punchline. Whichever way we're dealing with this, whichever way the tribunal is thinking about these issues, it is going to require an adjournment in relation to the hearing in 10 days' time. But let's just unpack the process a little bit.
Yes.
Because if this helps, and this, I confess it may trespass slightly on Mr. Bailey's submission, but I'm going to indulge if that's okay. The position is this: if you've got a merger situation that has resulted in a final report like this one, there's the period until the final order is made. Now, it's worth just turning up section 41, page 28 in the bundle.
Yes.
Now, you'll see there text that if we get to a hearing, it's going to be the subject of some interesting discussion. But for today, all we need to do is look at
41.3.
Yeah.
Material change or special reason.
Special reason.
Yeah.
Exactly. Now, as you know, and we put it somewhat enigmatically, perhaps under paragraph 22 in our skeleton, further issues. At the moment, before the CMA, there are submissions in relation to matters that constitute, we say, special reasons or material changes of circumstance that mean, in relation to this case, this RMS, this final report, a final order should not be made which takes the same remedial course as the final report. Now, the agreement that you're talking about that occurred and was announced over the weekend, that is the sort of material that can be considered, and indeed we would say must be considered by the CMA in deciding those sorts of issues. The CMA, as you know, has moved out the deadline by which...
Yes, to the end of August.
To the end of August. Now, Mr. Bailey earlier said that the final order would be made at the end of August. One would hope that was a slip, and that obviously it moves the parameters for the making of final order to the end of August, but things can happen a great deal more quickly than that. Now, what that means is that there is a mechanism already in place to feed in these issues in relation to the Sony agreement and a range of other matters, including those to which Lord Grabner has been adverting, so that we are not simply blindly carrying on, ignoring very significant developments that have occurred here, which is precisely the concern, as I understand it, sir, that you're articulating.
Well, that is precisely right, but let's test that a little bit further.
Yes.
So 41.3 imposes a primary duty on the CMA that the final order, as I will call it, is consistent with its decision. So the basic purpose of the final order is to implement the decision. Unless. So unless two things, material changes, circumstances, or some special reason. Yeah. And we can obviously have a debate about what is a material circumstance and what is a special reason.
Of course.
Now, this does seem to me the most promising route, apart from quashing, of the for the CMA. I'm not sure the Section 33 route helps, because the Section 33 route is a way of creating a second RMS, not dealing with the first. So the two may have to be considered in tandem, which is where I think Mr. Bailey was taking me, but we'll see where it goes.
Let me deal with all of these things. First of all, MCC, special reason, it can happen quickly. That could change matters very rapidly.
Right.
That could deal with the situation as it is, not as it was. That deals with the concern. Those are matters with which the CMA is engaged and will be engaged in relation to the issues concerning the Sony agreement. So that is obviously one route. Let me just pick up the second route that you raised with Lord Grabner, which is in paragraph 21, which is the CTS eventum FNZGBS. I'm so sorry.
Pause there. Let's stick for the moment. I do want to hear about CTS.
Yeah, I was going to just deal with each of the three broad categories.
The concern I've got with 41.3 is that the discussion about the terms of the final order will proceed without any form of obligatory wider consultation with third parties. The debate will be entirely CMA Microsoft until the terms of the final order are published for consultation, at which point third parties will have a say, but they will be given effectively a fait accompli.
Well, it's not a fait accompli, because as you rightly say, there's a statutory consultation period in relation to it, and obviously the CMA as a public body will conscientiously take into account any third party objections that might be made at that point.
So the consultation, apart from with Microsoft, will arise after the final order has been drafted and is put out for consultation.
Well,
not before.
But there's nothing particularly unusual about that sort of process, even in relation to a non-MCC process. The parties to merger proceedings have a particular knowledge about what is going on before other third parties do in terms of formal steps that are taken. I mean, third parties don't receive, for instance, working papers. Obviously, we have protestations about what material we're given as parties, and we say it's not adequate, but undoubtedly the parties do have certain statutory roles in relation to this. And the reason why the statute lays down the consultation period to which you refer, sir, is precisely to ensure that third parties do have a voice. Now, I have to say, given the series of deals that have been done, the idea that you're going to have interesting objections may, in practice, become more and more remote. But of course, it's right that that opportunity is afforded. Indeed, going to the fourth step in your taxonomy, it is part of the position of Microsoft and Activision. We do not want a CMA resolution that is vulnerable to some sort of further challenge. And therefore, absolutely, we will ensure that. But it can happen quickly, and the consultation can be compliant with the statutory regime, but need not be extensive in these circumstances. And the tribunal can have confidence that all the parties will want that, because we don't want some kind of collateral challenge.
Well, I can understand that, which is again why the weekend's events are so significant.
Potentially so.
The concern, though, was that actually the 41.3 route was articulated last week as a route that was feasible in circumstances where I was troubled that if you took that route, Sony would not be in the picture until a final order was. Now, of course, the weekend events have changed things.
This is the difficulty.
Well, yes,
but
I see the difficulty.
Discussions with Sony were not matters we could talk about.
No, not at all.
And nor were we certain as to the resolution of those matters. But to take it at a very high level, the public interest consideration that applies now is different from that which applied 2 weeks ago. Things, as you rightly said at the outset, sir, do move fast here. We are trying to make them move fast for precisely the reason we've articulated previously, and for which we're enormously grateful for the tribunal for moving quickly, for setting deadlines quickly, because the UK is the only impediment to closing, and speed is of the essence. Removing uncertainty is imperative, and that is why we have been flexible about the way we've engaged. We are engaging in relation to the MCC process, but we are also engaging in relation to the alternative RMS, which is being referred to as the Section 33 process.
Yes.
If you have an alternative RMS which is differently configured, and I'll take you to Argyll if Mr. Bailey doesn't further. I know he was referring to it, but I think we're paused part-way through.
I think we're part-way through Argyll.
So I won't trespass on what he's going to deal with in relation to Argyll, but we may need to come back to it, because what is important is that you acquire the RMS is in relation to an enterprise. It's not in relation to a badged company. It's what you're actually buying as a business. If the bits of the business you're buying are not the ones that give rise to any substantive concern, then of course the RMS is different, even if the headline in terms of share acquisition might be the same, because that was precisely what was going on in Argyll and one of Argyll's protestations. But you're still buying all the shares of distillers, so it's still the same transaction. And the CMA, or the chairman, said, no, that's not right there. But I think it's important to bear those factors in mind, because just to put this in context, GBST, FNZ and CTF Eventim, those are cases where errors were identified. Now, we understand that the CMA has maintained its position pending the hearing that it doesn't want to accept there were any errors. Sir, you have asked, is the quashing jurisdiction wider than that? Obviously, the debate about the power of the CMA to withdraw a decision, the scope of the quashing jurisdiction of this tribunal, are ones that have been aired in various discussions at various times. We don't necessarily need to resolve that now. What Microsoft was seeking to do was say, okay, we understand your position pending the hearing. let's find another way of doing it. And that's why we've explored the Section 33 route. And that's why we are confident we can resolve this through the Section 33 route by putting in place a modified arrangement such that either there is a final order and we have consent to undertake that new merger situation, or that the reference is effectively abandoned, which was the course in Argyll. But both of those are predicated on the CMA taking what we put forward to them and saying, yes, that constitutes a new RMS. The reason why we can't discuss it further and the reason why there isn't a specific proposal is because we don't want to be going to the CMA with a proposal that isn't going to work, which of course is the practical process that occurs in relation to all merger interactions. And that is why we can't get into, as Lord Grabiner rightly said, any of the without prejudice discussions.
I don't want to get into this.
No, of course, and yeah, I quite understand. And I don't want to sound as if we're being defensive in relation to these matters. It is the way these things work, but it's also the way they can work so much faster because those discussions can be sensibly undertaken and then the steps taken, always in compliance with ensuring that there is a statutory protection for any appropriate consultation that is required under the Enterprise Act, so that we do not trip over on your stage 4 in the taxonomy. And I think, as Lord Grabiner says, one can have confidence that there are differing views across this bench about the status and lawfulness and appropriateness of the final report. But there is consensus that there is a way through here, but time is of the essence. We've made clear previously the position in relation to the walkaway timings. We have emphasised the uncertainty. The tribunal has understood that in the way that it's dealt with these matters. We would not be coming back before you, given all we have said previously, unless we had real confidence, because time and certainty are of primary importance to us. Now, I'm sorry I've trespassed a little on Mr. Bailey's position, but that is why we say a route through on Section 33 can be dealt with quickly. The MCC course can also be dealt with quickly. It is before the CMA. Yes, there might be debates about how matters, what can be quashed. We recognise that. We say the final report can be quashed, but in the interest of reaching certainty without the need for a remittal, reconsideration and that complexity, an agreed resolution is much faster and gives greater certainty in relation to this process, which is why we are committed to asking for the stay in order that these discussions can continue. And I hope that assists.
It does assist, but inevitably I have a couple of questions as well. I understand that there is a diametric opposition between Microsoft and the CMA as to the status of the decision under review. Of course, that's understood. There can be no
rightness of it, I think, rather than the status of it, perhaps.
Well,
yeah.
Yes, that's what I meant. Yes.
Yeah.
There's no way that that is something that I can get into today or at all until a hearing of your application,
yeah,
which is what you don't want. So the concept of quashing on the basis of an error is just not on the table.
Of course not, and we don't see that.
No, I understand that. But are you saying that the basis for your paragraph 21 suggestion of a route, because let's look at it. You see, paragraph 21 is unique to Microsoft's stance. It is not in the CMA's cornucopia of approaches. Obviously, it's a matter for the CMA whether it does it or doesn't. But you are not saying, or are you, that quashing implies?
We don't need to, no.
Well, I think if the CMA were to say we are applying to quash, I would not want there to be any kind of suggestion that it was being done for any other reason than known and articulated change of circumstances that had occurred since the decision was made and that are in the past. So I don't get into your future WP discussions at all.
No, understood.
I do get into what has happened over the last fortnight, including in particular what has happened over the weekend. And for those reasons, do I have jurisdiction? If the CMA chooses to go down this route, which is a matter for it, I of course accept, do I have jurisdiction to say, yep, subsequent to change of circumstance, I can quash it, I can remit on a limited basis or a wide basis? That will be for the parties to think about. That seems to me a key question.
With respect, it may be a key question, but in practical terms, the key question is whether or not the CMA is actually going to impose a final order. It's not actually whether or not the final report stands. And therefore, there's an extent to which you don't need to get into the quashing question because you do have the Section 41 avenue, which is dealing with these issues. The point we make about the Section 41 avenue is, look, we've made it clear we don't agree with that final report pretty fundamentally. But if it stands there and you, CMA, say we're not going to put in place a final order that follows those remedial conclusions because of the MCC or special reason considerations under Section 41, we are not here to litigate just on matters of principle, and therefore we're not concerned about whether or not the final report formally is quashed or not, so long as the final order enables us to close our deal. That is what matters to us. And therefore, so the reason I say is it key is because I'm not sure that one actually needs the quashing if you're going down the route of dealing with the MCC process, which is in a way what, sir, you're contemplating. Now, I understand that you're suggesting to the possibility to the CMA that they could unilaterally accept a quashing by this tribunal on the basis of changes that have occurred in the current situation post the final report. I leave that to the CMA. Do we have to reach a view as to whether or not that is a matter within the tribunal's jurisdiction? If the CMA are willing to accede to that, we'll of course consider it. It seems to us that that would make sense as a matter of law. But given that they're dealing with these matters under an MCC process under Section 41, the question arises, do they actually need to go that far, delightful though it may be for us?
Look,
I don't know if it would be of assistance if I clarify the CMA's position in relation to quashing. I hesitate to interrupt.
In a moment. You're, of course, the one being interrupted, Mr. Bailey. I do appreciate that. So we're debating my stages 1 and stage 2. Is there legal basis for doing what the CMA want me to do? And is there evidential support to do it?
Yes.
It's pretty clear I've got concerns on both
Yes.
those fronts.
Yes.
So the question for you now is this. Do you want me to put a line through the potentiality, if the CMA chooses to do it, of looking at quashing as a route? Because I want to understand what my jurisdictional options are if the CMA makes it. Or do you want me to put a line through and say, I don't need to worry about it because you say it can't be done? Because we're at that stage now. If you want me to think about it, then we've got some questions about it. I appreciate you are saying there are other better ways of doing it, and I will look at those. But if you want me to consider all of the options, now's the time.
I imagine we may need to.
I've just been given a note about Chancellor.
It may be a perfect harmony where I can take an instruction in relation to that. But just going back to your 2 points, I think it is clear that there are a range of legal options here that can properly be explored. Your first threshold is met. In relation to the evidential considerations, as Lord Grabner has explained, we cannot provide the details, but we can provide you with the confidence that enables the tribunal to reach a conclusion that it is right here in the public interest because the public interest has moved on, and we would not be here if all of us did not think the same thing.
Yes. Well, the question that arises out of that is the extent to which a judicial decision like this, to adjourn a matter that has been fixed with some brutality for the 28th of July, can be shunted off without any evidence at all. That's a question which underlies all of the avenues here, and something which I'm sure you'll all be thinking on. But for my part, in order to close out, I mean, I'm gaining understanding of what everyone is saying about the 4 or 5 routes that you say are open to me, and I want to consider all of them.
Yes, sure.
But if it's going to be the Microsoft position that a quashing order can only be made if there is some fragility in the decision as made, then that's not going to happen.
No.
Whatever Microsoft says about the fragilities. So obviously I cannot act without the CMA deciding that that is the proper course, and that is a matter, of course, for the CMA and the CMA alone. But if that course is taken, I want today to be used as an opportunity so that everyone in this courtroom and I understand that if such an order were applied for, and if it were made, it would be because of known past changes in circumstance occurring after 26th of April 2023,
yes,
which have such a bearing on what was said in that decision that it is effectively something that needs to be revisited on certain terms. Now, there may be other ways of doing it. The question is not, are those valid or not? I'll hear submissions on that, we'll consider it. The question is that an item on the menu for this week? I'm not saying for today, but is it an item on the menu for this week? Because I'm up for considering it if you are.
I quite understand, and I'm grateful for the indication. I think it's sensible to take instructions.
No, of course.
We discussed briefly with CMA their position in relation to this.
Absolutely. And I think what I said earlier, this is not going to be a case of any absolute no. It's going to be a case of either a yes or a not today.
Yes, and I quite understand the approach that the tribunal is taking, and I don't want to take any more time, but I think one does need to reflect carefully on what anything less than a yes would involve that is consistent with the important interest that this tribunal and all courts recognise that settlement arrangements require the absolute protection of WP, and that in those circumstances what we don't want to be doing is discussing the same issues when we can't talk about them in detail in 2 days' time.
That is well understood, and I think one of the parameters of any evidential basis for doing anything about this case is a question of how far, without invading any form of privilege, this tribunal can be informed of what is going on. Now that applies, I think, in any of the scenarios we're talking about. Lord Gravener's point about without prejudice communications is something which he's absolutely right on. I can't be told about that unless all consent, and I completely understand why all cannot consent, because you're in opposition in the discussions, not in collusion. That is why I was so assisted by the events of the past, because it seemed to me that we had been gifted a really quite significant, not a material, something more than that, change of circumstance, which enables everyone to say, look, the game has moved on, because what once may have justified a prohibition is now so different. You've got Sony on a 10-year deal, all over the press.
Yeah.
That makes a very significant difference to this event.
In many ways, I'm perhaps the wrong person to be engaging with on this, because obviously I concur with that, and it has always been Microsoft's position that it would enter into these sorts of agreements, and so we're obviously very much alive to that issue. But there is an extent to which what we have been trying to do is find a route through with the CMA which didn't involve them
I can understand that.
And therefore we've been trying to be helpful. I know that may not feel like it on their side, but that is undoubtedly what we have been trying to do.
Look, I will rise. I entirely get the collaborative, cooperative approach that the parties are taking. You are all pushing in the same direction. And to be clear, if it was simply a matter of a non-judicial discretion, I'd say fine. As parties said, that's the problem.
We understand the public interest issue that this tribunal rightly has, particularly in circumstances where it has so much gone out of its way to accelerate matters. And as I say, Microsoft, which was in the vanguard of pushing for that, would not be standing before you offering this cooperative approach unless it considered that the public interest for consumers, gamers, developers, the UK's technology industries were not benefited by this process, which can be fast and certain.
Well, let's leave it in this way. We are balancing public interests. At the moment, the public interest that is in play because it has been directed is a swift hearing of the application that Microsoft have made.
Yeah.
The factors that go against that are the fact that the CMA is saying we want the adjournment, the fact that Microsoft, that previously opposed it, is saying it should take place. What is lacking is the necessary meat on, I think, the stage 2 process, the evidential question. And there we have the problem of chicken and egg, because you are saying I should assume the chicken, and I'm saying let's get the egg hatched. And that is a problem which Lord Grabban has quite rightly, quite properly articulated. Is a problem we all face, because I want to be clear again, I'm not asking for information about future proposals. It would be entirely wrong for me to do so. I'm not doing so. But what I'm seeing is a way out of this chicken and egg situation, which is a reference back to events of the past, which may be confidential, but are not going to be WP, which can be articulated in a manner that the CMA and I can see, and which, provided the quashing jurisdiction is wide enough so that no one can say it is a frailty in the decision that is causing the quashing, we might have a way out of the chicken and egg situation.
I would only make one final remark, which is when you talk about the balancing of public interest.
Yes.
In fact, the public interest made manifest in the early hearing and the acceleration was the public interest in certainty and speed in relation to a merger transaction which is being facilitated. It is in fact the same public interest that we are considering in relation to these issues now. What we are saying to you is that actually that public interest can be fulfilled faster and more completely through this mechanism. So I think it's important not to see them as in opposition, even though in terms of people's diaries and availability, that there may be a temptation to do so.
Well, you're absolutely right, but the difficulty, and we're really just articulating the difficulty in many different ways. The difficulty is this. I have control over the route that is running at the moment. If the hearing takes place on the 28th, we will have certainty by the end of August, one way or the other.
Well, with respect, we'll have certainty in relation to the outcome
of this decision. Yeah, absolutely.
Let's assume, in Microsoft's favour, that were to result in a remittal.
Yes.
We then have that further process that, of course, we don't have any managed agreement.
No.
The tribunal can seek to put in place directions, but they will be limited. Whereas when you have an agreement between the parties in the CMA, the ability for matters to move vastly faster is so much greater and so much more certain.
I quite appreciate that is right so far as it goes. And that is bringing me back to the chicken and the egg, which is, at the moment, all I've got to justify the decision is, and I say this with all respect, is the say-so of counsel. In ordinary circumstances, there would be something which I could refer to in a ruling to say, I've been told this by A or B or C. They've given me a witness statement. I understand the parameters in which I'm acting. And yes, the certainty that appears to arise out of a fixed date on the 28th of July is actually a bit of a mirage. For these reasons, I should act in this particular way.
I think we should perhaps...
We should rise, no.
It's been one or two further remarks.
No, that's been very helpful, Mr. Beatty. Mr. Beatty, I'm so sorry. We're approaching this in a somewhat ad hoc way, but then you are all advocating for the same thing, so it's probably fair enough. We'll rise for 10 minutes and resume then.
Porque, Lull, 10 minutos. Mira lo que está pasando. Mira lo que está pasando. El juez quiere anular el bloqueo, ¿verdad? Él quiere anularlo, pero Microsoft y la CMA no quieren, porque supuestamente la CMA puede apelar, que si yo qué, que si yo cuánto. Pero lo que yo también pienso es que la CMA, Microsoft y el juez están viendo como tonto a la CMA, y Microsoft haciendo de que no, y al final el juez viene y anule. Y Microsoft queda bien con la CMA. Como
claro.
Este está aquí, este está aquí.
Eso es así.
Yo creo que es más así, haciendo el tonto a la CMA.
Ahí viene Sega.
Sí.
Se está hablando que viene Sega. Ellos quieren de lado a la CMA.
A la CMA,
para que después no se la ponga en China. El problema es que esta CMA no vale nada, es una basura de institución. Ellos están buscando la manera porque saben que hicieron el ridículo mundial.
Que le queda bien.
Microsoft, el que quiera, dice, no era importante la CMA. La CMA es importante hasta donde Microsoft quiere. No, pero por la CMA la compra nunca se va a parar, nunca. Si ellos no tienen opción, le van a pasar por encima. Ahora, como la CMA sabe que hizo el ridículo, y si van ante el CAI van a perder, porque mira ahora el juez quiere declinar.
Y Microsoft y los abogados de Microsoft y de la CMA no quieren.
Tal vez por la apelación que ella va a apelar, puede que lleve más tiempo. Microsoft lo que quiere que le dé paso. Para ellos no
Microsoft quiere cerrar y quedar bien con la CMA, eso es.
Claro, y que no le ponga una multa.
Y no le ponga que mover todo, ni nada de eso.
Y ellos, claro, tiene que hacer PLC y joder.
Ajá, eso es lo que está pasando.
Pero si la CMA no le deja de otra.
Eso es lo que está buscando Microsoft.
Ellos van a cerrar.
Que no, el juez se lo dijo. Pase lo que pase. El juez le dijo al abogado de la CMA y puso la cara larga, como la cara del tipo ese que nos salió Starfield exclusivo, que puso así mismo. El juez le dijo al abogado de la CMA, pase lo que pase, Microsoft va a cerrar. Así mismo le dijo. Pero ellos quieren que estén en paz, porque es que Microsoft, los abogados lo ha dicho en el otro juicio que no sabe cómo la CMA va a ir detrás de ellos allá en Reino Unido. Entonces Microsoft quiere evitarse todo eso de Reino Unido, de tener que moverse, que cambiar otras vainas y toda esa mierda. Entonces quiere quedar en paz, como que
el CAT lo que quiere tumbar eso.
Tumba hoy. El juez quiere que hoy se resuelva. Eso es lo que está haciendo. Pero la CMA no está de acuerdo, ese problema, porque a Microsoft le conviene, pero la CMA no está de acuerdo. Entonces, el juez tiene que convencer a la CMA.
El problema es que Microsoft, yo no sé con qué futuro piensa, lo que piensa. A ellos no le conviene.
No, Microsoft utilizó a la CMA.
Espérate, que no le conviene extender ahora. No hay
No hay,
indicio de que vayan
el juez lo dijo que
extender.
no van a entender, el juez lo dijo ya.
Entonces, que le pase que ya, que decline eso.
Mira lo que pasa,
Porque ahí lo que
Microsoft,
tiene que hacer Reino
escucha,
Unido de ahora en adelante, mover y cambiar a esa tipa que está ahí y meter otro tipo de política
mira,
cambio
escucha,
en esa CMA.
escucha. Microsoft engañó a la CMA porque el juicio era el 28 y lo adelantan a hoy, día antes del cierre, y lo adelantan. Entonces ahora están ahí. ¿Y cuál es la intención? Que el juez quiere anular, la CMA no quiere, Microsoft hace que no quiere, pero lo que Microsoft quiere es que se termine hoy.
Quiere hoy.
Ajá, hoy, pero que se quede bien con la CMA, que queda bien con la CMA.
Viste, yo le dije y no quiso, viste, yo te apoyé,
sí.
yo te apoyé y por detrás puñala una puñalada porque ese se ve a kilómetros. Serán ellos idiotas para llegar a ellos lo que siempre han
Porque si
querido
Microsoft no se había puesto de acuerdo con la CMA, el juicio iba a ser 28 después del cierre y había que extender.
Microsoft lo que quiere también es, pues si se puede apelar, que ya no apele. Porque,
sí, ajá, que no apele también, porque queden bien, que no apele.
Para que quede bien.
Para quedar bien, por eso.
Eso está todo, oye, ese viaje de Brad Smith, cuando habló con el primer ministro de Reino Unido, eso está todo seteado. ¿Qué quiere decir eso? Que está todo...
Los abogados de Microsoft y de la CMA están contra el juez. Son los dos, los tres. El Activision, Microsoft
está siendo el abogado del diablo.
El policía malo, el policía bueno, el policía
sí,
bueno.
El policía de Ibar, pero mentira, está loco. No.
Oye, yo he dicho eso hace 10 horas y loco lo dice y Benete, y que loco tiene razón, loco, yo tengo 10 años diciendo eso, escribiendo en el chat, jade, hijo, tu maldita matemango.
¿Qué?
Que yo estoy diciendo todo lo que estoy diciendo, yo lo dije en el chat y tú lo dices y que loco tiene razón, yo tengo rato diciéndolo.
No, porque yo te estoy diciendo...
Pero yo tengo rato diciendo lo mismo que tú estás diciendo, yo tengo rato diciéndolo en el chat, escribiendo. Tú vienes y lo dices y dices, el loco tiene razón. Coño, jade, vamos a ser más serios, loco.
No, pero lo que se entiende es eso, es que a Microsoft no le conviene. Es una estupidez. Que por poner ellos van...
El juez lo dijo, el juez lo ha dicho varias veces.
Mira
hoy se termina.
Mira lo que está buscando Microsoft. Una, que si ella quiere que durar sus 2 meses, que lo dure, pero que le deje cerrar.
Que le deje cerrar y no apele y no vaya y no la multe ni nada.
No, ajá, eso mismo, que hay un acuerdo de que sí, después ellos van a tratar.
Ahora, ¿qué hizo
la
Microsoft
otra
inteligente?
Es hacerse el policía bueno.
Ajá, el policía bueno, ese policía bueno.
Y que no, que si yo qué.
No, yo no quiero que anule,
Pero
el juez está presionando a la CMA para que apruebe la anulación. El juez está presionando a la CMA con lo de... Ha mencionado muchas veces Sony. Mencionó la FTC y después Sony. Si Sony firmó, si Sony... Entonces, ya yo me la llevé como que... Yo dije, vean, acá cuando viene a ver, están cogiendo a la CMA de pendejo, entre el juez y Microsoft.
La CMA está demostrando ineptitud y que necesita 2 meses.
El abogado lo cambió, este otro abogado, tú viste, lo cambian el abogado.
Sí.
Microsoft quiere quedar bien, Microsoft quiere cerrar hoy y sabe que la CMA no va a estar jodiéndola allá en Reino Unido. Eso es lo que está buscando. Hay uno que me tiene alto ahí, que con un tal J de que y la CMA no era importante, y la CMA no era importante, y la CMA no era importante. Me tienes alto, loco, ese tigre, loco.
¿Sabe dónde vienen esa gente?
Una maldita multicuenta de que la CMA no era importante. Claro que es importante. El Reino Unido. El Reino Unido es importante. El Reino Unido es importante porque es la reguladora de allá.
Es que lo que pasa es que ellos no entienden que ellos quieren que no era importante, pero Microsoft ahora mismo, ¿quién es que está cediendo? El CMA y lo que Microsoft quiere quedar bien. Ya, porque ellos quieren cerrar de buena fe. Pero
tú estás viendo que el juez está diciendo que yo puedo anular y el abogado de Microsoft no anule porque es que estamos de acuerdo y queremos terminar esto lo más rápido posible, pero tú te das cuenta lo que dice Harry Potter, el abogado de Microsoft. Yo no quiero que tú anules, pero yo creo que estemos de acuerdo y que
él no tiene garantía.
Él no tiene garantía todavía.
Microsoft no tiene garantía de ella. Dale.
No el abogado, cuando el juez le dice, el abogado le dice, no, yo lo que quiero es que estemos de acuerdo y terminar esto lo más rápido posible, como diciéndole, lo más rápido posible, pero que estemos de acuerdo los dos. Eso es lo que está diciendo el abogado. Que
Es lo que
estemos
está
de
diciendo que la
acuerdo.
CMA, es lo que le está diciendo que la CMA hace, que ceda ya, que
Sí.
deje su disparate y cede
Sí,
ya.
porque la semana
Ceda,
una
mi
tira de
hermano.
que 2 meses, y el juez dice,
El
ajá,
culo 2
y si
meses.
en 2 meses tú
Te
niegas.
da la gana cerrar.
Oye,
sí,
el juez
después.
le dijo al abogado, y si en 2 meses tú lo niegas, tú no apruebas los remedios. Y dice, no, porque sí, este sí lo voy a aprobar. Y él dijo, pues deja que Microsoft cierre, entonces si tú lo vas a aprobar. Así mismo le dijo el juez, pues deja que Microsoft cierre. Sí, que quiere que la CMA admita su error y se apee y ya
Y
deje
ella
que
no
eso.
quiere,
Y ella no quiere, y ella no
no
quiere.
quiere. Ella no quiere que hizo mal su trabajo. Hizo mal su trabajo. Por lo hizo mal.
Eso es lo que está haciendo.
Para mí, el juez tiene que anular y Microsoft que se mete un dedo y el abogado y todo eso. Ustedes están locos, es que maldita lo que era el diablo, pero es como no nos dice.
Pero el juez se lo ha dicho 10 veces, yo puedo
ellos
adular, yo puedo adular, yo puedo adular. Esto no pasa de hoy. Microsoft va a cerrarse, pase lo que pase hoy. El juez lo está
Tú sabes
diciendo.
lo que, oye, tú sabes lo que
El juez
quiere.
está ahí para convencer a la CMA de que se apella.
Tú sabes lo que quiere realmente el juez. ¿Qué maldito que quiere qué? El juez lo que quiere es dejar el país bien, que se joda la CMA. Es lo que quiere ver que allá funciona la ley y que
Sí,
si la
pero
CMA va a
la
hacer una
CMA tiene
polla,
que rendirse, animal.
por lo mismo tanto.
Él está
Es lo que quiere
buscando,
saber.
él quiere convencer, o sea, él quiere llegar hasta el punto, acorralarla, que la CMA diga, ya, es verdad, me metí un error. Eso es lo que está haciendo. Que acepta su error la CMA.
Ya,
Eso es
cometió
lo que
un
está
error,
haciendo.
pues llevarse de línea acá. Ahí sabe. Ahí tienen que mover. Oye, ellos tienen que poner leyes y reforzar eso de la CMA en Reino Unido. Es un disparate. Comparado con Estados Unidos, eso es la jungla. Oye, en vaina de leyes, Reino Unido es una jungla comparado con Estados Unidos. Tú no ves que hay mucha vía, muchas cosas.
Mira lo que pasa, la FTC, el juicio de ellos es agosto 2, de ellos, que no tiene que ver con federal, de ellos. Entonces, si hoy no se resuelve en paz con la CMA, Microsoft tiene que hacer juicio con Lina Khan y con la CMA y va a seguir con juicio. Pero si ellos anulan a la CMA, que ya esto queda bien, nada más le va a quedar Lina Khan. Y si la CMA se rinde hoy, ya va por Australia y Nueva Zelanda va a aprobar también.
Mira, Jonathan Núñez, el ardido. Oye, tú estás desbloqueado de mi canal. Ve, entra a pasar vergüenza de nuevo. Que nada más iba a hablar de disparate, nada más. ¿Qué está diciendo que tenga más que tiene la razón? Pues estamos hablando. ¿Sabes cómo son estos haters de una vez, dolidos? De que yo entro a hablar de una vez, empiezan, le doy en la herida. Escucharlo parece que le da
ahora mismo.
Pero tú lo ves lo que dice de una vez.
Ya pues te lo contenga más su que no le dé la razón. Tiene que argumentar.
Pues yo no estoy argumentando, estoy jugando a aquello. ¿Qué yo estoy diciendo? Yo te conozco bien a ti.
No, Microsoft hizo una buena jugada porque era el 28 y de 28. Lo mismo que Lina Khan, que era en agosto y dijo voy a cerrar. Y Lina Khan tiró el troll la vaina y la adelantó. Y hizo lo mismo con esta. Vamos a estar de acuerdo, papá. Y lo adelantó. Entonces hoy se resuelve hoy. El juez se lo ha dicho varias veces. Puedo anular, hoy se termina, Microsoft va a cerrar, pase lo que pase hoy, esto no va a pasar, el juez lo está diciendo.
Quiere el juez lo que quiere dejar bien a su país, loco, bien adelante el mundo, porque te digo algo, ellos que quieren quitar la grabación, lo que están hablando, y el juez no quiere mandarle el mensaje al mundo,
sí.
En mi mundo, y dice, no, porque el Reino Unido quiere mandar un mensaje de que allá sí se puede confiar, porque la CMA ha dejado manchada a Reino Unido.
CMA le pidió a Microsoft que esté de acuerdo para que no graben y el juez dijo, no, yo voy a grabar. Dijo que iba a grabar el juez. Y el juez empezó enojado. El juez desde que empezó tiene más de 2 horas, como más de 2 horas y enojado
es lo que está diciendo, esta gente no hizo perder tiempo,
sí.
Messi, vaina, para un disparate, porque hizo un disparate, loco, todo el mundo sabe. Nada más un loco viejo decía que la CMA era profesional, que hizo un gran trabajo. Pero todo el mundo cuando vio la CMA dijo, pero ven acá, ¿qué lo que eres esta? Y ya se nota, ellos quieren tiempo, como de que pensaron, de que para después de que
oye, de que 2 meses más, y después cuando verá lo que pasa, a ver. Ellos quieren 2 meses, ¿verdad? Pero el 2 de agosto viene Lina Khan. Pero viene Lina Khan el 2 de agosto. Viene Lina Khan.
¿Quién dijo que viene Lina Khan el 2 de agosto?
El 2 de agosto el juicio de Lina Khan. El 2 de agosto el juicio de Lina. El juicio de ellos.
Eso se acabó ya, loco.
No se ha acabado.
Oye,
Lina Khan tiene su propio. La FTC tiene su propia vaina, la FTC. Ella puede seguir jodiendo. La
Eso va
FTC.
por parte, eso
Sí,
va por
pero
parte.
ella tiene juicio, el 2 de agosto es juicio de la FTC, el juicio de ellos, de la FTC.
Eso se aprobó, loco. Si se cierra ya no va a poder hacer nada. ¿Qué va a hacer ella ya?
Por
Ha
eso
pedido
mismo
2
que si se
veces.
entiende,
Ya
va a tener
Sony
que...
firmó. Ya
Sí.
ella no hable de Linacal. Linacal no
Loco,
tiene
pero
nivel
que hay
en eso.
juicio como quiera, loco, tienen que ir
No
a
importa.
juicio. No importa, tienen que ir. Hay un juicio, loco, tienen que ir. Hay juicio.
No, eso no tiene nada que ver, muchachos.
Loco, Chapato ya lo con que el rumor de ayer todavía dijo que la semana era profesional y no tenía que dejar que Microsoft cerrara hoy. Sí, el piloto número 1. Y se burla y se burla. Él dice todas esas cosas y se le burla de la comunidad. Y que, ajá, me puse mi carnet. Y se le burla ya, lo que es comunidad más rata, loco. El
No,
tipo
lo
se
peor
le
eso es lo
burla
que
en
lo
la
ven.
cara.
Lo peor eso es lo que lo ven.
Ajá,
A mí me
él
importa
se
un
le burla en
pepino.
la cara y ellos siguen
A mí me
mamándose.
importa un pepino. Pues yo sigo con mi vaina. Yo
Yo
lo
sé
que
que lo
sé es que
desmantelamos, lo
Yo lo
desmantelamos.
que sé es que esa guerra me sumó porque él me estaba drenando, vendiéndome como un desinformador. Al final tengo más visitas, tengo más donaciones, tengo más miembros, tengo más de todo. Estoy ganando más cuartos. Y entonces, ellos no se le dio el plan conmigo. Estoy mejor que cuando empecé la guerra con él. Que ahí fue que yo le empecé. Yo dije, vea, que este tipo me está vendiendo y la gente se iba a pan de él. Dije que era abogado y más informador. Al final, ¿qué? Yo traje más gente que él tenía mía. La tengo aquí. Más donaciones, más de todo. Y entonces, que debería tener más visitas, tengo Shadowban, pero como quiera saco mi cana a flote. Sin venderme como nadie, que profesional y que yo. Gran vaina, pero por eso es lo oye, te digo algo, nadie me habla de ese tipo habla demasiado disparate. Ese tipo tiene un año y 8 meses diciendo estupideces. No pega una, le roba a todo el mundo y no pega una. Cuando él quiere analizar algo, no le da el cerebro.
Pero ayer
Coeficiencia.
subió que Nueva Zelanda aprobó y tuvo que borrarlo porque yo demostré que era mentira y lo borró de una vez. Pasa que estaba en directo viéndome y lo borró. Dije que Nueva Zelanda aprobó, oye.
El que siga queriéndose llevar de un tipo que no pega una. Tú no ves lo que dice el juez ahí. Que si él quiere, declina. Y él decía que no, que el juez iba a mandarlo a revisión. Un viaje de desinformación, loco.
Sí.
Un viaje de disparate. Todo
¿Qué
lo que le venía a la
pasó?
mente lo decía.
El juez no daba a mandar revisión. No. Y mira que el juez, lo ha dicho como 10 veces que puede anularlo. Pero supuestamente el juez manda revisión.
Ya está en el despacho, ya está engavetado.
¿Qué pasó? El juez no mandaba revisión. El juez lo ha dicho como 10 veces que puede anular. Que él puede anular. Pero supuestamente era que no, que el juez manda revisión y la CMA bloquea de nuevo.
Que enseñe el título mejor y deja de estar hablando mierda. Y la gente que lo sigue nada más vive y no lo dice. Vean que ahí el título. Y el título. Nadie le dice nada. Porque sabe que no es abogado nada y se vende. Debería haber una ley allá, yo no sé si está en España, denunciarlo porque se vende como abogado para ver lo que va a hacer. Cuando le digan, ¿y su título dónde está? A ver lo que va a hacer. Es que no es abogado, yo le dije que iba a cerrar mi canal y no enseñó el título. Tú estás loco. Abogado y culo.
Entonces, estamos ya esto. Más de 120 juicios tiene. Lo que pasa es... su trabajo. ¿Verdad? Porque ellos son de la secta. Lo que pasa es... El juez quiere anular. El juez ha dicho que de hoy no pasa. Que Microsoft pase lo que pase hoy va a cerrar. Entonces yo me di cuenta que él quiere decir a la CMA, admite tu error y ya deja que esa compra se dé ya. Deja de joder. Eso es lo que el juez le está diciendo a la CMA. Ya deja de joder porque le ha dicho, pase lo que pase, Microsoft va a cerrar. Pase lo que pase hoy, Microsoft va a cerrar.
Es que no tiene título de abogado, ya lo hubiese enseñado. Si él tuviera su título, ya, oye, nosotros sabemos mucha información que no la damos porque no estamos en eso. Tenemos todo ese tipo, no es abogado. ¿Dónde estudiaba? ¿Qué hizo? Todo eso. Abogado, ¿qué va a enseñar? La hubiera enseñado hace tiempo y tapa boca. Tú estás loco, muchacho. YouTube no da título. Tú decides que yo soy abogado, YouTube no te va a mandar. La gente cree que si YouTube, tú decides YouTube, yo soy abogado, YouTube te va a mandar un certificado. Sí, toma, tú eres YouTube. Tú eres no YouTube, tú eres abogado.
Hay uno que es profesor, hay dos que son abogados, después va a venir un astronauta, un piloto, después va a venir un extraterrestre, después va a venir un perro.
Toditos son
que
unos
YouTube-
mentirosos, todos son unos mentirosos, hablando pila de M. Y vi lo de los puntos ahí del otro, eso ni él se lo cree. Eso es la cuenta de él, que la tiene familiar y juegan con la cuenta de él y acumulan los puntos. Tú estás loco, un tipo que vive haciendo videos, vive andando, vive de que subiendo montaña. ¿De dónde va a sacar de que 100.000 puntos? Nada más los borregos de él le creen. Nada más los borregos. De que no, que hay minijuegos. Un tipo que vive haciendo también análisis de juegos de PlayStation, que a cada rato saca un análisis. Pero tú estás loco, Nada más,
Loco,
la gente de ellos
loco, es verdad, loco, lo que está pasando. Hasta Florian lo subió, resetera en todo lado, que todo el mundo está confuso. Porque la gente dice, va, que el juez quiere anular, pero Microsoft dice que no. Hay mucha gente que no está entendiendo lo que está pasando. Hay mucha gente, hasta Florian dice que hay muchas cosas confusas. Que el juez le dice al abogado de Microsoft, yo puedo anular, y él dice no.
Dice que ya cerraron. ¿Que cerraron qué? ¿Cerraron el colmado?
No, está preguntando que si cerraron, pero que ellos no ponen el signo. Ellos no ponen el signo y no dicen nada.
Loco, la Microsoft está pasando por idiota. Si quieren que no. Pensando en otra compra, seguro en Sega.
El juez dice, como Sony filmó, la FTC perdió, ya aquí tiene que resolverse esto, pero Microsoft y Activision y la CMA están del mismo lado. Eso es lo que no se entiende, es una loquera, loco. Microsoft, los abogados de Microsoft y Activision y de la CMA están del mismo lado y son los toditos contra el juez. Porque el juez quiere terminarle todo y quiere anular, quiere esto, pero ellos no quieren. Porque ellos quieren que la CMA se ponga, porque la CMA no está de acuerdo. Pero si tú ves la cara larga que puso ese tipo, loco. Cuando el juez le dijo, pase lo que pase, hoy Microsoft va a cerrar. El abogado de la CMA hizo así. Tragó y se vio la cara larga y la tragó en seco así. Cuando el juez le dijo eso. Yo tengo una cuenta vieja que la estoy recuperando de 2012, 13 para allá. Desde que yo creé mi primera cuenta mía. Porque Roba Rumores dice que anular es reiniciar el proceso.
Deja de estar hablando de ese tipo lo que habla mierda. No se lleven de lo que dice ese tipo. Mejor llévate de lo que dice otro.
Mejor ven y después que Florian dice esto.
Mejor vean, incluso vean a Derek, que Derek habla mucho de disparate. Vean mejor a Derek que ese tipo. Tipo lo que habla pila de mierda, loco, tratando de que debe ser de que un tipo inteligente y no pegó nada, es que nada. Todo lo falló, todo lo que dijo, todo. Dice que eso se resuelve en 3 meses, que eso esto, que eso aquello, que eso de María hasta 2020, que yo cuánto.
Ya llegan.
Ya deja de estar hablando de esa gente. Loco,
given time, it's probably sensible if Mr. Bailey picks up. I think if the tribunal's concern is, in essence, things that have been said to the tribunal today, or are set out, for instance, in the CMA's skeleton in relation to the speed with which things can be dealt with, then I imagine, and obviously I defer to Mr. Bailey, that a witness statement could briefly be provided to the tribunal to provide that confidence that whichever of these routes we're going down, it can provide certainty and speed. And that may well be the sort of evidence you actually have in mind in relation to part 2, because given that one can't get into the substance of discussions, that may well be sufficient to deal with that public interest discussion that we were having before that brief adjournment. Obviously, we can provide our view about how speed works here, but in a way, the points that are actually made, to be fair to the CMA in its own skeleton argument, if they are signed off in a witness statement, that may well take us a very long way in relation to your concern, because then we have methods by which things can be dealt with legally. We would have evidence of speed being feasible and therefore certainty being feasible. We have consensus view in relation to point 4. I'm not sure that point 3 necessarily in those circumstances adds to point 2 in your rubric. And that may be sufficient for you in these circumstances. If the order of the tribunal would be, yes, I will provide the indication of adjournment on the basis that that witness evidence is provided, then it may be we have a way of shortcutting it in order to assist the tribunal. And just dealing very briefly with the issues that were highlighted in relation to public interest more generally here, I think we've got to be careful that in relation to the public interest, as I said, the public interest is in relation to process and the confidence we have in that process, not in relation to the particulars of the scheme. But I imagine also the CMA may well be in a position now to say that it does believe that a new RMS can be put forward given what it has heard without trespassing on any matters of without prejudice discussion. And if that were to be the case, Mr. Bailey might want to take brief instructions. But if that were to satisfy the tribunal without us getting into precise quashing powers, because I think there be a disagreement between us and the CMA, having had a brief discussion with Mr. Bailey, we could circumvent a number of these issues to all of our benefits. We would preserve the consideration of those legal issues, but we would make sure we had the relevant breathing space to deal with it.
Thank you very much. Mr. Bailey.
I propose to address issues in the following order. Briefly to address the question of quashing, since the time and as Mr. Beard has rightly anticipated. We respectfully differ from my learned friends in that respect. Secondly, to address you on how we say the statute does have mechanisms for properly dealing with new developments that arise after the final report. And just to trail what they are, prior to the final order being made, there is, as we discussed, my learned friend Mr. Beard took you to it, section 41.3, which is a process that is currently underway before the CMA. There is, of course, also prior to the final order, the possibility of abandonment, and that is the Argyle case, which I was taking you through. And after the final order is made, and Mr. Beard is right, if one is made ultimately in light of the representations, then the statute also has a mechanism in the form of section 92, which allows the CMA to take account of a change of circumstance that arises at that juncture. Having briefly dealt with those issues, what I then wanted to do is just retrace our steps back to your four-stage framework, if I may, and in particular to pick up a point that Mr. Beard was making about time of the essence. And he said at the end of his submissions there that the CMA has the ability to move with deliberate speed. And I wanted to show you how in the course of a phase 1 investigation, one achieves that speed, and in particular the fast-track procedure that exists for dealing with cases where it is appropriate. I then wanted to move on to stage 2 and the evidential basis for the application. You do have, of course, some evidence in the form of Ms. Radke's second witness statement.
Well, that's about the effort and the resourcing issues that the CMA has in doing a twin-track process, isn't it?
That's partly addressed in that statement. The other issue that she addresses in the statement is the question of the significant, we say, unexpended costs that could be avoided if the hearing is adjourned and relisted in October. She also sets out her estimates, at least of the costs that would be avoided on the CMA side. We obviously have no visibility as to the nature and extent of the costs.
Well, let me just be clear, Mr. Bailey, those are 2 points that I entirely accept. You don't need to spend very much time on those.
I'm grateful. And as Mr. Beard was alluding to, insofar as the tribunal wishes to have a proper evidential basis going beyond the matters addressed in her second witness statement, on instruction, I can say that the CMA would be willing to prepare a witness statement with a statement of truth that attests to various of the propositions set out in our skeleton argument, in particular at paragraph 2, which sets out the state of play as the CMA currently understands it. And of course, if there are other matters which the tribunal wishes to be reassured about, then of course I'd be willing to take instructions to see if a further statement can be prepared to see if that could provide you with that basis. And then finally, I'll deal with stages 3 and 4 of your framework and address your question that you asked about why, when the CMA made its first application for adjournment, this matter wasn't addressed at the end of June. So if I could just start then with a momentary disagreement between the CMA and Malone and Friends in relation to quashing.
Yes.
So it's perhaps helpful to turn up the statute that deals with the Tribunal's power in this respect. And as the Tribunal obviously knows, it's contained in section 120.
Yes.
And that is to be found at tab 1 at page 154. And the relevant power that the Tribunal would be exercising is to be found in subsection 5. And it states the Tribunal may dismiss the application or quash the whole or part of the decision to which it relates. And in my submission, one has to read subsection 5 within the context of the entire section, in particular, subsection 4. And that provides that the Tribunal shall apply the same principles as would be applied by the administrative court. And indeed, the Tribunal, in its remittal judgment following the B Sky B Virgin litigation, which is 2008 Cat 32, specifically said it would exercise its power under section 5 by reference to principles of judicial review. Now, we've rapidly looked to check the position as a matter of what the administrative court would do in this situation. And in my submission, the Tribunal does not have jurisdiction to quash absent a material error of law. And moreover, the Tribunal does not have jurisdiction to quash the final report by reason of facts and matters that arose after that decision was taken. The exception, of course, well established, relates to jurisdiction fact, where there is the possibility to take into account subsequent developments. But for those reasons, we say that the Tribunal doesn't have jurisdiction, no matter the Sony agreement with Microsoft or any other circumstances that have arisen after the final report. Now, that is my submission in relation to the statute and the Tribunal's power. But I have a further point to make, which is that the statute does have mechanisms for dealing with subsequent and material changes of circumstance. And before I move on to deal with those mechanisms, can I just pause to see if the Tribunal wishes to ask me anything about section 120?
Well, the only question I had was, are you saying that CTS Eventim was wrongly decided or just fails to appreciate that you needed to establish a ground of judicial review before you could exercise your section 125 jurisdiction? Because my reading of Eventim is that we went down that route on the basis of a mere arguable concern that existed on the part of the Competition Commission, which it wanted to look at. And so without conceding that it was right, they said, we want to look at this again, please quash. And I appreciate it was not after the end facts, but it was certainly not the case that section 125 was used as a remedy following a successful establishment of a JR, because there was no finding in that case to that effect.
I'm somewhat hindered that I don't have the Tribunal's ruling and
Yes.
order in CTS Eventim in front of me. I don't actually believe it's in the bundle.
No, I saw that.
From memory, the Commission conceded, I think it was the first ground that had been brought by that third party in relation to the Ticketmaster merger. And it was on that basis, which, as you rightly say, sir, is not an after the decision fact. The CC, having conceded that, then wanted to reinvestigate, and the mechanism that was chosen was to quash and to remit. But I confess I don't have the rulings. It's difficult for me to comment on whether it was wrongly decided.
I do, because I printed it out, because it seemed to me important. Paragraph 7 makes clear that the Commission has explained that Eventim's first ground of review, based on procedural fairness, was arguable, at least in the particular circumstances of the case. So all I'm saying is that the ratio of this particular decision is that the quashing order was made without finding a ground of successful JR. Now, that may be right, that may be wrong, but that's what I think Eventim decided.
Rather than make submissions immediately without having looked at the ruling.
Well, Mr. Bailey, of course, I understand the CMA's concerns because you don't want to be given what you've said about your standing behind the decision. You don't want it to be tarred by an overly tight brush, which suggests that the only basis for quashing is a deficiency in the decision. And frankly, I don't think Eventim is going to help you very much on this because it was dealing with what was acknowledged to be an arguable ground of judicial review, not what I would say is this case, which is an unequivocal change of circumstance after the decision. The only point I would indicate a degree of interest in and pushback on is your point that a subsequent change of circumstance that undermines a decision is not a material factor for quashing. It seems to me that if that's the case, one is opening the way to all kinds of defences, to unnecessary defences of decisions in circumstances where a regulator or a public decision maker is in a situation of having made a decision perfectly properly and is faced with later events which make that decision absurd, let's put it as highly as that. The idea that you can't come to court and say, look, I can't change this decision because of the way the statutory regime works, but it's a decision that just needs revisiting because of later events, that would be a very odd outcome, but it may be that's the law.
So you wouldn't be surprised to hear that CMA wouldn't accept that any of the subsequent developments renders the final report absurd or irrational or anything of that kind. It does lead me on to the next point, which is a point which actually happily the parties agree about, that there are mechanisms within the statute for dealing with the type of material change of circumstance that you rightly identify, sir. And Mr. Beard took you to section 41, subsection 3. And it's important for me to say that, of course, this is a live issue before the group. And sir, if I may, the CMA was somewhat concerned by the observation that you made in the course of argument about whether the agreement that has been entered into by Microsoft with Sony, and I'm in the same position as you, I've just seen the press reports of that, whether or not that should be regarded as either a gift of an MCC or even as an MCC at all. For the avoidance of doubt, of course, the CMA has to remain open-minded at this moment. It is considering the matter, and therefore, well, it's not even considering the Sony-Microsoft matter because that isn't part of the representations that have been made to the CMA to date. Moreover, as you rightly observed, sir, there is no evidence before this tribunal, and as far as I'm aware, before the CMA, in relation to the entering in the terms of that agreement. So there's just to sort of put down a marker that because that is a live issue and one which the CMA is going to carefully consider, that is one mechanism that exists for dealing with events that arise after the final report. Parliament has said if before you make your final order something material happens, then one is able to address it. But so you raised a point with my learned friend, Mr. Beard, about, well, hold on, this can't be just a dialogue between the parties and the CMA. And if I may, I wholeheartedly agree and would like to show you that during this process between now and the end of August, if the tribunal group, if the CMA group were to modify in any way the draft final order, it would be under an obligation by statute to consult interested third parties. So there is no way that this would just be a bilateral discussion between the CMA and the parties. And just to show you and make good that point, if one looks at tab 2 of the authorities in Schedule 10, this sets out various procedural requirements that the CMA has to comply with when considering whether to accept undertakings or making orders.
Yes.
Page 171. And you can see it first of all talks about the requirement when before accepting an undertaking, that's paragraph 1A, or making any order. Here we're concerned with section 84. And then paragraph 2 sets out the obligation that one has to give notice and then consider any representations. Now that is talking about the process that was initiated in May, and if one turns over leaf, one will see in paragraph 2, subparagraph 2, F, that the period that the statute requires is not less than 30 days, starting with the date in the case of an order. Now that's just by way of background. To come to the point about, well, what about the CMA considering Microsoft's representations of an MCC arising after the final report, and they say should result in either no final order or a material change. If one looks at paragraph 4, you'll see that relevant authority, here the CMA, shall not accept an undertaking, not relevant here, but make the order with modifications unless, again, it's given notice and considers any representations. And then that's spelled out in paragraph 5, paragraph C, where the period has to be not less than 7 days. So it's relatively rapid, as one would hope and expect, but nonetheless, there is an opportunity for interested parties to express their views on any change of stance in relation to the final order. For completeness, I should acknowledge at the end of this schedule, in paragraph 9, there is the power for the authority to dispense with any or all of the requirements of this schedule if the relevant authority considers that it has special reasons for doing so. And rather wonderfully, Parliament doesn't say what a special reason is. But that's just to show you the complete picture in terms of the statutory flexibility that exists, but also that there are safeguards for third parties in relation to any material change of circumstance. So that is one mechanism by which Parliament has, in my submission, allowed the CMA to deal with circumstances that arise after the final report that are said to be material to any remedy that it ultimately imposes. But as we were averting earlier this afternoon, there is, of course, a second way in which, prior to the final order again, it would be open to the CMA to take account of a change of circumstance. And in my submission, that is section 37, and the duty to cancel a reference if the CMA is satisfied that the original relevant merger situation has been abandoned. That's the Argyll situation. So if events move on and, like in the Argyll case, Microsoft were to come along and say, look, here's a new all singing, all dancing bit. It's not anything you've seen before. And we say that is a new relevant merger situation. And if the CMA was satisfied of that and no final order had been made, then it could reach the conclusion that the original RMS had been abandoned and then the reference would be cancelled.
But Mr. Bailey, aren't we moving from the grounded in reality to the fanciful here? I mean, are we really suggesting that there's going to be an arrangement between Microsoft and Activision that isn't, in substance, carrying forward an acquisition of the latter by the former?
Well, as Mr. Beard drew attention to, sir, in the Argyll case,
yes,
actually the Guinness original bit
I know,
the revised bits were not that different. They were the same in terms of acquisition of issued share capital. It was just a change to parts of the business that were going to be acquired. Yes. So, and nonetheless, the Court of Appeal held that the MCC were able to arrive at the conclusion they did on those facts, saying that there had been, on those facts, of course. And I do say that, of course, the CMA would need to look very carefully at the facts of the restructured transaction before it reached a conclusion that it had been genuinely abandoned.
Yes.
I just draw it to your attention because it's a different way, a different route by which change of circumstance can be dealt with prior to the final order being made. Once the final order has been made, if that is the case, having considered Microsoft's representations, and as to that, of course, the group has to consider what's being said, then Parliament has also provided for how a final order can be varied or revoked, and that is set out in section 92 of the Enterprise Act. I don't know if it would assist to briefly show you that so that you can see the picture of how the statutory scheme is, how it works. And so section 92 is to be found, it begins tab 1, page 93, and the relevant provisions are on page 94.
Yes.
And it's section, subsection 2, the CMA shall, so there is a duty in particular, from time to time consider, and the relevant paragraph is C, whether by reason of any change of circumstances, an enforcement order is no longer appropriate and needs to be varied or revoked.
Yes.
Now, change of circumstance here again is not defined and would be a matter of fact for the CMA to consider as and when it arose. The reason why I wouldn't press this on you at the moment, because you were asking about the factual basis for things, is that as matters stand today, there is no final order. And so in a sense, this would be hypothetical. It would only arise if a final order were to be made. And then the other point to draw to your attention in subsection 4 is that the CMA has a wide discretion as to the action it considers appropriate in varying or revoking any order. So it's really, I'm providing it to you for completeness, because I accept that that particular route is at the moment based on a hypothetical that hasn't yet arisen.
Yes,
with that in mind, I'd like to return, if I may, briefly, just to pick up a point that Mr. Beard made. Now, Mr. Beard rightly emphasised that we need to have our skates on, that time is of the essence. And I wanted to show you the practical context in which the CMA would review and consider any restructured transaction. And the way I'd like to do this is just to show you briefly two parts of the CMA's guidance on its jurisdiction and procedure. And that is to be found in tab 4 of the authorities bundle. The first is just to show you briefly what is involved in a phase 1 investigation. And that is to be found at page 203. And it's helpful because it shows you the process in a page. And we can see that typically it starts with pre-notification. But of course, here, the parties have been engaged in discussions, they know one another very well, and therefore there is no need for that. So we can skip straight to the beginning of a phase 1 investigation, which would start once Microsoft notifies the new transaction and once the CMA is content that the notification is complete. The next step in any phase 1 investigation, as one might expect, I'm now in the sort of the third box, is that the CMA would engage both with the parties, but also habitually consults interested, and that's a process that typically, according to the guidance, can take between 15 to 20 days. At the end of a phase 1 process, the CMA must decide whether its duty under section 33 is engaged. As we adverted to earlier, that has to be done within a strict statutory timetable of 40 working days. But there is more, because the CMA can move more quickly than the statutory timetable and has in place a procedure that allows it to essentially operate a fast track of particular mergers, and that is to be found at page 249. And if this were a matter that needed to be addressed in evidence in terms of how it works and how the CMA operates, I'm sure the CMA would be happy to assist the tribunal. And the point about the fast-track procedure, I know the tribunal has its own fast-track procedure. Here, the way it works is that it works with the parties asking the CMA to please essentially press the fast-forward button, and one can move either, and we see this at paragraph 7.6, either to a reference. I understand that no one is arguing for or wanting that to occur, but we can also see that it can move more quickly to offering undertakings in lieu, i.e. remedies, with a view of obtaining a phase 1 clearance. Now, of course, before one gets into the fast track, the CMA will have to satisfy itself that there is a new relevant merger situation. I'm not going to go over that again. But the point I did want to draw to the tribunal's attention is that the CMA does have the ability to flex and expedite its procedures. It can truncate the time for consulting parties. It doesn't have to have issues meetings. These are points that are made by the guidance at paragraph 7.12. And I should add that the CMA does have experience of using this fast track procedure. What one can see some examples in footnote 130, which is a rather long footnote on page 249. But more recently, earlier this year, various transactions move forward speedily to a phase 1 decision. But of course, the CMA will need to ensure that it discharges its statutory obligations properly and fairly. But nonetheless, if one needs to move with speed, this is a procedure that is available for doing that. So that's what I wanted to say in relation to the Section 33 process, what we refer to as Route 1.
Yes.
I'd like, if I may, to come back to your second stage of your framework, sir, and that is where you asked about the sufficient factual basis upon which the application has been made.
Yes.
And my learned friends have already averted to the fact that part of the factual basis is cloaked by without prejudice privilege. What the CMA has sought to do in its skeleton argument in particular, paragraph 2, is articulate that based upon the discussions to date, both sides, Microsoft and the CMA, have confidence that Microsoft notifying a restructured transaction is capable of addressing the concerns that the CMA has identified. Of course, I accept a skeleton argument settled by counsel isn't the same as a witness statement sworn by a statement of truth. And that is why I said earlier that the CMA is willing to set out those matters in paragraph 2 of the skeleton in the form of a witness statement to provide that evidential basis. I should also say, just for completeness, although I accept it's not an elaborate point, so that there is the witness statement of Ms. Radke, and it's at the core bundle at tab 6, and there is just the final point in paragraph 18, which I accept may not be enough in and of itself, but is a statement at page 26 of the CMC bundle, where she sets out essentially the CMA's carefully considered view that the application would be in the public interest, and in particular would be because, as she says towards the end, to see whether there is a means by which the competition concerns set out in the report can be adequately addressed without the delay and cost of litigation. And Mr. Beard addressed you on that point in terms of the concern on this side of the court by the tribunal's laudable proposal of having the hearing and then moving to a draft judgment towards the end of August, is that there is a critical window now of the next 3 weeks where, if the litigation goes ahead, it will inevitably be hard-fought, adversarial, and even with the best will in the world, that is not conducive to the parties engaging constructively one another in relation to the restructured transaction. And as Ms. Radke says, on the CMA side, and this is made at paragraph 16 of her statement, there is the additional challenge that many of the key members of the CMA's senior staff will be involved simultaneously in preparing for and attending the hearing, and they would also be involved in considering the notification made by Microsoft. And it's perhaps self-evident that one can't be in two places at once. Yes. But when you put those points together, it does mean that it is critical now to have that opportunity, in my submission, for the party to see if they can reach a constructive outcome, as far as the CMA is concerned, in the interests of consumers and protecting the nascent competitive process in cloud gaming. So that is where matters stand at the moment in relation to the sufficient factual basis. But as you, sir, said earlier this afternoon, if one is minded to say yes, but on condition that we bring forward further evidence, then the CMA is very happy to seek to consider what evidence is needed for the tribunal to satisfy itself of the desirability of this application. Stage 3, sir, was the adequate basis for the adjournment and the basis upon which we have made this application. So in my submission, the basis is as set out both in Ms. Radke's second witness statement and the skeleton argument, that we do say that there's a realistic chance of our concerns being addressed if this restructured transaction is notified and reviewed. You asked, as a matter of concern, why, if this restructured deal was under consideration, it was not mentioned in the previous application that the CMA made on the 28th of June. My instructions are that it was not mentioned essentially for two reasons. One, at the time of that application, there were no ongoing discussions between the parties in relation to any such restructured transaction. And two, the basis for the CMA's application was, as you will no doubt recall, sir, one of the need for a fair hearing and the view of the first Treasury.
I certainly recall the basis was entirely different from this, yes. And that's understood. It's more the absence of any hint of this being a matter that was of relevance, and it may not have been because it may not have happened to the CMA, that puzzled me, given it was only 2.5 weeks ago.
No, I quite understand, sir. And so my instructions are that it wasn't yet, it was not relevant to that application, and there was no sign that this was a real prospect until the moment at which we jointly made this application. Stage 4 is whether there's any other reason why the tribunal shouldn't grant the stay and adjournment. And you, sir, identified one possibility, and that is the coincidence in timing of the outcome of the FTC's application for a preliminary injunction and then the joint letter that was written asking for a stay. I can only speak for the CMA, of course. Mr. Beard will no doubt speak for his clients. But as far as the CMA is concerned, the outcome of that first instance decision formed no part of the CMA's thinking. We are squarely focused on the public interest, as you would expect. We would, if the tribunal were to grant the application, ensure that we discharged our responsibilities under the Act. And if I may, just in concluding, take you back to one passage of Argyll. I realise it's come up several times, but it's a different passage. And I hope it's a helpful one, just to provide a steer in terms of where I'd like to rest the CMA's submissions. So tab 3 at page 186. And I'm not so much concerned with the particular issue.
So sorry, page
186.
186, I'm sorry.
Or 266 of the law report.
Yes, thank you.
And on what here the Master of the Rolls is dealing with is setting out, we can pick it up just under little c. He says, we sit as a public law court, reviewing an administrative decision, applying judicial, quasi-judicial principles. We have to approach our duties with a proper awareness of the needs of public administration. And then he sets out 5 propositions, all beginning with good public administration. And I hope that when one considers these, one can say that in relation to each and every one of them, so far as the CMA is concerned, our application achieves those. So the first is that a trite point about being concerned with substance rather than form. And I can say on instruction that when the restructured transaction is notified, that is squarely what the CMA will focus upon. The substance of what's being proposed. Is there a new RMS? Has the previous one been abandoned? What is the likely effect of any RMS that's notified? So we will certainly focus on that. But then this, that is concerned with the speed of the decision. Well, this is a point that happily both Mr. Beard and I are on the same page. We want to move forward with deliberate speed. And I've shown you, sir, that there are procedures in place that allow that to happen. I'd like to take the third and fourth points together. They basically say good public administration requires a proper consideration of the public interest, and moreover, legitimate interests of individual citizens, however rich and powerful they may be, and whether they are natural or judicial persons. And we say that that has been absolutely the heart of this application. We wouldn't have made it if we didn't think that there was a realistic chance that a restructured transaction could resolve our concerns to the benefit of consumers. And then lastly, and I think it's an important point, about the requirements of decisiveness and finality, we say that if this transaction is notified and it addresses our concerns, then we do anticipate achieving comparative certainty more quickly than this litigation would achieve, not least, as Mr. Beard was saying, there is the prospect that the loser may appeal the tribunal's decision. If the CMA were to lose, the prospect of a remittal and a further investigation. By contrast, if one takes the counterfactual envisaged by the application, we say that it could deliver decisiveness and finality as expeditiously as one would hope for. Of course, I can't preempt the outcome of the group's deliberations. I can't promise that there will be a favourable outcome, but what I can say on instruction is that we do consider it has a realistic chance, and for those reasons we would invite the tribunal to grant the application.
Very grateful to you, Mr. Bailey. Thank you very much. Mr. Beard.
I realise the tribunal said take as long as you want, but I think I will try to be brief in dealing with 2 or 3 points. We've obviously canvassed a number of issues in exchanges already. Since we're in Argyll, perhaps we could just stick with Argyll,
yes, of course,
if that's okay. I'm only picking this up in passing. So you mentioned the question whether or not an abandonment and so on will be fanciful. I think it is very, very important to bear in mind that the RMS test is in relation to an enterprise, not whether or not Microsoft is acquiring Activision. It's what Microsoft would be acquiring. And that is precisely what was considered in Argyll, because Guinness would still be buying distillers, still be buying all the shareholding, and one can see that picking it up at page 181. Between D and E,
yes.
You're probably familiar with this passage. I won't read it.
No,
and through
yes.
through to G. Because essentially, Argyll's precise submission was, look, Guinness is still buying distillers. Look, it's still a full share acquisition. This is just tinkering around the edges. It's fanciful to treat this as an abandonment of the previous approach. And what the Court of Appeal, and indeed the court below, analysed was whether or not in substance there was a material change here. And I don't mean material change in the sense of Section 41. I mean in terms of the business, the enterprise that was being acquired. And since the only concerns related to whiskies, if the deal didn't involve the whiskies, it was materially different. It was still Guinness buying distillers, but it was materially different. And we can see this if we go over the page to 183. I won't take you through it all, but picking it up at G, where it's said by a prospective bidder that proposed or contemplated arrangements have been abandoned and new arrangements are proposed or contemplated, it will always be a question of fact and degree whether this is correct, or whether the so-called new arrangements are merely an amended form of the old arrangements, this is supremely a matter for the Commission. However, in defence of the conclusion which they reached on this occasion, it must be pointed out the concept of a merger under the 1973 Act, that's the Fair Trading Act, the provisions are materially the same still, is not related to the merging of corporations, but to the merging of enterprises, and enterprises means activities or part of the activities of a business. They therefore had to ask themselves whether the new proposal, which excluded specified whisky activities from the merger, and which in that form, admittedly, was neither in progress nor in contemplation at the time of the reference, and I stress in that form, was sufficiently different from the original proposal for a comprehensive merger of all the activities of Guinness and distillers, for it truly to be said that the original proposal, i.e. the arrangements in progress or contemplation at the time of the reference, had been abandoned and a new proposal had come into existence subsequently. And the court finds that the chairman had not misdirected himself, and just hiving off the whiskies activity, which was what the deal structure did, meant you had a different situation, and because you weren't pursuing the full acquisition, including the whisky activities, the RMS had been abandoned. Now, to the neutral observer, you might say, well, that feels a bit funny in terms of language. That is the statutory scheme. It is not fanciful, therefore, to think of a situation here, in this case, where the proposal is some sort of modification of arrangements that mean we are not dealing with the elements of the Activision business which give rise to the concerns the CMA has. Noting, of course, that those concerns do not relate to consoles and PCs because, of course, all of that theory of harm 1 material was dropped. And I'm just going to refer the tribunal, if you have the notice of application available, sir.
Now, where will I find that? It's not in the bundles.
Do we have a copy of it? I'm sorry, I don't know whether it's...
Well, make the point, Mr. Beard.
I will make the point, but I'm not going to read out the passage. In 451, there is reference to the sorts of matters that Microsoft might have raised had it been given the opportunity. I'm very grateful to the Activision team.
Please ignore the side marking.
Yeah, please ignore the side marking. It's merely a line down the side. There are no special messages attached. Well, not that I can read. I mean, sorry.
Yes, apart from say we'd like an adjournment, I don't think he says anything at all.
Yeah, there are no direct threats there, so no.
Yes, I see.
I'm not going to discuss it further. You see the position, sir.
Thank you. I'll have it back.
So the reason I advert to that is I'm not trespassing on anything to do with without prejudice, but you can see what the sorts of considerations would be there without my trespassing on anything to do without prejudice discussions. We can't provide you with evidence in relation to that. We can give you confidence that we think this will work, and we do so having had discussions. We don't need to discuss the precise modalities. We've set out the ways in which those could work. We've explained, I hope, why speed is of the essence, and we want to avoid uncertainty. We recognise the difficulties that the CMA has expressed about being able to engage fully in these discussions at the same time as engaging in litigation. And we also recognise the point that Mr. Bailey makes about the realities of hearing and that they can distract and undermine negotiations. But our key point here is that we can get to a point of certainty far faster through the parties cooperating in these discussions when the CMA, as Mr. Bailey has explained, does have real flexibility to deal with these processes and can deal with them speedily and can comply with the relevant requirements of consultation, that in those circumstances we will, we believe, be able to resolve these matters pursuing precisely the public interest that this tribunal recognised and for which we are inordinately grateful in the way that it approached the first and second CMC and the previous adjournment application. The world has moved on. We have moved on with it in supporting the CMA's application today. It is for good reason, and we hope that assists the tribunal in reaching its conclusion in relation to these matters. Unless I can assist further, and there are any particular further issues we can assist with.
I've raised my concerns. I'm very grateful to you, Mr. Beard. I've got no further points for you. Lord Grabbanner.
Well, my Lord, at the risk of repeating what you said, I can be incredibly brief. 2 points. One, it is critical that your Lordship has fully digested paragraph 451. Secondly, and all sides have been saying this, that speed is of absolutely critical importance. This is a massive transaction. The context is massively price sensitive.
I'm not unaware of the fact that today is the 17th and tomorrow is the 18th.
Well, my Lord, precisely. The regulator must, of course, and we're confident will act fairly and in accordance with the rules, but there's no reason why this can't be dealt with quickly, consistently with that statutory duty. And if I may respectfully say so, though of course your Lordship is well aware of it, the market and the parties need speed and certainty of outcome. Well, Lord, again, if I can assist you further, I'm happy to do so. That's all I wanted to say.
No, I'm very grateful to you, Lord Governor. Mr. Daly, you have the last word. It's your application. I don't know if you've got anything to reply, since you are all in violent agreement, but if there's anything you wish to say, you will have the last word.
I think I have set out the CMA's position. It's obviously a joint application made by both sides, and so in one sense, given that in every other respect in this litigation it is adversarial, it speaks volumes in my submission that we are urging this as the appropriate course as an alternative to the litigation.
Thank you, very grateful. Do we need another transcriber break? I don't know. We've been going for quite some time. Well, my intention is to give a very short conditional ruling setting out why I will be giving an adjournment, just to cut to the chase. I think it is appropriate that I do so this evening because it is going to be a conditional adjournment on evidence coming certainly from the CMA, which I will need to set out in some detail as to what I will need to have from someone, I think probably Mr. Previtt in the CMA, regarding what is envisaged by the CMA, but I will set that out in greater detail in my provisional judgment. I will therefore rise until 6 o'clock, just to give someone 8 minutes break, and we'll resume then.
En breve, cuando venga, el juez va a dar su vaina. Va a dar cuando venga el juez va a dar su vaina, va a dar su ¿cómo que se llama esto? ¿Cómo se llama esta vaina? Su decisión. El juez cuando venga va a dar su decisión. El juez cuando venga va a dar su decisión. Cuando vengamos, el juez va a dar su... ¿Quién está ganando? Si Mike, oiga, mi gente, escuchen, es el juez versus Microsoft y FTC y CMA. Aquí gana CMA, Microsoft junta o el juez. ¿Estás entendiendo? La CMA y Microsoft están del mismo lado. Gracias. El Pipo, 20 membresía, la creta. ¡Oh, Dios mío! 20 membresía. El diablo. Acá que suene, loco, que se funda. El diablo. He-Man, que nada más le regala locón. ¡Oh, Dios mío! He-Man, el diablo. ¡Oh, millones está 20 membresía, el diablo! La multicuenta de locón, no. El Pipo, el diablo, ¿a quién le salió? A todo el mundo, la creta, menos los haters. El diablo. El diablo. Diablo, la gente, cuánta membresía, la ñema. Hay que mutearla, gracias, Jima, hay que mutearla porque si la dejamos no vamos a hablar. Y loco, ¿dónde está? Mira lo que pasa, el juez, gracias, He-Man, se te quiere, 20 membresía, primera vez que regalan 20 membresía, la creta. Mira lo que pasa, el Pipo, 20 más, el Pipo, la multicuenta de loco. Dios mío, He-Man. Oh, es que puede que sea un ching. Pues no va a dejar que yo hable. Oh, Dios mío. Oh, Dios mío, no va a dejar que yo hable. Te mandó a para que no me deje hablar. El diablo, 40 membresías. El diablo millonario, loco.
¿Qué pasó?
40 membresías me regalaron ahora mismo Hitman, tu multicuenta. Eso no retuvimos. Oye.
Dime.
Gracias por la membresía, loco. El juez va a ver su decisión ahora cuando vengan. Están en break. Mira lo que pasa. El juez quiere anular, pero Microsoft y la CMA no quiere que anule. Gracias, denle gracias a He-Man ahí, Denle gracias a He-Man, 40 membresías, el diablo, la multicuenta de locón. Denle gracias, 40 miembros nuevos, la creta. No, a veces le toca a la misma gente que son miembros, ¿no? No le toca a la misma gente, loco. El Pipo He-Man. Papá, habla Huyi, ¿qué?
No, dime, ¿qué pasó? Entonces que ya va el veredicto.
La decisión. Pero esta vaina está loca. ¿Qué es lo que están buscando esta gente? Porque uno le da una vaina, a veces después otra vaina.
Ya vamos a ver lo que dice. Y va a anular.
O sea que no, si el juez no anula, ¿qué va a pasar? ¿Se va a entender?
No, ellos tienen, parece un acuerdo. Microsoft va a cerrar, ellos no van a hacer nada.
Yo voy a cerrar.
Porque Microsoft la está defendiendo. Si Microsoft sabe, porque el juez ya sabe que ellos van a cerrar hoy. Si Microsoft sabe que la CMA le va a poner una multa o algo, ellos se van a favor del juez. Pero como yo lo van a dejar cerrar, lo que la CMA quiere es limpiarse, lo que Microsoft la está ayudando.
Y el juez la quiere humillar para que vea, la quiere desbaratar.
Sí, la quiere desbaratar, el juez la quiere desbaratar.
He-Man, te amamos, He-Man, 40. Y lea lo membresía, la ñema. Si el juez no anula, aunque siga la apelación nublado, porque eso no impide que Microsoft cierre, loco el diablo.
No, es que ellos no van a hacer nada, ellos lo van a dejar cerrar. Ellos lo que quieren
La apelación continúa, pero si Microsoft cierra.
Oye, se ve.
10 membresía más. Gracias, Imán, el diablo.
Se ve.
¿Qué?
Se ve que ellos están ayudando a la CMA.
Sí, eso lo está diciendo todo el mundo.
Y que la CMA se arrodilló. Se ve que tú viendo el juicio, tú estás notando que la que está ayudando a la CMA
es Microsoft, sí.
Crazy, quien le hizo goló, quien se la sopló fue
la CMA.
El acercamiento se ve que fue de la CMA.
Sí, porque si Sony se rindió, si Sony tuvo que firmar, si la CFT se perdió a lo grande, entonces ellos no quieren verse así, ellos quieren verse, tú sabes. Entonces parece que ellos hicieron un acuerdo con Microsoft, oye, trata de ayudar, vamos, para quedar bien, que yo qué, y te voy a dejar, pero el problema es que si Microsoft no cierra y extiende, loco, que de barato la serie S, loco, a batazo, si no cierre. Agarro la serie S y la de barato, loco, si no cierran, loco, hoy. O sea, hoy o mañana. No está mañana, hasta las 6, ¿no, Edic?
12 de California. O de,
Gracias, He-Man, por esas 50 membresías. He-Man está rico, la creta. Denle las gracias a He-Man ahí, ya saben, sóplensela.
Te falta los vainas, loco, los iconos.
Tú no me lo has mandado, los iconos, ratón.
No, que tú no puedes tener lo mismo que ellos, tienen que tener hacer lo tuyo.
Pero enséñame a hacerlo. O mándame lo que tú no uses, loco. Y después yo me enseño. 50 membresías, la creta.
Lo tuyo de tu esencia, loco, tu canal, cosas
que yo no canal, loco. Si tú me robas toda la frase, toda la vaina tuya es mía, robar.
Como que yo no uso nada de lo tuyo, loco.
Que yo esté happy, este tipo sí jode, loco. Esta gente viene a joder, loco. Me tienen harto esta gente, loco. Este viene y dice que el juez no va a cerrar, que no va a cerrar, que no. Yo, si Microsoft no cierra hoy. Pues tú estás seguro que va a cerrar. Y yo controlo a Microsoft. Hijo de tu maldita matemango. Porque si yo digo, Microsoft va a cerrar y Microsoft no cierra. Loco, esta gente sí jode, Dios mío, la creta, loco. Vienen en un viaje multicuenta, joder, loco. Una envidia que le tienen a uno, loco. La creta, loco. Una envidia, loco, que le tienen a uno.
Ahorita lo jalan a Hickman, lo llevan para allá para que le donen para allá, tú sabes cómo es.
Dije, pues tú no te vas seguro. Y si Microsoft no extiende, aunque yo esté seguro, yo obligo a Microsoft, yo no obligo a Microsoft. Diablo, loco, me tienen harto esta gente. Para mí tiene que cerrar hoy y va a cerrar. Pero si no cierra, me voy a quillar. Lo mismo que dije hace par de días. Eso es lo que estoy diciendo. Pero tú no te ves seguro. Una multicuenta que llegó de la nada a tirar mierda, loco. Una envidia, loco. Que te vayan a mamársele el duofe para allá. O a iPhone para allá. O a jugar a juegos, qué sé yo. Loco, una envidia que tienen a uno, loco. La creta, loco. Qué envidia, loco. Como que creen que como se queda uno mal obligado, como, pero tú dijiste, sí, yo lo dije y qué. Pero eso asegura que Microsoft va a cerrar porque yo lo diga. La madre. Ese tipo no tenía membresía, ¿no? ¿No tiene membresía ese tipo? Tienes alto, loco. Yo estoy seguro que me voy a sacar el otro y los juegos y nunca me lo saco porque yo estoy seguro que me lo voy a sacar. Loco, el diablo.
Porque ellos te desenfocan.
Están a 93 acciones de Activision, sí. Va. ¿Cómo van a ver mucha gente si un viaje, los mismos agentes de habla hispana y latino le tienen una envidia, ¿no? Porque ellos ven a otros extranjeros superiores. Por eso es lo que pasa. Y como tú no tienes pelo en la lengua y dices la verdad, mucha gente no te soporta. Eso es lo que pasa. Ellos se lo maman a otra gente. Joder, tío. Dice joder, tío, y ya se lo mama. Pedí apoyar.
A long afternoon of complex submissions, and it will, I'm sure, require a detailed revision when I have its transcript before me, and that revision will, if it needs to be extensive, be extensive. Secondly, it is conditional because there are certain evidential requirements which will have to be met before I am finally prepared to grant the adjournment that I'm conditionally going to grant this evening. And that evidence will have to be containing of certain factors which I'm going to list in the course of this ruling. And the reason I am giving this ruling this evening rather than reserving until a short period tomorrow is so that the CMA know exactly what they need to produce and can get on with producing it. It is obviously clear that this is an urgent matter which requires an urgent, if conditional, outcome, and that is what I hope to provide this evening. I have before me a joint application made by the CMA and Microsoft to adjourn the Section 120 application that is made by Microsoft, and that is due to be heard on Friday, the 28th of July, and for the 5 days thereafter. This application was listed for the 28th of July over the CMA's significant opposition, and there has already been one application to adjourn, as well as resistance to the original date. Just to mention the application to adjourn, that application was made by the CMA on the 28th of June 2023, was opposed by Microsoft, and was refused by the Tribunal by a judgment delivered on the 29th of June 2023 under neutral citation 2023 Cat 43. Second applications to adjourn are rare, but I appreciate that the grounds for this application, and indeed Microsoft's stance in relation to it, are different. It is important to note that whereas the first application to adjourn was made by the CMA in opposition to the Microsoft and Activision stance, the present application is moved effectively by all parties before me. As I say, it is a joint application by the CMA and by Microsoft. It is also supported by the intervener, Activision. The question is whether a hearing that has been fixed and that all agree was fixed because of its urgency can and should be adjourned. All of the parties are agreed that this is a judicial decision that must be justified. That is true for any adjournment, but it is particularly true in this case. I had some concern when I read the written submissions of the CMA and Microsoft that there was an underlying assumption that the tribunal was not concerned with the reasons for the adjournment and should simply grant it because the parties were in agreement that it should be granted. I made clear in the course of submissions, and I think all parties ultimately agreed with this, that this is not the right test. Clearly, the agreement of the parties is a relevant and significant factor, particularly when they are otherwise in opposition in regard to the Section 120 application that Microsoft has moved. But it is now, I think, common ground that the reasons for the adjournment must outweigh the public interest on which the tribunal has already ruled twice of hearings Microsoft's application as listed. The decision to adjourn has got to be a multifactorial assessment. In this case, however, of particular importance is the legal or juridical basis for the application. Various judicial bases have been advanced by the parties. At last count, it was as many as 5. And it seems to me that it is very important, if one is seeking to adjourn an urgent application, that one is absolutely clear. We'll then come back to the other factors, much more straightforward factors, which in my judgment, very clearly militate in favour of an adjournment, and I will be able to deal with those extremely briskly. So I will begin then with the question of juridical basis, and I put forward to the parties, and the parties were accepting of a four-stage approach to the assessment of the juridical basis for an adjournment application. And although I put this to the parties in the course of an opening, I will reread them into this judgment because it seems to me they are critical to the approach in this case. So first, the tribunal must be satisfied that the course proposed by the CMA, that is to say, discussions with Microsoft necessitating an adjournment of the Section 120 application, have a proper legal foundation. Of course, that does not mean that I have to be satisfied as a matter of law that that juridical foundation actually exists. But I do need to satisfy myself that there is some proper juridical basis or jurisdictional basis for what the CMA is doing or proposing to do, which causes the application for this adjournment. So I need to know why I do not need to rule on lawfulness. Secondly, as regards each jurisdiction,
Se paró, ¿qué pasó? ¿Se paró? ¡Ey! Se paró el directo, lo tumbaron el directo. Lo tumbaron, porque pues, se paró el directo, ¿qué pasó? El momento muy importante, hijo tu maldita. El momento muy importante se frisa, loco. Se cayó el directo. Loco, se cayó en el momento muy importante el juicio, loco. No, se cayó, loco. ¡Eh, loco, fraude! ¡Fraude! Se cayó en el momento muy importante, loco, fraude. Loco, se cayó en el momento muy importante. Lo tumbaron en directo esta gente, loco. Lo tumbaron en directo. Oh, a ver.
In favour of an adjournment, and I will be able to deal with those extremely briskly. So I will begin then with the question of juridical basis, and I put forward to the parties, and the parties were accepting of a four-stage approach to the assessment of the juridical basis for an adjournment application. And although I put this to the parties in the course of an opening, I will reread them into this judgment because it seems to me they are critical to the approach in this case. So first, the tribunal must be satisfied that the course proposed by the CMA, that is to say, discussions with Microsoft necessitating an adjournment of the Section 120 application, have a proper legal foundation. Of course, that does not mean that I have to be satisfied as a matter of law that that juridical foundation actually exists. But I do need to satisfy myself that there is some proper juridical basis or jurisdictional basis for what the CMA is doing or proposing to do, which causes the application for this adjournment. So I need to know why I do not need to rule on lawfulness. Secondly, as regards each jurisdictional ground advanced as a justification for the CMA's conduct and as a reason for seeking the adjournment, I must be satisfied that, at least arguably, there's a sufficient factual basis for exercising the jurisdiction. If certain requirements exist in the various jurisdictional bases which lead to the adjournment application, if they exist, then I must, on an arguable basis, be satisfied that they do, in fact, exist. Thirdly, and drawing together these two requirements and assuming they are met, I must be satisfied that the CMA is indeed seeking an adjournment for these reasons. I stress that it is the CMA's consideration here, not Microsoft's, that is critical. Microsoft are a private company who are interested, quite rightly, in getting this transaction over the line. They are not tasked with the protection of the public interest that the merger jurisdiction exists to serve. That is the responsibility of the CMA, and in this case, the CMA alone. I fully appreciate that Microsoft and Activision as intervener have an interest and want to have this adjournment because it serves their interests, and that is something that I must pay due and proper regard to. But when it comes to a question of an adjournment in the public interest, it is the CMA that I must listen to first and foremost. And therefore, it is from the CMA that I require satisfaction that the course they are proposing, supported by Microsoft, is a proper one. It seems to me that I must be satisfied on this not merely as a matter of theory that the jurisdiction might exist. I must be satisfied that the CMA has decided to go down and will go down this particular jurisdictional route. An application to adjourn cannot, in my judgment, be hypothetical. It must be grounded in reality. Fourthly, and really by way of a negative cross-check, I must be satisfied that there is no obvious problem in the CMA's proposed course of action that would expose the CMA to an inevitable and successful judicial review if it pursued the course it is suggesting, whatever that might be. That is not, I would suggest, a very onerous obligation. If a judicial review of these procedures that the CMA wishes to embark upon comes later down the line, then that is a matter for a court later down the line. What matters is that there's nothing clear and obvious that can be dealt with, which is a problem with the course that is being articulated, such that it needs and should be addressed. So that is the four-stage approach that I'm minded to adopt as regards the fundamental question of whether there is a basis for properly adjourning. I therefore come to the various legal bases that have been articulated by the parties in order to suggest that an adjournment is justified, is required indeed, to achieve the ends that all of the parties are urging they want to follow and for which an adjournment is necessary. These jurisdictional bases were advanced by the parties as alternatives, but I actually consider that in most parts they are not alternatives but need to be read together. I begin with the first non-alternative, a new phase 1 investigation by the CMA, which is set out in the CMA's written submissions at paragraphs 10 and following. What this jurisdictional base suggests is that under section 33 of the Enterprise Act, a new reference would be made if the Microsoft proposals are put to the CMA in respect of what would be a new relevant merger situation. Section 33(1) of the Enterprise Act 2002, as amended, provides that the CMA shall, subject to subsections 2 and 3, make a reference to its chair for the constitution of a group under Schedule 4 to the Enterprise and Regulatory Reform Act 2013, if the CMA believes that it is or may be the case that A, arrangements are in progress or in contemplation which, if carried into effect, will result in the creation of a relevant merger situation, and B, the creation of that situation may be expected to result in a substantial lessening of competition within any market or markets in the United Kingdom for goods or services. The problem with this approach, section 33 reference, is that there has already been such a reference. That is clear from the decision that is subject to Microsoft's section 120 application. If I refer to the CMA's final report, which I shall refer to as the FR, and we look at paragraph 1.1 of the reference, this states as follows. On 15th September 2022, the Competition and Markets Authority, CMA, in exercise of its duty under Section 33(1) of the Enterprise Act 2002, the Act, referred the anticipated acquisition by Microsoft Corporation, Microsoft, of Activision Blizzard Inc., Activision, the merger, for further investigation and report by a group of CMA panel members, the inquiry group. Microsoft and Activision are referred to collectively as the parties, or for statements referring to the future, the merged entity. So there has already been a reference. It has resulted in the FR. What is being contemplated by the parties is that the Microsoft and Activision entities will put forward a new proposal that is so different that it amounts to a new relevant merger situation under Section 33, distinct from the old relevant merger situation that is dealt with in the FR. Once one sees the situation in this light, it is quite clear that Section 33 carries the adjournment application no further. It is, of course, a matter for the CMA whether it regards anything coming out of Microsoft or Activision as a new RMS. This tribunal can say nothing about that. In fact, the CMA can say nothing about that because as yet, nothing has emerged from Microsoft to suggest that there is a new RMS. There may be, but as both Mr. Beard for Microsoft and Lord Grabbanner for Activision emphasised, they are quite rightly constrained in what they can say by both considerations of confidentiality, without prejudice communications, and the fact that a situation regarding this merger is developing almost hourly, certainly daily. So at the moment, one can see as a matter of theoretical possibility that there might be a second reference under Section 33, but it doesn't assist in dealing with the outcome of the original reference, which is the result in the final report that I've referred to. And it is that which is the issue that we need to consider. How does the CMA justify the delay to the resolution of a challenge to that FR? And all I will say at this stage is that Section 33 does not provide the answer. It may provide the mechanism for a further investigation by the CMA, but that is nothing to the point for today. However, viewing the Section 33 ability to investigate a new RMS in conjunction with the adopting of a final order that is implementing or perhaps not implementing the FR is the next matter that I turn to, and is to my mind the critical aspect of this application. In that regard, it is important to turn up Section 41 of the Enterprise Act 2002 as amended. 41(3) of that section provides as follows. The decision of the CMA under subsection 2, which is taking such action necessary to mitigate an SLC, a substantial lessening of competition, shall be consistent with its decisions as included in its report by virtue of section 35(3, or as the case may be 36(2), unless there's been a material change of circumstances since the preparation of the report, or the CMA otherwise has a special reason for deciding differently. So, to summarise or paraphrase, the point of section 41(3) is to make clear that rather like a judgment of a court which is implemented into an order, making clear what the outcome of that judgment is, so too there's a relationship between the final report in this case and what I will call the final order under section 41. Generally speaking, and entirely unsurprisingly, the final order ought to be reflective of and implementing of the final report. That is what the opening words of section 41(3) provide. However, as all the parties stressed, there is a carve-out. The final order does not have to be consistent with the final report where there has been a material change of circumstances or the CMA otherwise has a special reason for deciding differently. Now, in this case, it has been said by all parties, but in particular by the CMA, that these carve-outs of material change of circumstance or special reason exist in this case. It is obviously the case that I cannot second guess what the CMA is telling me about this. The question of whether there is a material change of circumstance or special reason is a decision of the CMA. It is for the CMA to decide these matters, and if the decision is right or wrong, that is a matter for the CMA and for subsequent and separate judicial review proceedings. For my purposes today, I simply need to be satisfied that the factual requirements underlying the requirements under section 41(3) are met in this case. It seems to me, though, looking at section 41(3), the first stage of my four-stage process is met. I can see the route by which the CMA will seek to have a form of order that is different from the underlying decision, which requires consideration by the CMA over the coming weeks or 2 months, and which renders the consideration of the final report effectively redundant. Why spend 6 days of expensive litigation considering a final report when the final order is not in fact going to reflect that matter? Now, naturally, I cannot say what the ultimate outcome will be, nor can the CMA. What I can do, however, is satisfy myself that the touchstones of this particular jurisdiction are met, and that is a question for the second stage, which I will come to in a moment. However, if I can very briefly deal with the other jurisdictional mechanisms that are articulated by the parties and consider them further, the next one was the notion of a cancellation of a reference because the merger has been abandoned, and that would be based on section 37(1) of the Enterprise Act 2002 as amended. Section 37(1) provides that the CMA shall cancel a reference under section 33 if it considers that the proposal to make arrangements of the kind mentioned in the reference has been abandoned. Now, this would be a cancellation of what I call the old reference, the one that generated the report, and quite clearly the jurisdiction does exist, but it is at this stage of matters in the realms of the fanciful. No one has suggested, still less provided me with any evidence at all, that there is any kind of abandonment of the proposal to make the arrangements that constituted the relevant merger situation under section 33 that triggered the final report. And it seems to me that this is a jurisdiction that I really do not need to trouble myself with anymore. Fourthly, there was a variation on the consent mechanism or variation of the final order, which is set out in the Microsoft skeleton at paragraph 16 following. This, as it seems to me, is a variant of the route that I've already considered under section 41(3) of a final order that is in some way in tension with the reasoning and outcome of a final report. And I will say, for that reason, no more than that. The fifth route is one that was not advanced by the CMA as a route to dealing with the adjournment question, which was a question of a quashing of the decision under section 125 of the Enterprise Act 2002 as amended. I will say no more about that because it was not pressed by the CMA. Indeed, it was opposed as a route to this adjournment conundrum by the CMA. I may say a few words about this at the conclusion of this ruling. So that concludes my review of the stage 1 jurisdictional question. The answer to the stage 1 question is that this is a section 41(3) case, and I therefore need to ask myself whether there exists the evidence which makes it a more than theoretical route, and instead is one that is grounded in reality. It seems to me that at this stage I need to conflate my second and third stages. The reason I must do so is because there is at the moment no evidence from the CMA to indicate that the requirements of section 41(3) are met. In other words, there's no articulation of why the CMA considers there to be a material change of circumstance or what other special reason the CMA might have for deciding differently. I was referred to the very helpful evidence of Ms. Radke, her second statement, where she says in conclusion, at paragraph 18 of her second statement, this, quote, "The CMA has carefully considered, as the competition authority to whom Parliament has entrusted decision-making in merger cases, whether the application is in the public interest. Having regard to all the matters set out above," I will return to those in a moment, "and based on my discussions within other senior officials at the CMA considers that it would be in the public interest to stay the proceedings to see whether there's a means by which the competition concerns set out in the FR can be adequately addressed without the delay and cost of litigation," end quote. These are obviously relevant matters to which I'm going to return, but they do not address the two alternative matters that, in my judgment, do need to be addressed by the CMA in section 41(3), which is what is the material change in circumstance on which the CMA relies, and or what is the otherwise special reason for deciding differently. And it seems to me that without evidence dealing with these 2 points, I cannot make an order to adjourn. I made very clear at the beginning of this hearing that I was not going to say an absolute no, and I've made clear at the beginning of this judgment that indeed my answer is yes, but it is a conditional yes. I'm going to require evidence, I think, from Mr. Previtt of the CMA as the responsible legal officer in charge of legal matters at the CMA, a statement that is dealing with the following matters. First of all, by way of general background as to what this statement can helpfully address, I was referred to a very helpful passage in the Crown Against the Monopolies and Mergers Commission and another ex parte Argyll Group plc, reported at 1986-2 Order R 257. At page 266, beginning at letter C, where Lord Justice Dillon set out what ought to be informing public bodies and good public administration. I will not read this passage into the record. It begins at little letter C and ends at little letter H, but it seems to me that this is an excellent touchstone for what a witness statement ought to contain. More specifically, however, it seems to me that the evidence from Mr. Previtt needs to say the following. First of all, it needs to explain, and explain with granularity, the carve-outs within section 41.3 that the CMA relies upon. There needs to be an explanation of what is the material change of circumstance, if there is one, and/or it needs to explain what is the special reason, if there is one. But one or other of those two grounds must be met, and it must be met in evidence. Secondly, it seems to me that there is an important need for a clear statement of the consultation process that the CMA is going to embark upon from here on in. I say this not because I question that the CMA will not embark upon a proper consultation process. I'm sure that it will, but I have well in mind that this is a process that is principally involving Microsoft and the CMA. Activision clearly are involved, but there are third parties in any merger situation who need to be heard. And one of the fragilities of the section 41.3 process is that there is only a form of mandatory consultation when once a final order in draft has been approved. There is therefore going to be a gap between the point of consultation and the discussions between the CMA and Microsoft, which will need very careful handling in terms of how third parties are engaged with. And it seems to me important that that is a matter that is dealt with in Mr. Previtt's statement, so that any third party will know, if they come to seek to challenge a final order in draft, precisely what has been going on. I was referred very helpfully in the authorities bundle to a flowchart at page 203. I'm not going to read that into the record, that would be rather difficult, but it sets out a process for the CMA's merge investigations and the principal stages. I'm not suggesting for a moment that this is the process that ought to be followed in this very particular case, but I do think that the CMA need to give some thought about how they are going to manage this process, and they need to articulate it so that everybody is clear as to how it will work. So that is the second area that needs to be dealt with in this particular statement. Thirdly and fourthly, I can deal with these more quickly, I'm going to require, as I indicated in argument, an explanation as to why the first adjournment application did not advert to this matter. I anticipate from what Mr. Bailey told me in submissions that this is a very straightforward thing to do, but it does seem to me that it is a matter that ought to be on the evidential record in addition to what was submitted to me by counsel. Fourthly, and equally easy to deal with, the parties are all agreed that what has occurred in the United States, by which I mean the FTC's failure to obtain an interim injunction from the US courts, that all are agreed is an irrelevant and immaterial matter to this consideration. And Mr. Bailey has said it is and was irrelevant to the CMA in this case. However, the timing is unfortunate because this application more or less coincided with the refusal of injunctive relief in the United States. And it seems to me that it is important to close out the potentiality of future challenge that we have on the record, not only that it is agreed by the lawyers that this is immaterial, but that it has been immaterial to the CMA's consideration in the decision-making process so far and for the future. So that is the last area of evidence on which I would want to hear in a statement from Mr. Previtt. I consider that the CMA would be assisted, and this is simply an indicator of what might be desirable to ensure that this application goes forward untroubled. It would assist if there could be a form of backward-looking statement from Microsoft explaining the significance of the Sony transaction that has been reported in the press over the last weekend. I want to stress that I do not want, and indeed Microsoft would not do this, I do not want this statement to trespass into any confidential, still less any privileged materials, but it does seem to me that if one can articulate what has caused the position to change in this deal being concluded between Microsoft and Sony, that will make Mr. Previtt's job of identifying a material change of circumstance that much easier. So it is not a precondition of my granting the order, but it is something which I consider the parties should, since they want an adjournment, consider quite carefully, because in my judgment it will make the decision that I am going to make that much more robust. So I am satisfied that the four-stage process that I've articulated is met, and that there is a juridical basis properly to grant the adjournment. I can then move much more swiftly to the other factors that most clearly indicate that an adjournment is required and desirable in this case. First of all, as both Mr. Beard and Lord Grabbanner for Microsoft and Activision made clear, this is a case where all of the parties, well advised, are moving in the same direction. All are saying unequivocally that an adjournment is the way in which one can both protect the public interest most efficiently, deal with subsequent events to the final decision most effectively, and ensure that one has an outcome that properly reflects the public interest as it stands and not as it stood in the past. I hesitate to say that April is the dim and distant past, but it does rather seem that way in this case. Secondly, there is the fact that there is enormous urgency behind this matter. It is well known from both the documents in this case and more widely in the press that there is a deadline between Activision and Microsoft which triggers certain consequences tomorrow, the 18th of July. I've no doubt that Microsoft and Activision are being sensible about this. It's a matter for them, of course, but they are entitled to an assurance that the matters, the subject of the application and the CMA's consideration are being handled as expeditiously as possible. And it does seem to me that in this regard, the submissions of Microsoft and the submissions of Activision are entitled to particular weight. And when one adds to that the CMA's concurrence that in its view the public interest is best served by an adjournment, that is a very powerful factor in favour of adjournment. Finally, there is the question of cost and the related question of CMA resource to consider. It is obvious that there is no point in incurring the costs of a judicial review running across at least 4 and possibly 6 days in the near future if that is going to serve no purpose. If, as the CMA has submitted, there is a material change or special reason for making a final order that is different to the final decision, then there really is no point in hearing at this stage a challenge to the final decision. Over and above this question of cost, there's the question of CMA resource. The fact is the CMA has entirely understandably said that they can do one thing or the other thing, but they can't do both. They can't fight a very heavy JR whilst at one and the same time with effectively the same team having to deal with a new or effectively a new transaction emanating out of Microsoft. So it seems to me that this is a final and very cogent reason for granting the adjournment. And so that is what I'm minded to do. So subject to any revisions to this ruling and subject to receiving in proper form evidence from the CMA, that is the order that I'm minded to make.
Yeah, the same bit, please.
It may be the same point.
It's a point of clarification relating to the evidence that the tribunal requires.
Yes.
Mr. Previtt.
So, as I understood you to be saying that you would expect the evidence to explain with granularity the carve-outs in section 41.3 and on which the CMA relies, and you referred to the material change of circumstance and or the special reason.
Yes.
The point of clarification is that, as I understand it, at the moment it is Microsoft. It is Microsoft that is relying on there being material changes of circumstance and special reasons. That has been put forward to the group. The group has extended the deadline to then consider those representations. And the CMA can obviously set out what those matters are. They are not as yet matters upon which the CMA relies, and for good reason. And that is because the CMA group is considering them. We can, of course, set out the process from here to the end of August and how we would involve third parties. But it's just to sort of clarify that at the moment, as I'm sure you'll understand, the group has to retain an open mind as to where it will ultimately conclude in relation to those matters. It may be that Mr. Beard was going to raise the same point, but it's just about clarifying what Mr. Brevet should be saying.
Well, let's be clear about that. I'll deal with Mr. Beard's point separately. Of course, I understand that the CMA needs to keep an open mind, but section 41.3 is triggered by the CMA's consideration. So what I'm expecting is not an answer, because that would be entirely wrong. That would be to prejudge matters. What I am expecting, however, is an explanation with granularity as to why the CMA considers there is either a change of material change of circumstance or a special reason that justifies the making of this application. In other words, I'm not expecting a finality of outcome. What I am expecting is an ability to tick the box to say, I understand what the CMA are doing. Here's why we want to pause. We think that there is a necessity to consider either a material change of circumstance or special reason. This is why. So I hope that's clear. It's from the CMA's point of view.
So my instructions are that the CMA wouldn't be in a position to say now that there is a material change in circumstance or special reason. But as I understood you, sir, what you were saying was the CMA has embarked on this process under section 41.3, and that what you would like the CMA to set out is why it considers that jurisdiction is engaged. And yes, so that is my understanding. I understand.
I mean, this is why the judgment will, I'm sure, require revision. But you're absolutely right. I don't want, it would be wrong of me to ask, and I'm quite sure the CMA would not give it to me for entirely right reasons, an outcome here saying, yes, we can make a final order that is different to the final report for these reasons. That would be to put the cart before the horse. But what I need to be satisfied on is that I have got the evidential basis for saying Rule 41.3 is arguably engaged. We're at the level of grounding it in reality, not saying that it is the case, but saying that it is prima facie the case. That is the detail that I require.
I'm grateful.
Very grateful for your raising it, Mr. Bailey. Mr. Beard.
A couple of things. First, just in relation to that, just so the tribunal's aware, because of the recency of the Sony agreement, the CMA doesn't actually have a representation on MCC in relation to that. We will, of course, provide that in outline quickly so that it can be available to them. And we will also provide the witness statement that you've indicated, albeit it will be brief. But the CMA equally has to understand that in order for us to do this quickly, it may be less full initially as a representation than otherwise, but we will provide that material so that we don't hinder their provision of evidence.
Well, that's very helpful, Mr. Beard. And again, what I'm not looking for is the answer.
No.
What I'm looking for is the material that feeds into the, in other words, what I'm doing is I'm trying to lance the chicken and egg problem by identifying what comes first. And to the extent that Microsoft feel that they can provide an evidential basis for what they already know,
yes,
that would be of assistance.
Yes, we'll
both
do
to the
our
court
best.
and
And
You'll do your best.
It will be a compromise between speed and content length and detail, but we will, conscious of the timing issue, we will do that. Can I just, the clarification I wanted to sort out was slightly different. Obviously, in the judgment you've just given, you identify section 33 and the possibility of an alternative RMS and say, well, I don't have the detail here. You refer to Argyll in the context of the good administration paragraphs, but we do not take it, and I don't think it was the tribunal's remote intention to suggest that using section 33 and section 37 are matters that the parties and the CMA shouldn't be considering or anything of that sort, and that whilst you're looking for the juridical basis for this adjournment application, what goes on in relation to matters such as new RMS and so on are entirely for the parties.
Again, I will look at what I said. I had hoped I'd made that clear, but I
just wanted to confirm because I think that's probably important.
I will make that doubly clear. What I think I said, and what if I didn't say it, should have said, is that I don't regard the section 33 question as relevant to the adjournment matter, but what the parties choose to do and how they choose to use their time. In other words, if you want to have 2 torpedoes in the water, feel free. You can have that.
That was what I understood, and I just wanted to because I think that's important for because I understand that you want a juridical basis so that there's a proper basis for the adjournment, but you're not trying to in any way constrain how matters.
It would be entirely wrong for me to try and do so.
That was entirely what we understood. 2 very brief additional points.
Of course.
FTC materials they may be immaterial to the juridical basis for this adjournment. We'd like to stress we don't consider the FTC judgment and those matters generally immaterial, but we didn't understand that to be the case. And then there is one final tidying up matter, which is obviously you've granted a conditional adjournment. Let us assume for the moment that the conditions are met. In those circumstances, I would like to ask out of time for an adjournment of the service of our skeleton argument, which should have happened around 3 hours ago. Obviously, we didn't serve our skeleton argument. It wouldn't be appropriate in these circumstances. And I would ask the tribunal, just in those circumstances, to stay the pleadings and skeletons provisions in the order of the, I think it's dated the 22nd of June. But we can sort that out in due course. But if an indication could be given, that would be most helpful.
We'll so ordered, and it does actually raise a slightly more fundamental point, because I don't think it would be right for the parties to be burning the oil on 2 tracks from here on in.
Yes.
We've had nearly 5 hours of submissions on this point, and I've given the parties I hope appropriately hard time about why I was very troubled about this application. I would be very surprised if the parties didn't produce the material that I need to sign off on this order, and so I'm prepared to take the risk, if the parties are, of saying down tools.
I'm grateful.
And concentrate on what matters, which is to get the transaction over the line, rather than focus on what would, I'm sure, have been a very hard-fought judicial review. If, of course, the statement is no good, then I will throw my toys out of my pram and say, do it again. Yeah. But I would be entirely surprised if that were the case, because I've been pretty clear about what I need.
Yeah, I'm most grateful. And obviously, I made that application on a purely selfish basis, but obviously there are the other elements of the application that were made for formally a relisting of this hearing. Now, you have the submissions of Microsoft and other parties in relation to that. I don't know whether that is something that can be deferred until the conditional elements are effectively met, and we can deal with that subsequently, but I just put that as a marker. I don't want it lost in all of this.
No, I have that well in mind, and one of the concerns, but it wasn't really relevant to the question of adjournment, was how we would deal with a further application if and when it was required. We don't really have any idea of its shape. We don't have any idea of precisely when it needs to come up. So if the parties are happy, then that is something which I would be content to park for the moment.
The relisting and the reorganisation.
Exactly so. So that, I mean, at the moment the parties have a degree of real confidence about what they want.
Yes.
Of course, they must approach the tribunal, but there will have to be some diary juggling and quite possibly reconstituting of the tribunal in order to make it work.
I raised the point merely because in our submissions we'd looked at the period later in October where there was an indication that the tribunal might have availability, but I wasn't clear whether or not that was the case. If it were the case that the same constituted tribunal could be penciled in for that period, it might be something that is more sensibly done sooner rather than later, knowing that all members of the tribunal have extensive demands on their time.
Well, we will do that. We will look to see what can be done.
I would be most grateful.
That time frame. I'm bound to say, keeping track of where my diary sits at any one moment is almost as bad as this transaction. So I will. I'm
most grateful. And you quite understand, but just because things tend to get worse, not better.
They do. We will take it away and we will let the parties know what we have done on that front.
And then any indication from the tribunal, we can then work backwards from that. That tends to be the best way of dealing with it.
That's very helpful. Well, we will notify you in the course of tomorrow what's going on.
Thank you.
Well, I'm sorry, I don't want to delay matters.
Not at all.
I've got three very, very short points. One, might I respectfully suggest that Mr. Prevet be given a date by which he should be presenting his piece of paper. We shouldn't leave here without there being some agreement about that. Secondly, very trivially, but when your lordship made a reference to the Argyle case, and this was also in relation to the proposed content of Mr. Prevet's statement.
Yes.
You referred to the relevant passage at page 266 of the judgment, and you said it was Lord Justice Dillon. It's actually Sir John Donaldson.
Oh, I see.
Lord Justice Dillon starts a little bit further down the page.
Well,
but the magic words are Sir John Donaldson's.
It just goes to show you shouldn't look at the...
No, your eye caught the name, you quite rightly so, but it was the next judgment then.
I'm very grateful.
The only other point is this, that your lordship did say, and I think my attorney friend Mr. Bailey did agree, that in relation to the FTC exercise, that this was not something that they took into account when making this application or joining us in the application for adjournment, and that is completely correct. But I want to echo my attorney friend Mr. Beard's remarks, which is that we say that there are matters in the FTC judgment which are highly material. If, God forbid, we do have to have the substantive hearing. That's all I wanted to make sure we were clear about. But, my Lord, that's all I wanted to say.
Well, thank you very much. The correction to the judgment regarding Sir John Donaldson will be made. I think both you and Mr. Beard have made enough of a marker regarding the significance of the US proceedings, and all I will say is my reference to those proceedings in the context of this application was confined to this application. What the parties make of the American proceedings for the future, be it one way or the other, that is a matter for another day, and I'm certainly not closing anyone out from relying on it, nor am I saying that it's going to be the crown jewels in terms of evidential weight, but clearly both Microsoft and Activision will be entitled to refer to these matters if they are so advised. And indeed, the same goes for the CMA, but I suspect you would be making rather less reference. The date is the only question, Mr. Bailey, that you could insist on.
Pull out all the stops, as we have done throughout, and seek to prepare evidence. The time and date we're going to suggest was 5 o'clock tomorrow. If that could be done on a best endeavours basis, because of course we do need to digest what the tribunal has said, have to consult various colleagues within the CMA, the evidence has to be prepared, but we will strive and use our best efforts to prepare it by 5 o'clock tomorrow. And we can, of course, also undertake to update the tribunal at midday as to the progress that we're making, but we will absolutely do this in as short order as possible.
Well, Mr. Bailey, that's a very helpful indication. I think that even on a best endeavours basis, that is quite tight. I will see what Mr. Beard and Lord Grabbanner say, but it seems to me that given the business day has well and truly closed today, the idea that you should produce it in the course of essentially one working day is really not right. Is there any prejudice if we said it's to be produced, subject to a liberty to apply, but it's to be produced by midday on the Thursday?
We have no objection to that.
Lord Governor?
No objection, my lord.
Then I will gratefully adopt that.
I'm very grateful. Well, thank you all for your very helpful submissions. Is there anything more that we need to deal with tonight?
Not from the CMA, other than just to echo my learned friends in terms of our gratitude to the tribunal for moving so rapidly in dealing with this application.
Not at all. It's been a real pleasure.
Thank you.
Thank you. Thank you very much.
Se acabó esta vaina. No, mañana van a volver. No hubo nada. ¿Sabes? Captura. ¿Sabes? Locón, entra, Locón, entra. ¿Qué va a pasar? No hubo nada que mañana van a volver.
Al final, ¿qué? ¿Van a buscar?
No
Pero
sé.
ya la compra se cae mañana, es hoy ellos tienen que cerrar. Entonces, ¿qué van a hacer? ¿Van a tener que cerrar buscar una extensión para unos par de días? ¿O qué? ¿Una par de semanas?
Es que no sé, loco. Es que nadie entiende el juicio, ni los mismos gringos te entendían bien el juicio, porque el juez le quiere dar la razón a Microsoft y Microsoft dice no. El juez quiere anular.
Pero porque con este micrófono yo me escucho duro en tu canal, mi canal, y que se quejan que yo no me escucho duro.
No sé.
Maldita lo que era.
Es que no, es que lo de cerrar no lo decide porque.
No oye, maricón, aquí.
Es que si. Es que si Microsoft, si la CMA y Microsoft están conjuntas y Microsoft tiene que cerrar y decide cerrar, porque ella le va a impedir cerrar. Si ella le impide cerrar, porque ella monta del lado de Microsoft.
Él la defendió ahí, eso yo no sé, yo parece que la va a dejar cerrar, eso es lo que yo pienso. Ya van a tiene que cerrar hoy.
Porque yo me entiendo. Porque...
Pero Microsoft está ayudando a la CMA ya.
Sí.
Ya eso ya se ve ya están las dos como unidas. Y es lo importante.
Sí, pero que la extensión no la da el juez, la extensión la da el accionista de Activision, que es juez del diablo.
No, pero ellos van a tener que cerrar hoy, que no tiene lógica. ¿O qué? Tienen que cerrar hoy, ¿qué van a hacer?
Eso mismo es Microsoft que decide si cierra o no cierra, pero no es que mucha gente loco en RCT, en todo el mundo está confuso, loco, porque no entiendo por qué el juez le está dando las razones como, ok, yo puedo anularlo y Microsoft no lo anule. Por el punto de Microsoft va a cerrar. ¿A qué hora que se vence el contrato?
Hoy a las 12 de la noche.
Porque los accionistas no van a dar la extensión, supuestamente. Yo vi una vaina que dijeron que los accionistas que están inquietos y quieren salir de eso ya, los accionistas. Mañana a las 6 de la mañana. Hasta las 6 de la mañana.
Más de un mes.
Más de un mes, ¿qué?
Eso va a tomar 4 semanas o 6 semanas, más de un mes.
¿El qué?
Y que el K de nuevo evaluar, venir, buscar una opción.
Pero ya te depende que no cierre.
No, ya la compra está, la CMA no está en contra de Microsoft. Microsoft está a favor de la contra.
Lo que estamos desesperados somos nosotros que cierre.
Sí, ya, ellos ya tienen su vaina. Ahora, la pregunta de millón es, ¿cierran hoy o no cierran hoy?
No estamos hablando del juicio. El juicio puede ser 10 años. Si Microsoft va a cerrar o va a extender. Esa es la pregunta. Si Microsoft va a cerrar o va a extender.
El que sigue ilusionándose que la compra se va a caer, que ya eso está todo, esa compra está terminada, lo que pasa es que le están dando chance. Hoy se hubiese acabado, hoy si Microsoft se pone del lado del juez y ataca, hoy el juez dice, mira, yo declino. Pero Microsoft no va a ser tan idiota.
Florian dijo que cierra en 4 semanas. Él dijo el juicio en 4 semanas se termina, no que cierra, loco.
No, el juicio, te estoy diciendo
El
eso.
juicio, o sea, azul verde y koala, loco. Tú estás verde y koala, ¿por qué te vienes a decir vainas que no son, loco? Diablo.
Lo dije que yo dije, eso mismo. Que
O sea, verde y koala, que diga que Florian dijo que se cierre en 4 semanas. El juicio en 4 semanas, azul verde y koala.
No es juicio, es un juicio.
La vaina, esa la vaina que están haciendo eso, claro, como un juicio. La pregunta está, Microsoft va a cerrar hoy, porque si lo que
es que no debe haber juicio porque la CMA lo que está queriendo tiempo para yo evaluar y sí.
Entonces, pero el juez le preguntó ¿y cómo yo sé que tú le vas a dar sí? Y él dijo, porque él confía, entonces si confía, el juez le dijo, oh, ¿y por qué tú no permites que cierre? Y el abogado como que se tragó seco cuando el juez le dijo.
Loco, ellos tienen un convenio que no lo dijeron, hay un convenio entre ellos.
Sí,
Y
porque
puede
ellos
que el convenio
ellos no se lo
dejen
dijeron al juez.
cerrar.
Ellos no se lo dijeron al juez porque el juez le estaba preguntando.
Ellos tienen un convenio. Lo que Microsoft está haciendo es dándole el culo a la CMA. Pero, por lógica, ellos tienen que, no sé si van a cerrar.
Pero la pregunta está si Microsoft va a cerrar o no, loco. A mí no me importa nada de juicio, de que mañana, que pasado. Es si Microsoft va a extender o va a cerrar. Esa es mi inquietud. Si va a cerrar o extender. A mí que me importa, el juicio puede ser en 30.000 años, pero mientras la compra te cerra. Que confía en la FC. Florian dijo que confía en la CMA, en la ñema mía, pues confía yo. Tú estás loco. Que confía en la CMA. Yo confío. Si Microsoft cierra, yo confío en la CMA. Pero si Microsoft cierra, yo no confío en la CMA, tú estás loco.
Mira, el juez lo está haciendo bien. Oye, el juez lo que está haciendo es todo esto para ver si la CMA no venga ya a Microsoft.
Sí.
Entonces, eso es seguro que tiene Microsoft, porque se atreve la CMA. Microsoft está de buena fe, pero tiene el lado de quién, el gobierno, el juez. El juez está viendo de que ella vaya a hacer. Lo que tiene tiempo ahora, lo que le vaya a hacer, lo que sea, ella tiene hasta el 28 de agosto, Mientras ella está en juicio y probando, ya tiene que ir adelantando lo otro también. Y que para llegar a la negociación. Yo lo que te digo algo, yo no sé cuándo van a cerrar, pero si Microsoft no cierra hoy, olvídense de eso, olvídense de cierre de compra, que la compra se cierre cuando se tenga que cerrar. Al final, decisión de Microsoft, pero Microsoft tuvo la oportunidad de que el juez declinara esto hoy y ella no quiso apoyar a la CMA. Microsoft claramente viene con nuevas adquisiciones y parece que quiere tener el lado de la CMA, ganarse la voluntad de la CMA.
Sí, pero que la semana
al final,
si el juez anula, si el juez anula, tú no ves que el juez está hablando de la apelación o de la apelación, porque el juez tiene intención de anular y diciéndole como la CMA que como que sea es ridículo que apelen, Eso es lo que está diciendo el juez. Estaba diciendo el juez.
El problema es que Microsoft no respaldó el juez. El juez quería, pero si no tiene un respaldo de Microsoft, si Microsoft está con la CMA ahí, entonces. Nada más saben ellos el convenio que ellos tienen. Pero el convenio que ellos tienen claramente garantiza.
Ellos van a tener que pagar el cuarto si se cae la compra, que se paga los 3.000 millones.
Y hay que ver si cierran. Sabrá Microsoft lo que va a hacer. Hoy es su último día. Si ellos no tienen porque el juez decía que ellos van a cerrar como quiera, que van a cerrar como quiera, que van a cerrar como quiera. Para mí que en el convenio está que ellos pueden cerrar hoy. Porque no tiene lógica eso.
Es que eso es lo que yo digo. ¿Cómo la CMA y Microsoft están de acuerdo, pero la CMA no va a permitir que cierre? Eso es que la CMA no está de acuerdo. No, la CMA lo que le quiere clavar el cuchillo. Eso es lo que... ese es mi parte. Sí, pues ajá, pero entonces si Microsoft extiende y el juez le sale y la CMA le sale con una loquera,
Por eso está ahí. Y las acciones subiendo para arriba, loco. Subiendo y subiendo las acciones. Y todavía siguen.
Oye, todo el mundo en todos lados muchísima gente que no estaba entendiendo el juicio.
Yo
loco.
te digo la verdad, yo lo único que puedo entender es que Microsoft quiere quedar bien con la CMA
Sí,
para futuras adquisiciones. Ahora, Microsoft le salvó la vida a la CMA de hacer el ridículo mundial hoy que le declinaran su decisión de bloqueo, pero decidió apoyarla. Microsoft sabe lo que hace. Yo lo que entiendo es que hoy, todavía estamos ahora, y te digo algo, suelta eso de que si cierre o no cierre, Microsoft es la que sabe hacer su vaina ya. Cuando viene a ver, ni cierra hoy, busca su extensión. Ya lo que va a hacer es retrasar su cierre. Pero ya la compra está más segura que la seguridad.
No, es que yo no estoy dudando que se va a dar o no se va a dar. Yo estoy dudando del tiempo, luego que yo esperar
No,
que
va a tomar más tiempo,
meses,
va a tomar más tiempo.
porque Microsoft quiere mamárselo a la CMA.
No mamárselo, porque es lo que quiere, parece que sabe que viene más compra y no quiere tener la
Que compre el diablo, loco, no, porque tú siempre ustedes vienen con maldita compra el diablo, loco.
Loco, la única lógica, porque ella la podía
Y se juega nula. Y se juega nula. Tú sabes que puede apelar. Y la belleza va a largar más que el diablo cuando apele.
Por eso mismo, pues Microsoft hace lo que más le conviene. ¿Tú crees que Microsoft no está
Por
haciendo
eso
lo que más le conviene?
que por futura compra, después la apelación,
Pero quién
loco.
sabe, estoy diciendo. Apelación se retrasa más. Microsoft sabe lo que está haciendo, más que todo lo que estamos aquí. Microsoft sabe lo que está haciendo.
Porque di que no, por futura compra. Si el juez demostró que la CMA hizo el ridículo mundial, ¿por qué Microsoft tiene que temerle por otra compra?
No sé, pero tal vez eso mismo, tal vez no quería que se vaya eso. Ellos no quieren hacer PLC ni nada de eso ya. Y ya la CMA llegó a un acuerdo con ellos internos que nada más saben ellos, que nada más tienen ellos saben por qué están haciendo su vaina. Entonces ya lo de la compra está segurísima. ¿Qué es lo que pasa? Tomará tiempo, más tiempo, hasta que ellos van a cerrar con broche de oro, que no van a tener que hacer PLC ni nada, y van a tener su compra bien, por las reglas, sin pasarle por encima a la CMA. Ya eso lo decidió Microsoft. Eso estaba encima de la mesa. Ahora la pregunta de millón es, ¿van a tener que anunciar rápidamente la extensión, el juicio, el cosa hasta
a las
hoy?
6, a las 6 de la mañana, loco, yo te lo dije. Mañana a las 6 de la mañana.
No importa, pero que si no cierran como quiere, es hoy que tienen que cerrar. Tiene que verse hoy, qué es lo que van a hacer hoy, extensión o cierran. Lo que está la duda que yo tengo hoy es la siguiente.
Si cierran o extiende.
Si cierran o no. Ya después que la compra está mega segura, ya Sony firmó. Si Sony firmó por algo. Ahora, Microsoft sabe lo que está haciendo. La CMA denotó que se bajó los pantalones y Microsoft la está ayudando. Que Microsoft quiso la aventura de la CMA de que volver, de que analizar, eso sabe Microsoft. Tuvo la oportunidad.
¿Los nervios de qué? ¿Cuál es el nervio tú para el que yo tengo? ¿Cuál es el nervio?
Es que no hay nervio.
Yo lo que no quiero es que esta vaina se entienda, loco, ya para salir de esta mierda ya, loco. Eso es.
Esa es la realidad. Todo el mundo quería salir
la que apuñaló a Microsoft por detrás fue la CMA. Entonces Microsoft haciendo esto por la CMA, yo no lo veo sentido, loco. Pero a mí me gusta lo que yo digo, si Kudosai, si la CMA está de buena fe, tiene que permitir el cierre. Entonces, si Microsoft no cierra, es porque la CMA no está de acuerdo, entonces la CMA no está del lado de Microsoft.
Yo no entiendo la estupidez de Microsoft.
Entonces eso es lo que ese es el punto, loco.
Entonces lo que estamos en eso, ¿cierra hoy o no cierra? ¿Cierra hoy o no cierra? Entonces tanto disparate, tanta vaina con línea acá para al final, mamá, eso lo...
Sí, pero también es verdad, porque lo de la extensión, eso se debe saber, porque eso no di que, vamos a entender de una vez. Yo vi una vaina que estaban subiendo, vaina de accionistas de Twitter y vaina, subiendo que los accionistas están impacientes de los Activision. Ellos están impacientes.
Entonces, ¿qué van a hacer? ¿Van a cerrar sí o no? Esa es la pregunta hoy. O van a tener que esperar que la CMA que revise, haga su allante, porque sabe que hizo una porquería.
No, es que no tiene sentido. El juez, Microsoft tenía en su mano que el juez le anule el bloqueo y ellos dijeron que no. Entonces, eso es lo que yo me entiendo.
Entonces Microsoft sabe lo que está haciendo, hay que dejarla. Microsoft ha calculado todo bien. Hasta el momento, ya. Loco, me voy. Ya no, y no, no va a haber poca, porque uno va a hablar todo eso aquí hoy. Yo no estoy en directo, hablamos, me quité. Ya veremos si dentro de horas hace, qué hace o no hace. Ya lo que yo sé, que si eso se entiende, a esperar que la CMA y Microsoft, pero ya di que está ahí con el afán de que van a cerrar, que decidan qué van a hacer, extender o cerrar. Si uno sabe que extiende, ya uno se olvida de la compra y sigue normal hasta que le decida la CMA. Eso es lo que está. Hoy cierran, si se extiende, hay que esperar que de nuevo un proceso que no van a bloquear, ya no hay bloqueo, que aprueben. Entonces eso es lo que queda. Señores, me quité, nos vemos.
El problema que veo es que el K a futuro ya no apoyará a Microsoft si la CMA. No, si Microsoft extiende, loco, yo soy en banda, ya de que transmitir juicio y vaina, a la mierda se va todo. Que se dé cuando se dé ya. Tú estás loco. No va a cerrar, dice Florian en la que ve si cerró. No, que es que Florian no es Microsoft, a que ve. Nadie entendió este juicio casi, loco. No, ya Microsoft ganó, pero lo que me molesta es esperar más, loco. Eso, ya yo pensé que hoy iban a salir de esta mierda. Y ya, no, ya la gente lo que va a esperar es que salgan los juegos y la vaina y ya. Por ahora vamos a seguir con esto que juicio, que la CMA dijo, que Microsoft dijo, que el juez dijo, que la misma mierda de nuevo, loco. No, si se extiende, yo lo soy todo en banda, sí. Si se extiende, yo soy todo en banda, que se cierre cuando se, o sea, que se termine cuando se termine. Si Microsoft se extiende, lo soy todo en banda, que termine cuando termine. Pero la compra está segura, ya está segura. Ya Microsoft evadió todos los obstáculos que estaba. Pero no estoy quillado si se extiende, porque no quiero esperar más tiempo. No, claro que los suelto si extienden, loco. Yo los suelto yo. Pueden hacer 10.000 juicios y ni caso lo voy a hacer. Una mierda, la misma mierda, loco. Pero yo reaccioné al video de. Yo puse el video aquí, yo reaccioné al video de Game Pass Core. Ah, yo lo puse. Es que la CMA le jugó sucio a Microsoft y Microsoft está jugando por la CMA. Yo no estoy de acuerdo con eso. No estoy de acuerdo con eso. Sony filmó, todo el mundo ha filmado, ese FTC perdió y esta. No, no, tú estás loco. Que el juez iba a anular el bloqueo y la CMA y Microsoft dijeron que no, porque ellos tienen un acuerdo. Yo sé que ellos saben lo que está haciendo, pero no es eso, es que que ya quiero salir de esta vaina rápido ya. No es mañana que vuelve. Ajá, y si Microsoft queda bien y cambian al jefe y el jefe no quiere saber de Microsoft, se la va a probar. Es que eso no es así, loco. Y si cambian al jefe de la FTC, de la CMA. Si Microsoft se acontenta con Sara y la cambian, no estamos en nada. Esto es alta ya, loco. No, todos los viernes, todos los días, hoy, mañana, pasado, todos los días van a cerrar.
Loco, eso está todo amarrado, loco. Eso no es de que va a venir nadie, ni que
¿Y
va a
quién
venir.
está diciendo eso, loco? Aquí nadie en el chat
No,
está diciendo eso.
no, porque te estoy diciendo, lo único es, lo lamentable es que se puede extender y ya. Ahora la compra está más segura. Ya di que ya Sony firmó. Si Sony firmó, era la última que estaba luchando y sabe que no pudo hacer nada. Y si firmó es que todo está cerrado, todo está amarrado. El problema es que esto va a continuar. Ahora, yo te digo la verdad. Ya si se va a una extensión, ya pierde todo sentido de que ya todo se calmó. Ya Sony firmó. Seguramente hoy, yo no sé si la de Nueva Zelanda va a terminar aprobando. Tiene que aprobar y la otra, y Australia. Entonces, que va a perder más tiempo. Uno lo que tiene que olvidarse de eso hasta que el veredicto de la CMA, que va a ser positivo, no va a ser negativo. Microsoft lo quiso así. Bueno, ella es la que sabe. Yo lo dije en un podcast. A nivel de negocio, a Microsoft, si no tiene la necesidad de algo extremo, no dejar Reino Unido, porque si ya cede, ahora, si la CMA no cede, no hay un acuerdo entre ellos, claramente Microsoft la destrozaría, pero como tienen su acuerdo y está todo pactado, entonces que ya es lo que hay. Microsoft va a cerrar su compra sin PLC, sin nada, pero claramente si la opción era esa, la iba a tomar, y la iba a tomar porque la iba a tomar. Pero la CMA se nota porque tú viendo el juicio, quien estaba ayudando a la CMA era Microsoft, no Microsoft la CMA.
Y el juez hundiéndola y Microsoft ayudando.
Y entonces ya nadie puede tener de que una preocupación de que, ya olvídense de eso, la compra ya está. Lo que solamente queda es dos cosas que ya yo lo dije. Se cierra hoy y ella no hace nada porque están en negociaciones o extensión. Si hay una extensión, eso está planeado hace tiempo.
El punto mío es, si la CMA tiene buenas intenciones, ¿por qué no deja que cierre?
Porque tal vez quedaría muy mal.
Ajá,
no
sí.
Quedaría mal.
Y se hace un comunicado, y dicen que sí, que ellos permiten que cierre. Yo no queda mal.
Ella quiere volver de nuevo a revisar, pero Microsoft le está permitiendo. Porque ya ellos tienen un convenio. ¿Tú no entiendes? Ella le va a pedir alguna estupidez seguramente, que eso está todo ya. Loco. Eso lo vamos a hablar en poca, loco, ya cierra eso. Que ahorita hay poca y tú no estás hablando todo eso ahora. Ya, tú terminaste. Hablamos ahorita
Parcialmente
poca,
dura 2 o 4
todo.
semanas más, totalmente con chapón.
Ya la compra se cierra antes de septiembre. Está bien. Señores, nos vemos en el podcast y video más tarde en la noche. Loco, cierra y tumba eso.
Este día tú estás loco. Este día ahí, ¿no?
Tú estás tumba, loco. No te hablando, vale, que podemos hablar en el podcast. Nos vemos.
De Cierra te da un trato mejor. Sí. No, yo vuelvo y lo digo. Si Microsoft extiende, que se mete un huevo. Microsoft se extiende. Traduce 2 directo de Florian. Yo traducí un vaina de Florian y lo etiqueté y todo, ni la gracia me dio ni like. y a otra gente de una vez le da like y le da gracias por todo y a mí, vaya la mierda, tú estás loco. Yo agarré un espacio y lo traducí y lo mencioné y de todo ni like, ni nada, ni gracias me dio, ni nada. Está loco. ¿Qué es lo que, Ángel? Ya lo digo, si extiende, se vaya la mierda Microsoft. Cuando se dé, cuando se anunció ya, esperar, jugar los juegos cuando llegue, pero me decepcionó más. Si Microsoft extiende, voy a estar muy decepcionado de Microsoft si extiende. Porque si hubiera sido otra reguladora, yo lo entiendo, pero la CMA no, porque la CMA lo apuñaló. La CMA dijo que esto estaba bien, que esto, y al final bloqueó. Entonces, hacer eso por la CMA no le veo sentido. No tiene sentido, loco. Y si la CMA está de acuerdo y si no cierra porque la CMA no está de acuerdo. O sea, si la CMA y Microsoft están combinados y no cierra porque la CMA no lo deja, no entiendo tampoco. O sea, que vamos a ver hoy si cierran, no es a las 6 de California, no es mañana, a las 7 de aquí, de la mañana. Si no cierra antes de las 7, o a menos que se anuncie una extensión hoy o mañana. ¿Qué asegura compra del diablo? ¿Qué próxima compra del diablo? Eso es excusa, eso no es excusa. ¿Qué asegura compra? Si la CMA, el juez la dejó en ridículo porque hizo una payasada, hizo su trabajo mal. ¿Por qué dije que tiene que enfriarse de que por otra compra? Ya todo el mundo sabe que la CMA lo hizo mal. Entonces, como la CMA lo hizo mal, y Microsoft vuelve y compra y vuelve y le bloquea, le van a caer arriba porque van a decir que tiene algo en contra de Microsoft. ¿Qué es lo que dice que por otra compra? ¿Qué maldita excusa? Eso no es excusa, loco. No voy a con excusa de que no, que por otra compra, que compra del diablo. Eso que compra del diablo. La CMA lo hizo mal, el juez se dijo en la cara como 50,000. Desde que empezó el juicio, el juez le dio la mamacita a la CMA y estaba tratando de que la CMA admita su error y no lo admitió. Para después decir que no, porque no tiene sentido, loco. Claro, papá, porque ya no lo hizo mal. Si Microsoft vuelve y compra y la CMA bloquea y bloqueó con Activision y ya van a saber que una vaina en contra de Microsoft. Tú estás loco, eh. Si no cierran hoy, Microsoft se vaya a la mierda. Lo digo públicamente. Si no cierran de hoy a mañana. Si extiende, se vaya a la mierda. Se metan un huevo. Tanto tiempo matándome por Microsoft para el final de que extender, loco. De que para salvar la CMA o para estar la CMA que se mete un huevo, loco. Tú estás loco, eh. Tú estás loco, eh. De que futura compra. ¿Qué futura compra del diablo usted me está hablando a mí? Ya la CMA lo hizo mal, el juez se lo dijo en la cara, usted lo hizo mal, recapacite y no quiso recapacitar, y Microsoft dice y el juez dice, yo puedo anular, y Microsoft dice, no anule, tú no anules para después extender. ¿Qué maldito convenio es ese? Si hay un convenio y ese convenio no permite a Microsoft cerrar, ¿qué convenio el diablo es ese? No creo en esa vaina. Que se metan ellos la cosa, yo lo dije, extiende y suelto lo de la compra. Cálmate tú como que me calmo, usted está loco, eh. Cálmese usted como que me calme. Cálmese usted. No es a largo plazo, loco, eso es estúpido. Esta gente, la CMA, lo que pasa es que usted, loco, todo el mundo está diciendo en todos lados que no entendió el juicio. No entendió el juicio. No lo entendió. Y ustedes porque Microsoft dice que no, Microsoft, que es lo que Microsoft se vaya a la mierda, loco, si extiende. Que es lo que Microsoft sabe lo que hace. Usted está loco. La CMA te apuñaló por la espalda, loco. Este hijo de este mamahuevo, que es porque el diablo, loco, dame tranquilo, que es porque el diablo. ¿Oíste? La CMA ya apuñaló a Microsoft, loco. ¿Qué es lo que tú me estás hablando a mí? De que no, que Microsoft, que es lo que es Microsoft del diablo. Usted está loco, eh. La CMA te apuñaló. Si no hubiera sido por la CMA, la compra se había dado ya. Te bloqueó. te dijo que esto estaba bien y al final te bloqueó y mintió y puso vaina errónea, tú se lo demostraste, el juez se lo demostró que hizo una porquería y tú me vas a venir y que extender y que para salvar la CMA. Usted está loco, mamañema del diablo. Usted está loco, Y usted diga, porque no, que el magreso sabe, que el magreso del diablo. Tiene que cerrar, loco. Cerrar, tiene que cerrarle para que se respete. Porque la van a ver como una mamita. La CMA te lo metió y tú vienes y te mojas por ella. Usted está loco, desbarátela, ciérrele. Ella te de acuerdo o no te de acuerdo, ciérrele. Para que respete los rangos. Métale cerró a la FTC, coño. Métale cerró a la FTC. Y nadie está hablando que mete mala, que mete futura compra. Métale cerró a la FTC, que es más peligrosa, loco. Porque mete de Estados Unidos y le cerró a las reguladoras de Estados Unidos, coño. Y no ha pasado nada. Usted está loco, Coñazo. La CMA la apuñaló por atrás a Microsoft. Métale cerró y Microsoft es más fuerte que mete y meta cerró. En el propio país aquí le cerró. Usted está loco. Le cerró a la FTC. Y nadie está hablando de que, qué mal le meta. Meta cuando compre, la FTC le va a negar. Pero con Microsoft, no, porque Microsoft tiene que estar bien, porque para futura compra, no. Meta va a seguir comprando. Y le cerró a la FTC. Tiene que cerrar hoy o mañana. Si extiende, son unos pendejos, loco. Tiene que cerrar para que respeten a Microsoft, como hizo Meta. Que Meta no le paró bola a nadie. Más que Zuckerberg no le paró bola a Lina Khan y le cerró. Usted está loco, le denegan el pi. ¡Pa! Cerrado de una vez. Usted está loco, Usted está loco, Tiene que cerrar, loco. Si no cierra, Microsoft se le dio la nalga a la CMA. Yo he hablado de que si extiende, estoy hablando. Ya sabes, me voy. Si Microsoft extiende para mí, ya sé. Hay que criticar, loco, está mal. ¿Cómo que tuviste un juez que dijo, yo puedo anular a la CMA? No, es Harry Potter. No anule. No. Coño, pero eso es lo que queremos, que tú anules. No, estoy hablando si extienden, yo lo dije. Si Microsoft extiende, todo lo que dije es válido. Ya tú sabes, nos vemos en el podcast. Tú estás loco, que es miedo el diablo. Aquí no tenemos miedo de que lo que compra futura del diablo. Tú estás loco. ¿Cuántas reguladoras no han pasado por arriba a la CMA y siguen comprando? Usted está loco, Va de ahí, nos vemos. Si extiende, si extiende. Si la CMA extiende, todo lo que dije es válido. No es que sabe lo que hace, que es lo que sabe lo que hace. Meta sabe lo que hace y cerró. Nos vemos. Y si ahorita viene Activision y dice que no va a renegociar y Microsoft cierra, ¿qué va a decir tú? Microsoft sabe lo que hace. Tú no vas a decir que se equivocó. Y si Activision no quiere negociar, ¿qué tú vas a decir? Es Jacobo. Microsoft sabe lo que hace. 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 ¿Qué es lo que sabe lo que hace? Lo que sabe lo que es jabón. Eso es lo que sabe. ¿Qué hace del diablo?